Broadcast going. Excellent. Let's get my script in front of me. Welcome to the 9th hearing of the Public Accountability and Works Committee's inquiry into the New South Wales Government's use and management of consulting services. I acknowledge the Gadigal people of the Eora Nation, the traditional custodians of the lands on which we are meeting today, and I pay my respects to elders past and present and celebrate the diversity of Aboriginal people and their ongoing cultures and connections to the lands and waters of New South Wales. And I also acknowledge and pay my respects to any Aboriginal and Torres Strait Islander people joining us today or watching on the broadcast. This morning we'll hear from Professor Brendan Lyon and the Australian Services Union, before moving in the afternoon to hear from a range of state-owned entities, including New South Wales Treasury Corporation, Sydney Water, Hunter Water and Energy Co. Before we commence, I'd like to make some brief comments about the procedures for today's hearing. Today's hearing is being broadcast live via the Parliament's website. A transcript of today's hearing will be placed on the committee's website when it becomes available. In accordance with the broadcasting guidelines, the House has authorised the filming, broadcasting and photography of committee proceedings by representatives of media organisations from any position in the room and by any member of the public from any position in the audience. Any person filming or photographing proceedings must take responsibility for the proper use of that material. This is detailed in the broadcasting resolution, a copy of which is available from the Secretariat. While parliamentary privilege applies to witnesses giving evidence today, it does not apply to what witnesses say outside of the evidence at the hearing. I therefore urge witnesses to be careful about comments you may make to the media or to others after you complete your evidence. Committee hearings are not intended to provide a forum for people to make adverse reflections about others under the protection of parliamentary privilege. In that regard, it's important that witnesses focus on the issues raised by the inquiry's terms of reference and avoid naming individuals unnecessarily. All witnesses have a right to procedural fairness according to the Procedural Fairness Resolution adopted by the House in 2018. If witnesses are unable to answer a question today and want more time to respond, they can take a question on notice. Written answers to questions taken on notice are to be provided within 21 days. If witnesses wish to hand up documents, they should do so through the committee staff. In terms of the audibility of the hearing today, I remind both committee members and witnesses to please speak into the microphone. Finally, could everyone please turn their mobile phones to silent for the duration of the hearing? I now welcome our first witness, Professor Brendan Lyon. Could I please ask you to state your name and position title and then swear either the oath or the affirmation?
Thank you. Brendan Lyon, Professor of Practice, University of Wollongong. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. And would you like to begin by making a short opening statement?
Thank you, Chair. Through you, I thank the committee for the invitation to give evidence today. As at least some of you would recall, I last appeared before this committee on the 8th of November 2021, approaching 2 years ago. I was subpoenaed to appear and to produce documents in my lawful possession during that public inquiry into Tahi. In 2021, I had finished my work on Tahi and in consequence I faced internal reprisals led by KPMG's Chief Executive Andrew Yates and his most senior colleagues. I had faced investigation for wholly vexatious complaints to force me from the firm. I was under vicious and personal attack from the Treasury Secretary. I was attacked by government politicians, I was sacked and have lost at least $2 million to costs and to lost earnings. And to this day, I face continuing attacks on my character by the guilty. I don't say that because I'm seeking your sympathy. I would do it all again in an instant, because some things matter much more than a partnership in some global firm. I listened carefully to the testimony by Mr. Peter Perdiccas of Transport for New South Wales, who placed on record the import of my advice in identifying and curing the material safety problems introduced by Tahi. That process forced discussions about the legitimacy of the accounting treatment and caused major outbursts and ill treatment of me by KPMG and Treasury personnel. I am old enough to remember the Waterfall, Glenbrook and more than 100 other rail accidents caused last time operations and assets were split. So much so that the first report I provided contained case studies of rail tragedies caused by poorly executed structural separations in live rail. the inclusion of which saw Mr Pratt's first complaints about me, saw him demand the case studies be removed before Cabinet saw them, and saw his friend Mr Hunter form the conflicted oversight group that included the CEO of KPMG, Andrew Yates. But the counterfactual point of that Mr Perdiccas was too polite to say is that the efforts to frustrate my work meant KPMG and Treasury chose flawed accounting over public safety. That is as far as I can imagine from the public interest and not the behaviour of good human beings. Mr Staples and I were both sacked for our work on Tahi, but I'm sure we'd each do the same again in the same circumstance. I must admit I was surprised to hear Mr Lowe of KPMG testify that KPMG observes the whistleblower laws in the Corporations Act. Mr Lowe also testified yesterday that I did not make any reports under KPMG's whistleblowing policy. He is wrong. I made countless written reports under that policy, including to the CEO Andrew Yates, risk partners Joel Lucas, Jeff Cook and Christine Wilcox, KPMG's General Counsel Louise Capon, KPMG's then Head of People and Culture Deb Yates, now on the executive team at Lendlease, my Divisional Managing Partner David Heathcote, KPMG's Global Head of Tax David Linke, to Ms Watson as the engagement partner with the conflicting work, the head of my practice groups Stanley Stavros, now on the National Executive Committee of KPMG, and of course to my second partner Paul Lowe, KPMG's Head of Government, who appeared before you yesterday. In this regard, I point the committee to the emails numbered 58 to 61 in the subpoenaed documents of the last inquiry by this committee. My first email reports extensive ethical risks and failings to David Linke, who then forwards it to Mr Andrew Yates, Mr Hunter and Ms Watson, and her second partner Andrew King. In my assessment, alongside those warnings, I had also noted that I considered there to be an extremely high level of media interest, including in KPMG, an extremely high level of political interest, including in KPMG, an extremely high level of professional and reputational risk to KPMG, and likely a call for papers and upper house inquiry into the erosion in the New South Wales budget due to Tahi and KPMG's accounting advice. That email was sent on the 25th of July 2020. In response, I was disciplined for not being a team player, as I was with subsequent written reports of misconduct, including to the General Counsel, Louise Capon, and the Head of Risk, Jeff Cook. I do not understand how you could make a clearer internal report than to do each of those things. I do not blame Mr Lowe. I like Mr Lowe. I do not blame him for sticking to the KPMG team line. After all, Mr Lowe is earning about $2 million a year and I am not. He can be a team player, but he should take his money quietly and not become complicit in the smears of others that found they could not stand with his team's culture or practices. The evidence that is already in the Parliament's possession shows repeated, clear internal whistleblowing reports by me, and it shows equally clear internal reprisals by Mr Yates, Mr Hunter and Ms Watson. Mr Lowe saw it all, and Mr Lowe could have and should have, under that policy and as a senior partner, reported those reprisals. Perhaps Mr Lowe is unfamiliar with the policy. Given my treatment, I doubt that it is very often used at KPMG, if at all. Another surprising part of yesterday's testimony was the insistence that I was not fired, something that was also the subject of a submission by KPMG to the federal inquiry, backed up in both cases by a post I had made on LinkedIn before my departure. On this point, KPMG are either being deliberately dishonest or they are totally demented. First, LinkedIn is not usually a place where one shares their mental state. Second, the Parliament has extensive records that prove that this is materially false. That evidence shows that KPMG's General Counsel even sought to insist on my immediate return from leave the day before my wedding to be sacked in reprisal for my work on Tahi. It was only the revelation that prominent defamation lawyer Rebecca Giles was acting for me which saw that urgent meeting delayed and ultimately never convened. That was then and this is now. What were allegations made by me have moved to findings made by the New South Wales Auditor General, by the Public Accountability Committee and increasingly the Court of Public Opinion. These findings are evidenced through scores of documents, emails and text. While KPMG submitted yesterday and continue to argue that their work for Treasury was sound, the Deputy Auditor General testified to this inquiry's earlier hearing that it's history now that the Auditor General said the KPMG advice that Treasury preferred was not necessarily the advice that was going to get a cleared opinion, it was going to get a qualified opinion. New South Wales is now worth $20 billion less because of KPMG's advice, and New South Wales taxpayers and the government face a complete bugger's muddle to unpick the mess. Even the industry's self-regulator Cairns has now placed on record it is undertaking some form of ethics investigation into KPMG's partners and their actions on Tahi, albeit with very scant detail and little apparent urgency. But KPMG are still, as I understand it, trying to discredit me to journalists and no doubt to politicians. I've been credibly advised in recent days there's been renewed backgrounding against me by KPMG operatives. By its nature, backgrounding involves unsourced hints and allegations made behind closed doors and therefore are very rarely able to be evidenced, just alleged. I believe that this instance is different. On the 8th of July, shortly before my Senate testimony, I received a WhatsApp message from KPMG's Corporate and Government Affairs partner, James Copsey. Members of the committee might note that Mr Copsey was sitting behind Mr Lowe at the hearing yesterday. Mr Copsey messaged me at 7:17am. Mr Copsey's message contained a document resembling a political shit sheet, which in this instance sought to cast shade over my role at the University of Wollongong as a professor of practice. The document included a message from Mr Copsey asking if I had anything to add. Precisely 15 minutes after it was sent at 7:32am, Mr Copsey updated his WhatsApp seeking to set disappearing messages. Once it was apparent to Mr Copsey that he could not remove the document unread, he then sent a text which said, "By the looks of this, one of your academic colleagues at the university isn't happy." Not from me, obviously, James Copsey. I responded asking Mr Copsey the following: "What was the document you sent me? It's not appeared anywhere online. And why would you ask me if I have things to add?" Mr Copsey responded somewhat unconvincingly, in my opinion, that that's how it was sent to me. It's obviously doing the rounds, just giving you a heads up. If the committee will forgive me, I do not accept Mr Copsey at his word. Mr Copsey is the Public Affairs and Government partner. In other words, he's KPMG's spinner and in-house lobbyist. He is the man Friday to the CEO, Andrew Yates. In the past 4 years, Mr Copsey has never once provided me with a heads up about anything else. He's never done a thing that's been in my interest. In my opinion, either Mr Copsey texted me KPMG's shit sheet in error, or else he sent it intentionally in some attempt to intimidate me before my Senate testimony. Of course, were KPMG bound by the Corporations Act, I could report this. And Mr Copsey and Mr Yates could each potentially face criminal charges and even jail time were it shown that they'd engaged in unlawful reprisal. But as a Big Four partnership, they are protected from the laws and taxes which bind all other corporations in Australia. It is useful to turn from the deeply personal, but I'm pleased to say increasingly historic impacts of Tahi, personal impacts of Tahi, to consider contemporary structural causes and remedies. There is now clear evidence of ethical and professional misconduct across Australia's Big Four accounting consulting partnerships. These failings are born of a culture where accountability and ethics are words used in inquiries, not duties which fundamentally bind the actions of partners and firms. This is caused, in my opinion, by the interoperation of two acts enacted by this Parliament precisely 100 years apart. The first is the Partnership Act 1894, which codified the rights, obligations and risks affecting general law partnerships. The second is the Professional Standards Act 1994, which sought to support the public good via codified rights and obligations for certain professions, and is unique globally for its provision of statutory caps which limit professional legal liability. The Partnership Act and the Professional Standard Acts individually seek to balance protections of the public interest against the preservation of appropriate private rights. But in practice, the Professional Standards Act has been used by the Big Four to fundamentally retard the partnership model to create a new species of protected pseudo-corporation.
Chair, I'm just going to make one more Short opening statements usually don't run this long.
I've got another 2 paragraphs, Mr. Feng.
I think in relation to the point of order, I hear the point of order. In this particular instance, it is very interesting. Could we just let it finish? And yeah, thank you.
We would normally not allow witnesses to have an opening statement this long.
Please go ahead.
Normally of this nature, though. So.
Exactly.
Thank
It's
you.
not only this spicy. Go ahead.
Well,
But in practice, the Professional Standards Act has been used, as I said, to fundamentally retard the partnership model and create a new species of protected pseudo-corporation. One which avoids the transparency, the legal duties and taxes paid by other corporations, and one which provides a far stronger protection than the corporate veil granted to real corporations. It is clear that the national and state interests are not served by allowing the perverted Big Four pseudo-corporate model to continue, and it is within the powers of this Parliament to remedy the structural problem facing the Big Four. I thank the committee for your forbearance for my opening statement and look forward to your questions.
Thank you very much, Mr. Lyon. It was a long opening statement, but it was well worth it, in my opinion.
Can I just ask a quick opener?
Please, go ahead.
On the evidence, Mr. Lyon, did you table that WhatsApp message to the Senate inquiry?
No, I have not. I will table it.
Table it to this committee?
I will. It's on my phone and I'll submit it to your staff at the conclusion of the hearing.
Thanks. Maybe just for the purposes of the committee, in terms of just a bit of a recap on the structural separation of Tahi and the purpose thereof and the effect it had on safety, just a thumbnail sketch. And I think the evidence we got yesterday in the context of that structural separation was that, well, Treasury gave us writing instructions, we complied, and the accounting advice was in accordance with the instructions, was pretty much the argument we got yesterday. Just some commentary around that.
Well, look, I mean, that's entirely misleading. The reality is that they were in a conflict situation. They were in a conflict situation caused by the work for Treasury in the first instance. It's on the record from Mr. Staples asserting that to the firm, asserting that it conflicted with the evolving transport work and asking for it to be remedied. That's how I came to work on Tahi. I didn't particularly want to work on it. I was asked to do so because of the damage to the firm that had already been done at the start of the conflict. Once Mr. Pratt became unhappy, they formed a conflict oversight group that made various undertakings to Ms. Trussell, who appeared yesterday, and to Mr. Staples, that again are all on record about how they were going to manage the conflict moving forward and that it would be minimised. The great fib in what's portrayed by KPMG about all of this is the conflicting work was accepted in October 2020. It was after my final report that was required by the Cabinet and being prepared for the Cabinet by Transport for New South Wales had been out in exposure draft for, 6 weeks. And so it was deliberately procured, it was agreed to at a secret meeting without me present, and it was done absolutely seeking to have 2 answers and therefore none to go back to Cabinet because of the scale of what was being revealed and the pressure, the obvious pressure that had on Mr. Pratt and his colleagues.
Can we go?
This is all, and I should just say, this is all already on evidence and it's worth having a look at, but there are sort of 2 sets of books running around what happened with Tahi, one that's being narrated and one that is being evidenced, and the one that's being evidenced, it takes a long time to get through, but I'd recommend you read it. It could be a dodgy film one day.
Can we go back to the evidence we heard yesterday around your leaving of the firm, and it was very much portrayed as a resignation rather than a sacking. And I did ask very pointed questions about this of Mr. Lowe, and he was very clear that you had not been sacked. What's your response to that? Why is he saying that?
So I guess Mr. Lowe is being cute in the construction, and that's been a feature all the way through. There's sort of a construction of facts that suit the issue that's being discussed at a point in time, but it conflicts. I guess technically I did sign a retirement deed.
So what's in the... So there is such a thing. What happens?
So to exit a partnership, you sign a retirement deed. That's why they talk about retiring. It was the sort of retirement that you do with legal counsel sitting on each side of the table. after a 15-month vicious and bitter campaign that is all through the evidence that I'd given before. And so I guess what you would call it in truth is constructive dismissal.
Okay.
So maybe I shouldn't use the term sacked. In my submission, I certainly said constructively dismissed. Mr. Lowe should not say it was voluntary because he is aware that that is untrue. We discussed it many times and he was on my side until he wasn't.
I asked him if you had signed some form of deed in relation to your constructive dismissal. He said he was not aware of that. Was that...
I find that unlikely. He's a very senior member of the firm. But again, I like Mr. Lowe. Let's give him the benefit of the doubt. Certainly the senior leaders, and it's probably a good demonstration of why Mr. Yates should have appeared at the inquiry yesterday, because he certainly could have given a lot more evidence to that effect.
We also asked yesterday of Mr. Lowe a number of times as to whether or not he was aware of you making reports in relation to your concerns around what was happening in KPMG.
I'm going to give him the benefit of the doubt again. I mean, those emails that you have where I'm saying the firm is in fundamental conflict, you and I cannot in good conscience report to this conflicted committee because we are breaching ethics and we are potentially involved in a conspiracy to maladminister New South Wales. I don't know if they're also on record. I don't know if I need to put in the heading, this is a risk report, or whether there's a form that needs to be filled out, but there are, I don't know, dozens, scores of emails, including the one I read out where I even presciently pointed out that people are going to notice that the budget's been knocked by tens of billions.
I also asked him if he himself had made any kind of report or raised any concerns in relation to the work KPMG was doing with Tahi, and he said he couldn't recall doing that. Was he concerned?
Yes, very. And you can see it. I mean, you can see it all through the emails. Again, it's where, just having a look back through the evidence, the text messages that are on evidence from Mr. Lowe and others, it was a huge bun fight within KPMG, but it was one where there was only one side that was going to lose in the end, because all of the powerful partners who had set up a committee, then they were definitely going to get the answer that was wanted. I think Mr. Lowe didn't do himself the best justice yesterday in terms of his forthright answers or complete answers to the questions. It was very clear, and it's very clear on the evidence. People could see it. I lost 27 kilograms in about 10 months. And that wasn't through diet and exercise, it was through stress and pressure. And it's evidenced by all of the emails that include Mr. Yates and the others. So again, I don't understand how they can say that no risk reports were made, or no, whatever they call them, whistleblower reports, whatever else. I even warned them a year before the inquiry started that if they continued, then all of those outcomes were likely to happen, because this is public finance, this is public rail operations. Transport were deeply concerned about, and particularly in the period, and again, sort of longitude is important. I guess by the time I'd finished my second report, Transport were comfortable that there was an operating model that was well understood. There were more than 1,000 tasks that were allocated out across the live rail operating environment, so very complex, involved months of complex consultation with the rail operators and everybody else. No one wants to go back to leaving jobs unallocated in a live rail environment when you're putting a split between assets and operations. And I guess everybody was concerned about that. Sorry.
No, it's okay. I just want to focus on, in the time we've got available, if we look back at what has occurred, we have we have evidence on record, as you say, of you having raised concerns on multiple occasions with senior people at KPMG. We have those concerns being borne out by history. We have KPMG themselves saying that they made mistakes. We have the Auditor General backing up the problems that you raised in relation to Tahi. We now have a new government who is trying to unpick what is at least a $10 billion problem that we have in the budget now as a result of that. When I had KPMG in front of this committee yesterday and asked them questions, I couldn't I couldn't get any evidence that there'd been any consequences for KPMG as an organisation.
I was obviously listening yesterday. I mean, what I heard is their billing changed slightly, but still growing, and there's sort of life goes on. And why is everybody still talking about Tahi?
So what assurance does the New South Wales Government have that it is dealing with an entity that is acting ethically?
Well, given what I've seen, I don't think it has any assurance of that from the actions of Mr Yates and the other very senior partners. You can't say that the circus is different if the clowns are the same.
Professor Lyon, could I just ask where, to your understanding, the Tahi debacle started? Because it's, I think, clear to any common sense observer that this entity was never suited to being a state corporation because it's loss-making and inherent with risk that looked like it was an attempt to get it off the budget. And the consultancy firm just did the... Sorry?
To keep it off.
To get it off and keep it off.
Yeah.
And do you know where that policy decision came from? Was that ever made clear in the process by which the consultancy firm and Treasury just played along?
Just in the way that if you're a little bit worried that you might go missing, you leave a nice trail for the record. I'd recommend that the committee have a look at the second report that I wrote on Tahi, because it details this from the structural separation of the railways in the 90s, which is when they went off. In my view, that historic change in structure was a well-intentioned one that involved transport. I could be wrong, but was designed to try and bring product efficiency into railways, happened in the context of the sort of Hilmer competition reforms and the structural reforms that were going on at that time. That proved not to be safe in the context of a complex suburban rail operating environment. It saw tasks unallocated. It ultimately saw rail tragedies. It takes a little while, it seems, for the reporting to catch up with the change in structure.
Sorry, Mr Lyon, is that because it's impossible to separate capital and operational without affecting safety in a nutshell?
It was because things got forgotten, Mr Buttigieg. It was, so when you bring a separation in like that and people forget who's accountable for which particular bits of complex operations, so it's the interfaces. It's not, it's not malignant, it's not malicious, it's just very complex.
Just an unforeseen byproduct of the separation.
Yeah, and it's not been unique to the New South Wales railways that happened. I mean, Hatfield in the UK was similarly caused by structural separations and they can be done, but they have to be done very carefully and very prudently. They shouldn't be done in a bum's rush, because it has to be operating on 30 June or else the Auditor General is going to find out. That's not that without an operating model in place, and that's where Treasury were at that point in time. Sorry, back to your question, Mr Latham. So it takes a little while for the books to catch up to reality, and usually the books are reflecting or supposed to reflect and write down accurately what has happened. I guess the ABS gave notice to New South Wales that they were going to change the accounting treatment because they were controlled entities not operating as they'd been. In 2015, that was put into the budget that the state would adopt the transport asset holding entity structure, and it would do that to maintain the treatment, explicitly to maintain the budget treatment. It was then not switched on because Transport were very cautious. People still remember Waterfall and the other things, and they have a big impact culturally, as you'd expect, and there's a very strong safety culture in operating transport environment. So it never really progressed to consideration of an agreed operating model. It was always a concept that existed only in the books. All of a sudden, the Audit Office began to write, as they should, began to write matters of emphasis of increasing urgency in the state's review of finances. All the timelines were missed. There was still no operating model, and then all of a sudden, Mr Pratt decided it must happen at any cost, and it must happen by 30 June 2020.
Right. But in answer to my question about where the idea started, you're saying it started within the Transport.
Started within the Treasury.
It wasn't a ministerial initiative necessarily to get it off budget?
It was already off the budget. It was more that the ABS had given notice of its intention to reclassify, and so it's been about trying to maintain that treatment and then ultimately to increase it in its transition phase where you could...
Right, so your depiction is it started within transport for well-motivated reasons.
Treasury. It started within
within
Treasury. Yep.
Started within Treasury for
modern
well-motivated
iteration.
reasons, but then unravelled.
No, I think it started in Treasury in the current iteration. I think it started purely for budgeting reasons, and you can see that because there was no progress to develop an actual operating
Right, but
model.
that was Treasury, not the Treasurer that was driving it.
I don't know.
You don't know that far up the chain.
Budgeting reasons, what were the... Was it say you could load it up with debt?
No, it's so you could not count your depreciation or your capital investment into
I see.
rail on your budget.
Yeah.
So that's very beneficial. It helps to undertake larger investments if some of them are not reported in the same way, or some of those costs. So I think it was about that. The budget paper in 2015 was pretty explicit about that.
So I guess we've heard figures of 10 billion, 20 billion cost to the government, or to the public, public purse, I guess, as a result of the flawed accounting advice that KPMG gave to Treasury. What is that figure, before I go any further? What do you think that figure is?
So I think it's the write-down that happened to the asset. So it's recorded now in the state's books. It was 20.6 billion or something.
Okay.
Thereabouts.
Yep.
And that was the problem in my model, was that I couldn't find a reason for the write-down because of the revenues to do with the full economic cost calculations required, again, under national competition policy. So I don't know how they got to that, but I'm sure it's very valid. It was done by PAWC.
So we've been left with this sort of budget black hole. We have a set of evidence from an accounting firm that is telling us that, yes, they made mistakes, but really there's been, as far as I can tell, no real consequences other than to yourself.
There were vast reputational consequences, but no change to billing or work or positions. In fact, most people got a promotion. So.
Right. Should they just give the money back for the work that they did? I asked them this yesterday.
Look, I think they should. I absolutely think they should. I mean, they gave 2 bits of competing advice. They did it deliberately. That's not
Sounds like it'd be covered in 1 year's wages.
Well, it'd be insured away. It'll be insured under the scheme.
It would be insured under the scheme. Can we talk a bit about that then? So you said in your opening statement that the scheme that New South Wales, I understand, has enacted under legislation, but then the other states and territories copy, has given protection to the big four in a way that doesn't exist in other parts of the world. Is that correct?
That's correct. It's unique in its effect. It was done. I mean, it was done for honourable reasons. It was done to react to the caution of the insurance markets after the 80s crash, and it was done to respond or to seek additional competition into the provision of audit services. So it was done so that smaller firms wouldn't be betting the entire firm on one good faith error in an audit, and they would be able to compete with what were then the Big 8. In practice, the Big 8 have become the Big 4. They do 99% of the audits for listed corporations. So it's actually seen a concentration, as far as I can see it, in audit activity. And it's been extended well beyond audit. It covers everything they do. As you discovered yesterday, I was a member of Chartered Accountants while I was a partner at KPMG. Everything I did was covered as if I was an accountant in public practice. I did all sorts of ethics training at KPMG. I actually read it, which is why I did as I did. And I guess I saw the others do the tests, but maybe not pass the ultimate one when it came to it.
So are you suggesting that we scrap that protection or just modify it in some way?
Look, I think there's a very good argument to say that the professional scheme was not brought in to help big global firms to avoid the risk and consequences of misconduct or malpractice. It wasn't brought in to give them an unusual protection and sort of liability cover in their management consulting and their other non-accounting work. So I think at the very least there should be a very firm consideration of winding it back to the bits that we want to protect. The other question that I have is, where is the enforcement in return? So the premise for the scheme, as well as responding to market factors and trying to reduce costs. Sorry, I forgot my train of thought. Sorry.
That's all right. We were talking about enforcement. So when we're talking about, and this was, again, one of those issues that we had, and when I was talking with KPMG about, where is the enforcement if there is something that goes wrong?
The premise of that's what I was saying. The premise of the professional scheme was that you would have a better off outcome for the public overall, because you would have better conduct and less claims overall, because of the enforcement under self-regulation by the professional associations. I guess that's the bit where I know that you're in receipt of private information. I met with Chartered Accountants Australia New Zealand last week with Ms Chapman and with the head of public sector audit, Amir. It was a very perfectly pleasant meeting, but I kept getting told, well, we can't tell you about that. Oh, no, we agree, it's all terrible. And yeah, no, it's terrible that the accounting profession is where it is and it's on the dinner table for discussion by families. But when it came to any consequences, it was sort of, can't tell you that, you're just going to have to leave it with us. Our bylaws mean blah.
So this point about self-regulation you made, which we touched on yesterday, it's actually can be extrapolated right across a range of industries, not just accounting firms, but this concept that you can join an association and everyone does the right thing because we're all in the same tent, so to speak, and we'll slap you over the wrist if you do something wrong. There's no actual third-party punitive intervention like there might have been in other industries years ago. I don't know in the accounting industry whether that's been in since time immemorial, but have you got any commentary about the efficacy of that sort of approach?
Look, I mean, moving from technical professions regulating themselves is fraught with danger, because they do, fundamentally a profession requires two things: exercise of professional judgment, and that exercise of judgment is demonstrably in the interest of the client, patient, community at large. I guess if I look at the other professions that do function differently and better as far as I can see, I mean, you look at the lawyers, for example. Lawyers are routinely struck off when they do something wrong. Routinely. What's the difference between the Law Council, which is the membership group, and Chartered Accountants Australia New Zealand? I guess it's that there's the Legal Services Council that checks whether the council is enforcing the code, whether it's investigating, whether it's prosecuting issues of professional conduct judiciously and well. So I guess they have what accountants would otherwise describe.
What's the that's an interesting analogy. That Legal Services Council, is that like
state?
That's a state regulator.
Yeah, and it just checks the homework. So it's much easier, and I made this point to Cairns. I'm not actually trying to harm them, and I don't want any of the accounting firms to leave Australia. We need them. They're supposed to do a job. It's just that at the moment I can't see how they've got the incentives to do a good job, because they're not exposed to any downsides when they do a terrible job, and demonstrably so.
So, Professor Lyon, to that point yesterday, so you are a member, or you were a member of Cairns as a non-accountant. Then
that's the deputy chair's favourite term. I've heard it so many times.
And then in terms of those people who are working under you, they are not members of Cairns. Is that correct?
No, they were all chartered accountants.
Oh, they were all chartered accountants. So what about other people in the firm who were not accountants?
All
are
members.
They governed by anything?
Yep. So all the partners are members, and then their staff are covered by them. In my instance, I had mostly accountants, and very good ones, working for me.
Okay.
And so that was, again, the great fallacy of those sort of castigations, that I wasn't an accountant and somehow I'd been sitting in my garage doing this financial model that was kooky. It was just, it was just not right. We did, and again, you've got the evidence. It went through all of the risk processes. It went through the financial modelling group. It was assessed. I went through independent safety review of my operating model, which I insisted be external to KPMG, because I didn't want to sign off on something where I have to turn up at a commission of inquiry into a rail accident later. So it was all belts and braces. And then it was hit with a report that had a shelf life of about 5 minutes before it expired, that said everything's tickety-boo and it's all fine. Well, it wasn't tickety-boo, it wasn't fine. Transport Secretary was willing to lose his job over it because it mattered, not because it was a political issue or anything else. The fact that the maths didn't work, that is to the eternal shame of the Treasury, because it was incompetent assessment that was done, both for the cabinet minutes that went up and the prior modelling, which had overestimated the benefits twofold, or else had hidden the coming right down in asset value, to go to the Chair's question about 20.6 billion. I mean, these are sort of complex issues, and Mr Pratt and the evidence when KPMG were defending their work more was all to say that, you know, complex, it's all complex, it's so terribly complex, accounting is so complex. My observation is accounting shouldn't be complex. It's probably only complex if you're trying to contort it to unnatural positions that aren't going to work, and ultimately that's not to the benefit of the governments that this advice goes to. It wasn't to the benefit of public administration, it wasn't to the benefit of the New South Wales Treasury. So I think the professional standards and professional acumen were clearly not there. Adverse comment by the Auditor General, I mean, that is a pretty big thing. It's not even just an adverse comment by a client or an Audit and Risk Committee, it's the Auditor General of New South Wales. Those things should matter, but I haven't seen any consequence, and again, I'm just told it's all tickety-boo, don't worry, there's an investigation going on. Well, into who? Over what? This was led from the top level of the firm down. Is the investigation just into Miss Watson, who left recently to go and work for Mr Pratt in his new private board role, working as the managing director? Did she take the fall for it professionally? I mean, we don't know, because there's no, or perhaps you do because you've received or will receive confidential information from chartered accountants, but to the public, there's been nothing other than continued billing.
So just
It
on
just continues on.
Just to continue this for a second. So we've received some suggestions before this committee that there needs to be another body to regulate professional services outside of accounting. Do you think that that's merited?
Look, I mean, I think ultimately you should be binding all of your consultants to the Public Service Code, and you should be enforcing the contracts on them. I don't know if you need a regulator or you just need a clear statement of the standards that the public service has to apply to. Enforce them onto the contractors. I mean, the problem with this is that the regulators don't feel particularly regulatory-ish, and they see themselves more as a membership group in competition with another membership group for accountants. So again, if we go to incentives, I can understand why chartered accountants find it difficult to take material fast action, even where the evidence has been there for some years unenforced. So
Yeah, but if you bind them, unless there's oversight, how are you going to make them accountable?
well, I guess if you're doing government work, it's not that common that you'd be submitting it to, or it'd be visible to, an external regulator. I mean, you could have one within the public sector, or you could have, I mean, there should be closeout reports and stuff done anyway. You usually, in my experience, you hear about it if someone's unhappy about something, and so you usually do hear about it. I guess these are more about, I mean, these breaches are not so much about sloppy work, they're about flexible ethics and, you know, and sort of fundamental breaches. I guess that's something where it is a matter of judgment. It's very hard to codify how to be a good person every day of the week, otherwise you'd be passing a law that says no DHs are allowed by law in New South Wales. It's a matter of judgment for professionals like it is for individuals, and I guess that we expect the public service to be bound by a code that's principles based. We can question how much that's enforced as well, but I would try and back that. I mean, if these are, and you need consultants, they're experts, they come in, they help the government to do things that are unusual and atypical. I guess it's where they're being brought in to be evidence makers for things that don't make sense, and in the case of Tahi, were never going to work. I mean, audit were already hot on the trail. It was never going to work.
Sorry, Mr. Fang, I've got Mr. Primrose, then Dr. Kane, and then I'll come to you.
Okay, but I'm just going to point out that I've been waiting patiently to ask some questions.
I hadn't realised you were seeking the call.
Oh, quite.
I will go Mr. Primrose and then you, Mr. Fang, and then I'll go to Dr. Kane.
I have a relatively simple one, I hope, and you've mentioned a number of things, and it's all incredibly interesting and valuable, so thank you for that.
Thank you.
I note, for example, you've raised two particular pieces of New South Wales legislation, partnerships, and that's something that we should seriously consider in terms of recommendations and review. But I was wondering if, out of everything else, if you could nominate some specific things that you believe this inquiry should recommend that flow out of your evidence. I mean, you've given us a lot of material and you've alluded to a number of things. I mean, if you could just 3, 4, 5, whatever, very specific things that you would recommend.
All right, well,
that we should be
now,
recommending.
Mr. Primrose. Let me just make a quick passing comment on the Partnership Act.
Yep.
I mean, the basic discipline, the reason that partnerships are not exposed to the degree of regulation and controls that corporations are is on the premise that the partners are jointly and severally liable and will lose their personal belongings if they let the partnership incur losses beyond what it can pay. That is premised, and it's in the Act, that it is about the partners all being engaged in mutual control of the organisation. That is not how these work. When you join KPMG, you are given an enduring power of attorney that you sign. At the same time you sign your partnership deed, it cedes all of your rights under the partnership. I think it's to the chief executive, but it might be to the chairman. And so in effect, you're an employee. You're not a partner. You're not jointly engaged. You never see the books of the firm. I did note with interest, I should have read the Act much earlier, but I could have actually gone in and demanded under the 1894 Act to inspect the books that must be kept on the premises. And I would have probably taken a feathery pen or worn my new academic robes or something along those. But I mean, I guess the point I'm making is that it's a nonsense that these are partnerships. They use legal agreements within them to create it into an old style partnership that doesn't even have a board that matters. It's just a kingdom run by the CEO and a cabal of senior partners. And why did we bring in the Corporations Act? Why did we strengthen duties on directors? Why did we bring in sort of insolvent trading protections and all of the rest? We did it to stop exactly these kind of structures and behaviours from happening, but we're letting it happen in the people we're expecting to patrol the borders. I guess in recommendation terms, I think that very clearly there needs to be public examination of the scope and remit and operation of the professional scheme for public accountants. I think that it's underway now by a body called the Professional Standards Council, but it is, as you say, a reference of concurrent powers that will occur under, and I think the New South Wales Parliament, New South Wales Government, members of the public, it's not a well-known organisation, but potentially quite impactful in the decisions that it does and doesn't make. The other thing to have a look at is the structure of your own legislation and whether it's appropriate given the passage of time and what we've seen, and whether it might be better given the fundamental aims of it to reduce it to accountants that are smaller, or to radically increase the penalties and make them uninsurable in some instances for the major firms. But I'd say that getting a new boundary around the operation of the professional scheme is one. I think that the more reporting that there is around the outcome of tendering, and I know that the committee and the procurement board and everybody else are sort of focused on that, but that's been a problem since the iCare kind of inquiry onwards about getting an honest picture of what's being spent with which consultant and for what purpose. I think transparency is always a good way to reduce an overgrowth of fungus, and in this instance it may well prove that transparency and being held to account by a regulated or regulator in a strengthened way, or a removal of the scheme altogether and a strengthening of contracts. But I think the broader problem is what's going on in the audit side of these firms. Are these same failings being repeated? And I guess that's the thing that should worry us all, not so much as taxpayers on the end of big bills for reports, but more for our superannuation funds. And we know from the ASIC sampling that there's been a very high failure rate, and they'll explain that and say, oh yeah, but they're the complex ones that they sample. Well, if you're failing half the complex ones, that's pretty bad, because complex companies are generally large ones with lots of our super in them. So,
Mr. Fang.
Thank you. Professor Lyon, thank you for appearing today.
Thank you.
we've heard from Cairns that there's some gaps in what it is that they're able to do. Do you agree that we might need to, I guess, strengthen some of what it is that they are able to look at and perhaps investigate?
So I think that from the way I read the bylaws, they can strip someone of membership, they can strike them off, they can, and it shouldn't take 3 years to investigate something where all of the. So I guess what I'm saying is the law enforced is the one that becomes optional, and that's probably what we're saying.
Are you a member of that organisation at the moment?
No.
And it's true,
They
isn't it?
They did invite me to rejoin on Friday, and I'm giving that due consideration at the moment.
and
truth,
would
I
that
should
be-
say,
would that- yes.
Mr. Fang, just if I may, that the meeting with Cairns was very pleasant, and I don't bear them any ill will. I guess if we go back to reality, they're fighting to be a relevant membership organisation, and that's what they spend their time doing. It's not an emphasis on discipline. No one's expected them to do it. They've not been held to it.
Yep.
I guess that's the gap.
But it's true, isn't it, that they can't investigate former members. So anything that you've perhaps provided by way of commentary or evidence that isn't quite accurate, that they're not able to investigate that at the moment, are they?
I would welcome. I would rejoin so they could investigate me if that's what you're
So
alleging.
is that a
Mr.
commitment, Dr. Lyon?
Yes.
So Professor Lyon?
Yeah.
Okay. No, that's interesting. And so, are you currently regulated by any professional body?
No.
No. So there's no, I guess, recourse to your professional.
For what?
Sorry.
For what?
For work, for example.
Well, I have contracts.
Sorry.
I have contracts. I don't have a protection, so they have absolute recourse.
Right. Are you a consultant?
Yes.
At the moment, you are under which organisation?
It's called Project Partners.
Okay, so it's not just your work with the university that you've got.
No.
So you also do
Yep.
contract work. And
We have a website. That's
does anybody
not secret.
regulate that work that you do
Yeah,
under
my
that?
clients do.
Your clients do.
And the work we're doing at the moment, yes, because I'm a expert witness in a case in the Supreme Court of Victoria where I'm the court's witness, so I'm definitely regulated by statute for that.
Okay. And what usually expert witnesses are there under a certain guise, as an expert. What's the expertise that you are?
Transport pricing, so very similar to the Tahi one, but not involving rail. I can't speak about the case.
Okay.
It's a modelling exercise.
It's a
lot
modelling
like-
exercise. Okay. What qualifications are required to be an expert in transport
Experience and
experience?
judgment.
So no qualifications itself.
In what?
Well, that's what I'm asking.
So I've got a MBA. I studied law originally, left that in fourth year. I've got a Masters of Business Administration. I'm currently doing a PhD on the regulation of professions.
Okay.
And I've spent nearly 22 years working in regulated, priced transport markets, have published very widely on them.
Okay.
And so I guess there is no degree that would cover all of those things. I guess it's professional experience that I've earned working in the infrastructure sector for a long time. If there is some suggestion that you have of improper anything, then it would be good to put it to me in the interests of the procedural fairness provisions of the
No.
committee.
I'm just trying to understand.
I
and build
understand,
the
yeah, no,
picture.
I understand what you're doing. Yep.
We've
Yeah, no, I understand.
we've had I guess a lot of evidence put to us, and evidence is really not helpful unless it's tested. So
Could I, just before I go to Dr. Kane, could I just perhaps suggest to Mr. Fang that this particular witness has provided folders of documents to this Parliament previously. If there is any aspect of his testimony today you would like further evidence for, please do put it to him now or put it in as a supplementary question so that we can clear that up.
well, Chair, just to that point, we are here as a committee, and the
so
committee
that's right.
is during its inquiries able to put questions to the
Yeah.
witness, and I'm just doing that. I don't
that's
think
fine,
my
but
questions haven't been ruled out of order. They haven't.
That's not what I said. All I was saying is that if you
I
have
know.
something specific, please do put it in the interests of procedural fairness.
And I am.
And I will now go to Dr. Kane.
Well, I hadn't finished my
Thank you, Chair.
questions, but
We'll
I
come
think-
back
I
to
mean,
you
I've
if
had
there's
literally
time.
5 minutes out of
We'll come back
Okay,
to you
we'll
if
come
there's
back.
time, Mr.
Thank you.
Fang.
Thank you, Chair. Mr. Lyon, just a quick follow-up before I get to my question on the questions from Mr. Fang. You weren't suggesting in any way that as a consultant that you would not be regulated by any of the suggestions that you've made. You would be quite happy as a consultant to submit yourself to any regime.
100%.
Okay.
My whole career has been demonstrated, or I have sought to demonstrate honesty and integrity in the work that I do. And I am more than happy. I mean, when I last appeared here, and it's probably a reasonable point for all of the committee to note, when I last appeared here, it was just me. I had a Treasury Secretary who was making awful allegations about conduct and personal matters. I had a firm that were backgrounding against me, meeting with politicians and giving them questions and suggestions to ask, all of that sort of thing. I guess this time there are findings, and it's a sort of, it should be a different, I guess it should be a different discussion, but in some ways it's not, because there haven't been consequences for anyone else.
And just to that, given that we've heard that there haven't been consequences and even reputational damage hasn't resulted in a decline in business, it would seem.
Yeah.
We've heard some testimony from KPMG yesterday and previously from other consulting firms where they've made seemingly very earnest commitments about the changing culture in their organisations and, you know, public mea culpas about what's gone before. How convinced are you about the cultural change in those organisations?
I was so convinced that I came off the bench when they wrote their submissions to the Commonwealth saying that they are, and to yourselves, saying that they are the most ethical firm and blah, blah, blah. I didn't even mention Tahi and the Commonwealth one. And then testified in June saying that they'd learnt their lessons and everything else, but the people sitting there are the same people that did all of that to the New South Wales taxpayer and by consequence to me and my wife and friends. I guess it just brings it home. It's sort of, they're still the same people, and it triggered me to write a submission, which I did to the Commonwealth, where I tried to largely focus not on KPMG, because in some ways I certainly feel sorry for the good people who work within all of those firms, and I think they've been badly led. I don't particularly bear KPMG ill will. I'll always not love that organisation, but I guess what I see is a sector that needs regulation because it's badly led and it's badly incentivised, and those two things together have led to some pretty bad outcomes, of which my last 4 years has been one.
Thank you.
I will go back to Mr. Fang.
Thank you. We were just talking about qualifications for the evidence that you're providing to the Victorian Supreme Court, I believe it was.
How is this relevant to the terms of reference, Mr. Fang?
Well, I'm just establishing credibility of the witness, that's all.
Could you do it in a more specific manner, please?
So I can't answer any questions about that case, Mr. Fang.
Okay, that's right.
Because it's regulated and I have to adhere to the ethics of that.
And you made the point to the Deputy Chair that your accounting background isn't by way of qualification, is it?
I'm not an accountant. I never said I was an accountant.
No, I think
In
we've-
fact, the part of my report where I question the accounting treatment is all about the requirement to give control of the rail assets across to a remote organisation. I don't particularly care about the accounting treatment. I know a hell of a lot more about AASB 1059, ASB 16, etc., than I wanted to. What I do know is transport, pricing, regulation, and that's what I did.
Yep. But in November 2020, your transport report said that state-owned corporations can be given direction by the shareholding minister.
They can.
They can? And it has to be laid before Parliament?
Yep.
Okay. Section 20N of the State-Owned Corporations Act does not allow for direction. Sorry, it does allow for direction, but there's no requirement for laying anything before Parliament. Is that correct, though?
I'm not sure, Mr. Fang. You might want to ask the Parliamentary Council's office. It'd probably be better
Okay.
to do that.
'Cause it seems that might have been not quite accurate in the report.
Mr. Fang, can I ask where you're going with this? Are we now having a discussion about your views of accounting treatment or your views of corporate structures versus Mr. Lyons?
I have plenty of views about corporate structure
Okay,
and corporate
could you
treatment.
please bring this back to the terms of reference?
Well, no, we're not testing my views here. Chair.
Well, no, we're not.
The last question I was going to ask is, we heard yesterday from KPMG that there were, I guess, a number of increased and improved whistleblower protections for people within KPMG, and you've indicated that you, I guess, used some of those. Were you at all, are you aware, were you at all the focus of any whistleblower reports to KPMG? Your conduct, your behaviour?
Oh, I'm sure, Mr. Fang, there were all sorts of vexatious complaints that were made.
From people that worked underneath you?
Probably.
Is that an admission that your
I
conduct...
have absolutely no idea, not that I'm aware of.
Not that you're aware
Not
of?
that I was made aware of at any time.
Okay.
And if one were to emerge now, I guess I would look at that with extremely sceptical eyes, given the passage of time.
Even if it was historic? And made in the circumstances that it was...
I would say that if KPMG want to start issuing documents, they should do it.
I'm simply asking a question. I'm not suggesting...
So I have absolutely no idea what you're talking about.
Right.
It was never raised with me at any point, and there were lots of conduct complaints that are all on the record that were issued to me. I've put them all on the record. Go and read them. There were complaints made by Ms. Watson that I had used words like, I'd bullied her by using words like ethics, professional scepticism, and said that I was unwilling to work with her on the basis of her conflicts and that had made her feel bullied and ostracised. That comments I'd made in the conflict group were similarly where I raised ethics and conduct issues that were fundamental breaches. They were also, I would have used the same words they used in the conduct letters, except I would have just explained them differently and said these are what I allege were the problems at KPMG. So I guess I don't know what you're talking about. It was never brought to my attention that such a complaint had been made, and if one emerged now, then I think most people would treat it with derision.
Mr. Latham.
Thank you, Chair. And Professor Lyne, drawing to the end of your session, I, for one, would put on record my admiration for your role as a whistleblower. As you've indicated, it's fraught with revenge, retribution, bitterness and personal cost to you, but I think we're all better off for your honesty and the material you brought forward now over a substantial period of time. So I think that should be recognised. But more generally,
Thank you.
Just to lift above the Tahi debacle, one thing that has come out of this inquiry is that under the former government, there's a relatively small number of firms, some accounting, some legal, some in other areas, who seem to get the great share of the work. Isn't this just evidence of how it's sort of reverse agency capture, that these consultancy firms know that if they play the game, they tell the government what the government wants to hear, regardless of the risks and the downside, they get the next job as well, and that we're so much better off doing this work through a fearless, independent, well-staffed public service that in the public interest acts according to the facts rather than a commercial interest of how do I gouge some more money with the next job?
I mean, I guess you need both. You need a really functional public service that knows what the mission is, knows what the lines are between a public outcome and a sort of political outcome, and where the line is to say no. I guess in my view, that is not served when work is concentrated amongst politically powerful, politically connected, small number of firms who say that they do everything, but from what I saw, they'll do anything. It's not everything they'll do, it's anything.
What makes them politically connected?
I mean, they're some of the largest political donors in the country. That was part of the submission I made to the Commonwealth, and they are the largest non-contractor providers to non-construction providers to government. So again, I think there's a range of ways that things could be tightened up. I guess my observation generally is the lines have gotten pretty sloppy. To Mr. Fang's probing questions, and I'm happy to take questions. I'll welcome them. I guess the point that I'm making is the entire sector needs to be tightened up. Government needs to be better at buying and specifying what it does. Needs to be better at saying what it is that, and the professions also need to be better incentivised to do proper practice of what they're supposed to do and not do everything or anything for cash.
Have you ever seen any accounting firm or any of these big four give policy or campaign advice during an election campaign?
Look, I'm certainly aware that they attach personnel to political oppositions over time. I'll take it on notice, but definitely, I mean, I'm aware, I don't know if KPMG does, I'm aware another firm had done that. Let me just take it on notice and I'll just refresh my recollections.
Thank you. Unfortunately, we are out of time. I just want to ask one last question, just reflecting again on the evidence you've given us today, the evidence we heard yesterday, as Dr. Kane says about, this sort of reformed KPMG, that they've learnt lessons and that they've sort of changed the way that they've behaved, or that they're now behaving. Right at the beginning, you mentioned that the CEO, Mr. Yates, was aware of your concerns. Did you face retaliation from Mr. Yates?
Yes. Yeah, I mean, he was the incoming CEO. He is the one. All of a sudden, it was me out the door, and they waited until Tahi had gone through cabinet, which I think happened in February, and then just got hit with a conduct complaint every few days until I was gone from the firm. So it was led by Mr. Yates. He had put a prohibition, or agreed a prohibition, on me doing New South Wales Government work, which is an infrastructure partner. He lives in Sydney. Is pretty.
Did you get a payout when you left?
I did.
You did?
Yeah. It wasn't big enough, Mr. Fang, but yes, I did. And again, it sort of shows you that they knew that things were untoward at the time. If I was facing conduct complaints that had even a scintilla of backing, I don't think I would have got the retirement benefit that I did get. But if the whistleblower protections that applied to corporations existed, I wouldn't have had to have expended money to defend myself in the context of ensuring that after subpoena, the right things have come out.
And people that worked with you at KPMG followed you, didn't they?
They did, yeah. Some of them have moved on now, but yes, they did. And again, I wouldn't be surprised if everybody in my team put in complaints about their treatment. They should. It was disgusting. If you go and read the email I sent when I got disciplined for not doing the occupational health and safety training, because I had been taking cold and flu tablets and up for 48 hours to get the first report in because we were given no resources. I was then disciplined for being aggressive in my explanation of why I hadn't done the training. Nonetheless, the working conditions that my team and I had to suffer and endure were a disgrace, an enduring disgrace. And I wouldn't be surprised if every single one of them went at KPMG for something. They should.
Thank you. Unfortunately, that is all we have time for. I think we could speak for many hours with you. Thank you. It is not easy being a whistleblower, but I know that this inquiry and this committee, in its former iteration in the last Parliament, has benefited greatly from the evidence that you've given, and we've certainly a lot wiser than we would be otherwise. So thank you very much.
Thank you.
To the extent that there were questions taken on notice or there are supplementary questions, you'll have 21 days to respond, and the committee secretary will be in
I
touch.
only took one, but I also only took one last time, and it was a 162-page response. I guess Mr. Fang may want to start there just to get some of the history when he wasn't on that committee, but it's very well evidenced and would probably put to bed some of the concerns he might have.
Excellent.
Thank
also
you.
look
Forward to you joining.
Okay, order. Thank you very much. That concludes this session. We will bring in some new witnesses. Thank you.
Thank you, Professor.
Thank you.
Thank you.
Excellent. I think we're ready. Great. We now welcome our next witnesses. If I could ask each of you to please state your name and position title and then swear either the oath or the affirmation.
My name's Angus McFarland. I'm the Branch Secretary of the Australian Services Union, New South Wales ACT branch, and I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
Good morning. My name is Jan Primrose. I'm the Deputy Secretary of the New South Wales ACT ASU Services Branch, and I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. We'll just get that microphone moved a bit closer. Excellent.
Thanks.
Thank you. And would you like to begin by making a short opening statement? Please go ahead.
Thank you for the opportunity to appear before this committee this morning. My name's Angus McFarland. I'm the State Secretary of the Union, and I'm joined here by Jan Primrose, my deputy. Our evidence today is based on conversations, feedback and insight from our members. In New South Wales, we cover community services, the NDIS, airlines and transport, but of relevance to today's deliberations, we cover the water industry. We're the Union for Public and Private Water in New South Wales, including Hunter Water, Sydney Water, Water New South Wales, and private providers, which includes the desal plant Veolia and others. And today I'll just focus my opening remarks on Sydney Water. Sydney Water is a utility that provides water, wastewater, recycled water and stormwater services for the Sydney Basin. The latest annual report shows that Sydney Water has approximately 3,000 full-time equivalent direct employees. There is no data on the number of indirect employees, those employed through contractors. Sydney Water's most recent available annual report states that over the next 4 years, it will deliver capital works of about $8.21 billion. This is a very significant budget to deliver essential services and with very significant implications, obviously, for planning and for the environment. This expenditure should be spent in the best interests of people and the environment. Now, while we do know the approximate budget, we do not know how it will be spent in terms of the use of consultants and contractors. It is of concern to our members that consultants, in fact, also do become contractors. The manner in which this happens may vary. However, we believe that at Sydney Water there has been extensive use of private external consultants to provide feasibility studies and proposals for capital works and maintenance projects. And we believe that those private external consultants have access to internal information that allows them to develop these proposals and studies. We further believe that those consultants are able to utilise that information in their own tenders to deliver projects. In this way, consultants on capital and maintenance projects become contractors on the same projects. Our concern is that this is not transparent or accountable procurement process. We further believe this has led to a hollowing out of skills and networks in the workforce at Sydney Water in relation to specialist procurement, engineering, planning and design and related teams, and also in relation to the field staff of tradespeople and other skilled workers. Our members are further concerned that projects delivered by external providers may not be at best practice standard, necessitating further and expensive rectification work, which increases the final cost of projects. Another concern is the inefficient use of public funds to deliver essential water services, and that this is leading to an unbalanced budget in which funds are not effectively prioritised as issues requiring urgent work replace planned maintenance and work. And this has led to the budget at Sydney Water, we believe, not having sufficient funds for effective long-term preventative maintenance, which can cause obviously disruption to water services, such as the recent experience in Lane Cove, where people had no water supply for up to a week. At the recent state election, there is a clear difference between those competing to be Premier around a commitment to protecting Sydney Water as an essential public asset, and the electorate overwhelmingly endorsed the current government's position. And the first piece of legislation enacted by the new government was to protect Sydney Water and place it in the Constitution. Unfortunately, it appears, I think, that some of those appointed to deliver the agenda of the previous government have not acknowledged that there is a new government. The Managing Director of Sydney Water was appointed by the last government in 2019. I understand from annual reports his salary is in the vicinity of $800,000. And prior to his role at Sydney Water, he did work as the head of some of the largest private water providers. For example, was the CEO of Suez, which last year was awarded a prominent contract to deliver upgraded Prospect water filtration plant. He also was Managing Director of United Utilities Asia and Pacific, which was also awarded a very significant contract last year to construct and operate the Upper South Creek Advanced Water Recycling Centre. It's important to note, though, that the preference for private consultants and contractors is not limited to organisations the Managing Director has previously led. There are many other private consultants and contractors delivering major projects across the organisation, and our members tell us they are often associated with cost overruns, necessitating late variations and delays in project delivery. For example, in recent weeks, our members were told of $40 million in cost overruns in the treatment division alone of the organisation, while approval was recently given for a further 20,000 man-hours of work to external private providers. We have further reason to be concerned about these procurement processes. At Sydney Water, it's all underpinned by a secretive panel of preferred providers, and we have been informed that there are examples of internal costings for projects being significantly less than the quotes provided by external providers who are ultimately awarded the very lucrative contracts. And we've also been told of demand for late contract variation by these private providers, variations on already late contract delivery for critical maintenance. And then when those projects are delivered, we're aware that there are instances of critical asset damage and work of being such a poor standard that additional and expensive work is required to meet legal operational requirements. And in support of this view, our members point to significant increase in prosecutions, fines and penalties levied against Sydney Water in recent years due to their breaching of operating licences that can be linked to poor procurement practices. The recent example being $400,000 plus costs and a requirement for an apology by Sydney Water associated with the 16 million litres of sewerage at Narromburn. It appears that to many, the payment of fines and penalties has become a cost of doing business rather than a cause for shame. And we do know that EPA officials have told our members that they regard Sydney Water's business model as putting out fires rather than a realistic plan for preventing them. So in summing up, in the views of the essential services that Sydney Water does provide, and in the interests of public accountability, we do believe there are many questions that Sydney Water need to answer. Indeed, we believe it would warrant its own separate inquiry process with the broad terms of reference, including the management of the organisation, procurement, use of contractors, use of public funds, and whether the organisation is meeting environmental and other standards, including staffing issues. While we can provide some information to you based on what is on the public record and based on what our members tell us, it appears that Sydney Water Corporation, as a state-owned corporation, is not required to provide the same level of information and data transparency as other state government agencies. So that's my opening statement, and we're happy to respond to any questions.
It's monologues today.
It's quite a statement, and again, a very good one and worth the extra time for. There's a whole lot of information that you've just given us that seems incredibly valuable. Firstly, are you able to table the opening statement? That might be helpful for us to get our heads around it ahead of having Sydney Water in front of us later on. Where do we start? Can we start with...
Sorry.
You're okay. Can we start with the issue around the contractors and these consultants sort of becoming long-term contractors? Can you just go back, because that was a lot of information.
Yes.
Can you explain a little bit more about that?
Yes, and I might ask Jan to elaborate on this one. But our understanding is that a lot of the private consultants who are used to help develop feasibility studies do have access to information which can then be useful for them to assist or advise contractors bidding for work. There's a lack of transparency around how the panel of preferred providers, etc., is established, but it's something that our members inform us is a problem and there is a link. But Jan, do you want to elaborate on that?
Sorry, go ahead.
Do you want me to? Do you want to ask first?
Oh, I was just going to say, so, okay, we can ask Sydney Water about that that panel of providers. In terms of the contractors you're talking about, so it sounds very similar to what we heard in relation to the transport and metro stuff yesterday, that we have these people sitting within government departments who then have access to a bunch of information that they're able to then take and use to sort of pitch for more work. Is that correct?
Do you want to?
Yeah.
If it's okay. Yeah. So our members have explained to us that a common process is that if there's a major operational maintenance or capital works project, that a specialist consultant will be brought in to develop a proposal. It might be a feasibility study or it might be a proposal for a project. And to develop that proposal, they would have access to a whole range of otherwise confidential information at Sydney Water. They would then develop a proposal, which they would present to Sydney Water, and then they would bid to deliver the project. But they would have the advantage of the information that other people wouldn't. But also because there's a panel of preferred providers, if they're also on the panel of preferred providers, then they have a second advantage in making their or proposing their tender. But in some of those instances, they are also tendering against Sydney Water for the tender to deliver the project as well. But they have the advantage of already having all the information, plus the advantage of also being on the panel of providers. So
Does that mean the internal employees don't have access to that same intellectual property to be able to make an informed bid?
Our members have told us that while they might have access to the information, they haven't had the advantage of having developed the proposal. And if they've developed, if the external consultant has developed the proposel, then they're in an advantaged position relative to.
Is there a case study of this that we could look at? It's good that members give you feedback, but
Sure.
Are there specific examples that the committee could examine?
There are a number of examples. I think it would be. It's probably better if, with respect, if the committee were to ask Sydney Water for specific examples, because the procurement team is very small at Sydney Water, and if we gave very particular examples, I think that could be a problem for the members who have given us the information, if that's all right.
Can I just ask, by way of context, 3,000 directly employed, I think you said.
A bit over that.
What's been the historical, presumably, decline? Do we have any stats on, 10, 15, 20 year? What was it historically? I'm just interested to know. Presumably, you've got a public utility. Well, it's essentially a state-owned corporation now, but public utility for all intents and purposes. They've got a job to do, and that's to supply water to a big and growing city. So presumably, the work has actually increased, hasn't gone away. So if there's been a decline in full-time employees over a period of time, that's got to have been supplanted by these other people. I'm just interested to know what sort of quantities we're talking about.
I don't know the exact. My recollection of this is that they used to be around 10,000 employees at one stage, direct like their own. I would want to check that, and I can provide further information. But that's my understanding of kind of the trend over the last couple of decades.
We might ask Sydney Water that too. Yeah. Okay. So 70% reduction in internal staff over what? Probably 15, 20 years.
Yeah.
Thanks.
That would be my guess. As I said, I'd want to check that.
Yeah.
So are these contractors sitting next to employees? Is this and we heard yesterday a relatively new thing that Transport are doing, where they're making efforts to protect their confidential information by letting everyone know who's a contractor and who's an employee. Has Sydney Water done that? Do we know? Is it clear who's an employee and who's not?
No. We're not aware of something that would, like, if you're talking about labelling or something, it's nothing clear like that. But certainly the people who work at Sydney Water are aware of who is on the site as a contract employee or a consultant, as distinct from someone who's an employee of Sydney Water, although the contract staff drive cars that have Sydney Water labelling all over them, and they wear clothing and do other things essentially as if they were Sydney Water employees.
And email addresses and things, is there any difference if you're emailing internally? Would you know if you were emailing someone who is an employee or a contractor?
I'm not aware that, from what our members have told us of, people who are working for consultants or as contractors having the same email addresses, but the contract and consultant staff often also work in the field, so that you might have, for example, if they were doing a maintenance project, you might have a team of 20 or 30 people working on a site, and you couldn't tell who was a Sydney Water person and who was not directly employed by Sydney Water. They're all essentially doing the same work at the same site, or similar and related work.
Ms. Primrose, have your members suggested or given you any indication about the length of time that these non-employee people have been around? Have they seen evidence of moving from project to project?
Certainly, yes, they have. And their concern is that the number of employees of consultants and contractors has increased exponentially, and that projects are extended end on end, so that at the beginning of the period of time, for example, when it appeared that Sydney Water was being prepared for privatisation, appeared to our members, that some very large contracts through consultants were commenced with long contract periods, like 5 years with an option for a further 5 years. So they extend over very long periods as well.
Wow, okay. And could I just ask while I'm here, Mr. McFarlane, you spoke about connections between the current CEO and organisations that have subsequently won large contracts. Could you expand a bit on that? And is there evidence that you could provide?
Well, I guess the evidence is that annual reports of the company and his LinkedIn, in terms of where he's worked and who has contracts with the company since that time. Very significant one. So it's all on that's all on the public record. As I say, and I want to be clear in my statement to say I'm not. There are other. I'm not trying to suggest that every single thing is based on their use of contractors are limited to sort of places where he has worked. I'm not suggesting that, but I was just pointing out facts that are on the public record. And I think when you add on to that the lack of transparency around the process, the decision making, internal bids and other things, that's why we do have, I guess, questions about all of that.
And is this fellow, Mr. Charoux, I think his name, is there a track record of him prepping public utilities for sale?
That campaign's finished, mate.
I believe that he was. I believe that in South Australia he was a part of or worked there when that was privatised, South Australian Water.
Smoking gun.
Prior to here, moving to New South Wales.
Okay. So in your industrial instrument, is there a provision? How elaborate is the provision for internal employees to be able to bid? Like you mentioned that they have, Ms. Primrose, access to information, but not necessarily the wherewithal or time to develop an alternate proposal. Was that an accurate characterisation of your evidence? And therefore the contractors have an advantage because they've obviously got the developed proposal?
I think it would be maybe more accurate to say that, and reflecting on Mr. McFarlane's comment, that over a period of time, we've been told that the original procurement team at Sydney Water was replaced. So all of the people who worked on the procurement team, a significant number were replaced by a new procurement team and the new panel system. And there is a new procurement team. But major projects are not necessarily developed by that procurement team. So there would be people in specialist roles throughout Sydney Water who would need to be brought together to develop a proposal of the size and magnitude and cost that is involved in a major public utility by Sydney Water, like Sydney Water. And over a period of time, as more and more consultants are brought in and less work is done in-house, there's been a hollowing out in the skills and the ability and capacity of the organisation to compete with those specialist consultancies. I think, I'm not trying to work around, I just think it's not a straightforward
so essentially,
thing.
The wherewithal for internal employees to provide an alternate bid and put a proposal together theoretically could be there if there was the intellectual infrastructure to put it together, but there's not because it's been hollowed out because of,
Certainly, and that's not uncommon to Sydney Water. That's a more general problem.
Yeah.
Could I ask a follow-up about, current employees? So I think, Ms Primrose, that you said that consultants or contractors are working alongside full-time or ongoing.
Now, point of order, Chair. There's these constant sort of juvenile interjections from the member. We're trying to listen to the question and the answer. I ask you to ask the member to stay silent while we're asking questions.
In that case, I will take a point of order because I'd actually indicated to the chair that I had questions, and instead of seeking the call from the chair, the member just went into and launched into questions. So the chair didn't have the opportunity to provide the call to me.
Order.
My apologies, Mr. Fang.
Order.
Thank you.
I will allow Dr. Kane to finish her question and this line, and then I will come to you, Mr. Fang. There's plenty of time. Go ahead.
Thank you. And Mr. Fang, we have been pursuing, you're not always on this committee, we have in these hearings pursued a free-flowing approach. So let's just
Again, it's
ensure
free-flowing
that.
through the chair.
Thank you. My question, Ms Primrose, was you indicated that these consultants and contractors work alongside ongoing or direct employees of Sydney Water. Would the contractors and consultants be members of your union?
I couldn't tell you, I'm sorry. I just couldn't tell you, I'm sorry.
Okay. So they wouldn't, but they wouldn't necessarily. But there has been an increase in those consultants and contractors over time, instead of direct employees. And do you think that that might have any impact or be informed at all by negotiations or the situation with regards to enterprise agreements and Sydney Water dealing with the union as a representative of those workers? Do you think there might be any intent in hollowing out, any industrial intent in hollowing out the permanent ongoing workforce?
Probably should be.
I'm not aware of that, no.
Okay.
Mr. Fang.
Oh, thank you, Chair. Much appreciated. Mr. McFarlane, I noted during your opening statement you talked about the piece of legislation that was put forward to have Sydney Water protected by having it included in the Constitution. You'd know, I'm sure, however, that there were a number of other, smaller rural regional water entities that weren't included, that other parties within the Parliament thought should be included. Did you have a view on that? That there was only a selective protection of metropolitan assets and not for rural and regional communities?
I think first I'm not exactly sure how this starts within the terms of reference to this inquiry, but
I think it's just related to, I guess, the opening statement that you made in general. I was just curious to sort of get a baseline from where I can start the questions.
Yeah, I think that the government's commitment was in response to the previous government failing to rule out privatising certain things, and I don't know that
they
related
do that,
to
Did they
those
fail
things.
to-
So you asked me for my opinion on it. I'm just giving it to you.
No, yeah, but I'm just asking, like, factually, did they...
All
did
right,
they fail
order.
to-
If we could allow the witness to answer the question you've asked.
Apologies, Chair.
So yeah, that's I guess my response to that.
Okay. So you didn't have a view that rural regional communities should have their water assets protected as well?
I guess that would be something that the union for those regional assets is not the ASU. That's a different union. So I'd be discussing with them their members' concerns and seeking, as unions do when we on policy matters around industries we don't cover.
Oh, no, but I mean, just in relation to that, I guess you were happy to provide a view earlier to the first part of the question. Do you not have a view on that?
I've just answered your question. So.
Yeah.
No,
Can you...
thanks.
sorry. Are you going to continue down that line of question? Because I wanted to ask how it related to terms of reference. But if you're not going to continue, then I don't need to ask.
I'm happy to move to some other things.
Have you got another question?
I certainly do, Chair. I've got many
Please go
questions.
ahead.
In fact, if I don't get through them, I might put them on notice, but we'll see how we go. Just in relation to the, I guess, opening statement that you made as well around the current head of Sydney Water and previous roles, does it not strike you as perhaps disingenuous to suggest that one's actions in a previous employment or entity are somehow going to be reflected in their current role? Certainly, there are many people who have been employed in roles prior to their current role, may have had a different scope in their tasking, but is it not, I guess, coming here and using parliamentary privilege with an axe to grind to, sort of make these sort of statements in an opening statement that are
point
baseless?
of order, Madam Chair.
Well,
I will hear the point of order. I will hear the point of order.
The point of order is this. The member is referring specifically to an answer that the witnesses gave to a question I asked. They weren't verbaling people or trying to undermine people's reputation. They answered to the best of their ability in a factual sense to a question I asked about the Chief Executive's previous employment history and track record.
To the point of order, I was referencing the opening statement, and then I was going to further elucidate that answer by asking the witness to, I guess, provide some evidence of the anecdotal points that he indicated were from his members. And so I was going to start there and then work my way down.
Okay.
I was teasing out a line of inquiry.
Order. In relation to the point of order, I would ask that we show respect to the witnesses we have in front of us. If we could,
I believe I was.
please be more direct in the questions that you're asking,
Well,
without as much commentary that lends itself to inference that
Well,
may
it's a
not
quid
be
pro quo,
desirable.
Chair, I might say, because these opening statements that are more like monologues
order.
are unhelpful. Mr. McFarlane, do you have any evidence to support your opening statement concerns that you raised around the head of Sydney Water?
Yeah, it's the annual report of Sydney Water and the LinkedIn of the managing director.
Okay.
On the public record.
Do you have any documents that indicate a predisposition or a prior willingness to engage in these, I guess, concerns that you've raised?
I don't think I indicated there was a predisposition.
Okay. In relation to the, I guess, the anecdotal evidence you raised during your opening statement from your members, whilst interesting and, as the chair I think indicated at the time, somewhat spicy, or that might have been the previous one, but certainly that that there was interesting points raised in your opening statement. I note that it was, as I indicated, anecdotal without a lot of evidence. Are you able to provide? Are you able to provide specifics in relation to the concerns that your members have raised, the work that's been done in relation to investigating or determining the validity of those concerns.
Point of order, Chair.
I'll hear the point of order.
I'm not sure if Mr Fang was listening, but Ms Primrose did, in answer to, I think, a question from Mr Latham, did answer regarding her concerns about being able to do that, and how one way for us to potentially verify those issues was indeed to ask specific questions of Sydney Water, which we intend to do.
No, I appreciate that.
Order.
and I-
There is no point of order as such, but I will again ask you, Mr Fang, to please ask specific questions about what it is you are seeking elucidation or evidence about, rather than a more generalised.
Maybe it helps if the union could provide the case studies on a confidential basis to the committee, which is standard practice, because without detail, it's very hard to make the.
And
informed
that's
judgment.
exactly the point that I'm making,
Please
Chair,
get
is
to
that
that point.
the opening statement made clear reference to concerns raised by their members around conduct or behaviour of the entity without actually identifying
We
specifics.
don't want
We
people
need,
to lose their job.
No.
But
Exactly.
but we
confidential
need
information.
specifics as to what it is that
Okay,
we're seeking
order.
to ask questions about.
Is it possible to provide any more information to us on a confidential basis after the hearing?
Yes, so as I said in my statement, the evidence I've given is based on conversations with our members, and as members of the committee have pointed out, we, based on what Jan said earlier, we do need to take into account the privacy and job security of our members, but we can certainly ask them about providing that detail in a confidential way, as has been suggested.
Can I ask then, in relation to those conversations, obviously where concerns have been raised with you, have you documented those? Like, have you made file notes? Have you got a register of these concerning reports or conduct? How do you track these conversations that you have with your members?
We talk to our members all the time, every day, as you
No,
would
I appreciate that, but how do you
appreciate.
register it?
Yeah, so we talk to our members all the time, and we talk then share information internally through our different channels, through our team meetings, discussions that people have, etc.
But how do you record it? I mean, how do you ensure that these concerns that you've raised, that you've come to this inquiry and included in your opening statement,
Well, point of
are
order, Madam
registered?
Chair.
I'll hear the point of order.
The witness has clearly answered that it's recorded in the collective conversations that they have with their members on a daily basis, and it's now on evidence in the transcript from the opening statement that this is what their members say, so we should take that on face value because it's the evidence under oath.
Well, to the point
Okay.
of order, there's
What about the Australian Paramedics Association? You didn't
All
take
right,
that.
order.
yes. To the point of order, Chair, I guess what I'm trying to do is seek an elucidation around this issue, given that it was, I guess, felt by the witness so important to actually come and provide
Okay.
evidence in the opening statement.
Witnesses
I'm
Order.
just seeking to understand how it is recorded and actioned within the organisation. I'm sorry, but
Yep,
conversations
order.
is
I'm
not
done.
appropriate.
I'm done hearing the point of order. Thank you. There's no point of order. However, Mr. Fang, in the interest of time, I need to go to other members soon. I'm going to allow you to ask that one question, and then we will be going to Mr. Farlow.
Okay. Can you provide to the committee, please, on notice, the evidence of those conversations as recorded by the union, so that we can, I guess, better understand the way that it's recorded for following up purposes, but also so that the validity can be cross-referenced?
I've already made an affirmation about the things that I'm saying, and I've already said that it's based on conversations, feedback and insights, and I've already given commitment to Mr. Latham around how we'll be able to provide more information to
Does
the
that
committee.
mean you don't record them?
That means I'm responding to Mr. Latham's request.
I understand that,
And
but
not-
I mean,
not
my
yours.
request's separate and discreet.
I've responded to your question.
Okay, order. Mr. Farlow.
Thank you very much. Thank you, Mr. McFarlane. Just following up, so in your opening statement you outlined concerns about Mr. Charoux's previous engagement with Suez and pointed out a contract with the Prospect Wastewater Treatment Plant. Just Suez is somebody who has been in that space for quite some time. Have you got evidence in terms of an uptick of work to Suez since Mr. Charoux's come into the role?
what we have available to us is what's on the public record about the contracts that they declare in their annual report, and what I was pointing out in my statement is also what's public about where he has worked. I have not done an analysis myself of from the date he's commenced to every contract since, etc.
Sure.
And as I did say in my statement, it's important to note that the issues around contracting don't just, from our perspective, aren't just relating to companies that he may or may not have worked for.
Sure.
And just as a quick follow-up, which will perhaps help, is that information available from Sydney? They don't provide it. Why have, presumably the unions asked for it?
One of the concerns that Mr McFarlane raised when he was in his opening address was precisely that point, that unlike other state government agencies, departments and entities, the requirement to make public all of the contracts that the organisation enters into is different. And so what we've been able to do is look at what is publicly available, and that's available on the Sydney Water website, in their annual reports and other places, at their IPART submissions and so forth. So we've been able to look at those, but we're not able to access further information, and that also informs the comment that Mr McFarlane made earlier, which was that to divulge publicly too much information would be difficult because that information is not publicly available, and therefore to provide information on that other than on a confidential basis would expose the people who potentially might have given it to us. But certainly they would be questions that perhaps Sydney Water could be asked, but they're not keen to give us that sort of information, no.
Thank you, Ms Primrose. And Mr McFarlane, you've called publicly for the dismissal of Mr Charoux from the role as CEO of Sydney Water. And I don't know if you went that far today in the opening statement, but certainly did say that he didn't necessarily fit with the change of administration now. In a recent article, it had been indicated by Minister Jackson that she'd be meeting with you, I think, within 2 weeks from that article. Has that meeting taken place? And if so, what's the outcome of that meeting?
Yes, the meeting was yesterday, and it was in relation to that and a second letter that we wrote to her on Monday following the vote at Sydney Water, where 75% of employees voted to reject the organisation's proposal around cutting their conditions. The letter was basically suggesting a path forward, and we wrote a letter similar to Mr Charoux yesterday, on Monday as well, and the meeting with the Minister was about us articulating our view.
Was there any outcome from that meeting? Or?
No, I think she said she just wanted to think about it, basically, but just was us articulating our position to her.
Thank you.
Chair, can I, just on that agreement, 75%, that's pretty high no vote. Are you able to inform the committee on what the proposition was from Sydney Water for the yes vote, like in general terms, so we've got an idea of the sort of circumstances surrounding the no vote?
Yeah. So Sydney Water were proposing to basically take their employees backwards in their conditions at work. So putting up to 50% of their employees onto individual sort of contracts, removing, disrupting, I guess, established work patterns. So increasing the span of hours, removing RDOs, etc., making people work longer for less, and which would have impacted overtime, rostering, caring responsibilities, etc. And that was all very, basically, the workforce gave a very clear indication of their views on that.
50%?
More than 50%.
What, contracting out of the agreement, essentially?
No, it's a provision that is around putting people onto what are called independent contracts within the EA, where sort of all of lots of different provisions.
I like
no longer
local
apply to
workplace,
them.
the old local workplace flexibility agreement setup. Yeah.
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 Well, it's a bit different to that as well, actually. But
Yeah.
if you want to.
They're not individual flexibility agreements. It's more than half of the workforce on individual contracts of a kind that was very common 25 years ago and is no longer common.
Could I ask, in follow-up to that, do we have any sense of the arrangements or the workplace arrangements for those consultants or contractors who are working alongside your members?
I can tell you that some of them have enterprise agreements as an industrial instrument. I can certainly tell you some of them do. I couldn't tell you honestly what all of them have, but I can certainly say a significant number have enterprise agreements in their own right. Okay. And we've seen those enterprise agreements.
Okay.
And is there any provision in the main Sydney Water agreement for those external people to have similar wages and conditions?
In fact, the external contractors have better wages and conditions.
Mr. Fang.
Thank you, Chair. Mr. Fallon, I just want to return back to your opening statement. Just in relation to the reports from your members, are they often related to the quality of work or the cost overruns, etc.? What are the basics of these reports?
I'll ask Ms. Primrose to answer that one because.
Sure. I'm sorry. I just want to understand the question.
Sure.
Would you?
Sorry. The reports that you get from your members that are raising concerns in relation to, I guess, Sydney Water and I would assume the performance or conduct of contractors or consultants. Could you provide just some insight as to is it like work related or is it paperwork related? Is it
Sorry. So there are consultants and contractors who do a very wide range of work at Sydney Water. And so the comments that have been made to us by our members vary according to the different work that's being done. But certainly you would be correct that our members certainly have raised with us their concern about cost overruns, late delivery of work, and work that they say they're disappointed in the standard of work that's delivered. Those sort of comments. Is that what you mean?
Yeah. So there's some cost overruns.
Yes.
Would shoddy work? Would you describe it as sort of shoddy work or incomplete work or?
Certainly, that would be one of the options. It's not their main concern, but certainly they have raised that with us from time to time.
Okay. So, Mr. McFarlane, in that instance, then, if they're raising concerns around shoddy work or incomplete work, wouldn't that then, I guess, trigger within your organisation being a union that there's perhaps a safety issue there? Shouldn't those things be recorded and shouldn't they be progressed by the union where they're raised?
Yeah, I guess we're talking about a series of conversations that people have had with us that we're bringing to this in the context of your terms of reference. That's not to say that when people raise them with us at the time, we don't actually act on them in the appropriate way as we would as a union.
No, and I guess that's the bit that I'm asking is that where those things happen and there are, statements that are made to you around incomplete or insufficient work of a mechanical or physical nature that's designed to from a physical process point. I would imagine that should raise, given the nature of Sydney Water, some concerns around safety. There should be a safety report as a union. You should be following this up and actioning it, shouldn't you?
Yeah, I mean, whenever our members raise issues with us around safety, we of course support them on those matters and to raise them, and it depends on the particular issue, because you've just listed a whole bunch of hypotheticals. So
no, I appreciate that, but you've not provided any details, hence the reason why I have to put hypotheticals. I'm asking, there should be a register. You can provide that to us, can you not?
I've already answered your question before about the information you want, and I've given a commitment based on Mr Latham's request, and we do respond and support members on
No, I
issues they
appreciate
raise
you-
with us, as you would expect, including safety.
I appreciate that. However, I
Yeah.
guess what I'm asking is that can you provide on notice the register where these concerns have been raised and that you have followed them up and actioned them? Because I
Point of
imagine as a
order,
union
Chair.
that
Point of
is
order.
I'll
that
hear
is
the
required.
point of order. I'll hear the point of order.
I think Mr McFarlane and Ms Primrose have indicated that they will go back and provide the appropriate information. The particulars that Mr Fang is asking for are not at all related to what we're looking at. In fact, he has been badgering the witnesses who are acquitting themselves very well, but it's not appropriate.
I don't think that's all up
To
for you
the
to
point,
judge, but,
sorry,
you know.
I'll rule on the point of order. I do think you were coming perilously close to badgering Mr Fang.
But I was skirting the
Are there
edges. I
any
didn't cross the
other
line.
questions?
Yes.
Thank you. Please go ahead, Mr
On a
Bokey.
related issue, so the evidence is that Ms Primrose, that the contractor is actually getting paid a higher rate in a lot of circumstances or all circumstances. So it's actually costing Sydney Water more to do this work externally. And just on related to Mr Fang's line of questioning, in terms of any history of penalties and breaches from Sydney Water, can you just inform the committee of where that may have occurred?
Sure. I could give you some examples. Is that what you're after?
Yes.
Yeah. I guess the most, keeping in mind that sometimes these things take a while to be processed through the relevant department. I can tell you about a most recent one, which was about $500,000 and a requirement for a public apology, and that related to $16 million litres, overflow of sewage at Naremburn. But some other ones, the penalty there was $865,625 relating to a sewage overflow in 2020 of Naremburn Creek.
Is this contractor work, is it?
It's not specifically contractor work. These are environmental breaches and breaches of licence that have arisen. In some of those instances, there would have been consultant and contractors working on those sites, certainly.
Yeah.
And there's a list of those on the public record. I mean, I can list them or we can table it, but there's a long list of those. Is that what you were interested in?
That'd be
yeah,
good.
Certainly.
And
yeah.
just on this general theme of consultants and contractors supplanting the internal workforce, is that consistent across the capital works program and the maintenance as well?
I couldn't give you a precise figure, although I can probably. I mean that's not available publicly, but I can certainly tell you that our members have told us that it's a very significant problem, both across maintenance and capital works. Certainly.
Okay, thanks.
Thank you. Is there other further questions, Dr.
Thank
Kane?
you, but I won't ask them.
I just wanted to just see if there was anything further. Mr McFarlane, you did mention contract variations in your opening statement, and I just wondered if there was anything more that you wanted to add about that, or indeed Ms Primrose.
Only to reflect on what Mr McFarlane said earlier, that our members have been concerned that on large capital works and maintenance projects that there are significant cost overruns and also significant contract variations of multi-millions of dollars. Their concern, and I should say this stems from the fact that a large number of our members have worked at Sydney Water for quite a long time, and they are overwhelmingly proud of the work they do, overwhelmingly. They're really aware that what they're doing is delivering an essential service, and they're very aware that Sydney Water has always had a good reputation for providing clean, safe water, through fires and floods and COVID and so on. So they're proud of the work they do, and that's where their concerns stem from.
Can I ask on a related point? Do you have reports from your members having to go back and fix issues that contractors have created? 'Cause that's
Absolutely.
often a complaint
Yep.
in these situations. Yeah.
Absolutely. And their concern arises not only because as skilled workers they have pride in the work they do and they want it to be done to a high standard, but it also stems from that overwhelming pride they have in working for Sydney Water. And they genuinely believe it should be done properly and to a really high standard.
It's
And
pretty
so
galling to know that you've got someone working side by side who's getting
Sure.
paid more, who then
Yes.
stuffs up, and you have to go back and fix it.
that's true. And I might also say nobody, including Mr McFarlane or myself, would blame the workers who are employed by those contractors for being less than adequate workers. That is absolutely not what we're saying. But the circumstances in which they're working mean that jobs simply are not being done to the standard that I think the public would expect and the skilled workers who are working beside them would want to see done. So it's not a criticism of the workers so much as the circumstances they're working in.
Just in relation to those points that you've just indicated to Mr. Buttigieg, can you provide some evidence of that as well, where work's been done by a contractor that has then required Sydney Water employees to go back, and just what's with the documentation around that, if you wouldn't mind?
Certainly.
Thank you very much.
On a confidential basis.
Of course. Thank you.
Certainly.
Thank you. That is unfortunately all we have time for today. Thank you very much for coming and giving us the benefit of yours and your members' experience in relation to the use of contractors in Sydney Water in particular. To the extent questions were taken on notice, which they were, or there are supplementary questions, there'll be 21 days to respond, and the committee secretariat will be in touch to discuss that. We are running a couple of minutes over, so let's come back at 11:35 after our tea break.
Thank you.
Thank
Very
you.
good, Chair.
Thank you.
Thank you.
The curry except,
It's
which is
super
true.
okay, and the food's great.
Are we okay? Yep. Okay, go ahead. I believe we are broadcasting already. So welcome back and thank you. And we welcome our next witness from T Corp. If I could please get you to please state your name and position title and then swear either the oath or the affirmation.
Thank you. David Deverell, Chief Executive of New South Wales Treasury Corporation, otherwise known as T Corp. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. Would you like to begin by making a short opening statement?
Yes, I'll make a very, very brief opening
Okay,
statement.
that'll please Mr. Fang.
So thanks for the invitation to provide evidence at the hearing. As background, T Corp is a New South Wales Government Public Finance Corporation, or PFC, that provides financial services to the government, to the New South Wales Government, and exclusively to the government. T Corp employs approximately 210 people and is governed by a board, which includes 7 independent non-executive directors, 2 senior Treasury officials, and the Chief Executive, me. T Corp provides 2 key services. Firstly, since 1983, when we were founded, we have been the central financing authority for New South Wales. We raise debt from the financial markets on behalf of the state and in turn lend these funds to the New South Wales Government and its businesses. As at 30 June 2023, our liabilities were approaching $150 billion. The second thing that we do is since 2015, we have been the state's investment manager. We manage 15 separate investment portfolios on behalf of the New South Wales Government and its agencies. These are managed within the risk and return parameters approved by the respective New South Wales Government entity owners. And as at 30 June 2023, investments under management were approximately $106 billion. T Corp is an entity that implements government policy. It does not set government policy. This is important context when considering T Corp's use of consultants under the inquiry's terms of reference. And despite our broad remit and our relatively small number of staff, T Corp does not consider itself to be a major user of consulting services. Where we do use them, we use them according to 3 criteria. Firstly, must be strategic in nature, particularly where we want to understand global trends or best practice of other jurisdictions or other industries. Secondly, it is outside our area of technical expertise or outside our industry. Or thirdly, we need an impartial opinion. And with that, that is my opening statement. Happy to provide that, but happy to take questions.
Bravo.
Thank you very much. That's fabulous. Just looking through your disclosures in your annual reports, we have lists of consultants spend over 50,000, and then we've also got the consultancies of less than 50,000. But I presume by nature of the type of organisation that you are, we don't have financial statements that set out total contractor and consulting spend that I have in front of me anyway. Are you able to tell us what for example, if we've got 2022, we had, let me check how much. We had consultants of around 420,000 all up. What was the total line item for consultants and contractors?
Thank you for the question. Yes, we do not separate that in the annual report, mainly because the contractor expend is immaterial. But I did ask my CFO before I came here what that number was for FY22. Contractors was 622,000, and that would mostly be, if not exclusively, for IT contractors, who, if we're doing an IT project, for example, and we need to have some short-term surge capacity because they've got a specific set of skills, we'll hire IT contractors. That's essentially all we use them for.
Okay. I understand. So
just on that,
Yeah,
just
go.
out of interest, Mr. Deverell, so what 620, what was that for this FY?
last
FY22.
So what would that be like when you say surge, would that be like a software project that you're looking at, or a model, developing a model or something? Or
Yeah, a good example of that is that we're currently doing a major project to upgrade our treasury management system. That's a fancy word for the computer system that allows us to manage the $150 billion of liabilities. Our current system is effectively going to be it's not going to be supported by the current vendor. So we are upgrading to a new system. In order to do that, there's a lot of IT work involved.
Yeah.
We need to bring in some short-term skill sets. Don't want to bring them on as full-time employees, but they will work for us for 6 months, 9 months, that sort of thing,
Yeah.
and then leave.
So that'd be in the time frame of 5 years or something. That would be an unusual peak, would it, for IT for contracting?
It's hard. I don't have the numbers in front of me, but generally, when people ask me about contractors,
Sounds like a big project.
It's immaterial mostly.
Yeah.
So something like the use of BlackRock Aladdin.
Yes.
Where would that sit in the financial accounts?
Okay, so give an example of BlackRock Aladdin, which we put in place about, it went live during the middle of COVID, so that was 2020, it went live. What we were doing is replacing a whole series of systems and spreadsheets and all the rest of it to bring BlackRock Aladdin in. We use contractors to help us do that particular service. The actual expenditure on BlackRock Aladdin will be going through the funds management accounts so the $106 billion of accounts, which are our clients own those accounts, that will be charged through to those particular 15 funds.
So that's really interesting. So maybe I'll come back to the IT contractors in a minute to ask questions, but I think I'm trying to get an understanding I understand that although what we have in front of us on the T Corp operational side is quite limited in terms of contractor use, when we're looking at the expenditure from those funds,
yes,
presumably you also have the sort of investment management,
funds management,
fees,
yes,
and
that's
all
right.
of that.
Yep.
And you wouldn't see that as a consultant spend.
No.
Is any of that possible? And I understand you've had, there was 3 main funds. I understand there's a sort of a one portfolio approach that T Corp is pursuing. Is any of that sort of fund management work able to be brought in-house, technically?
Yes, a really good question. I'll try and answer that to the best that I can. So when we look at the funds management side of things, the biggest decision a funds manager can make is what we call the asset allocation, the split between equities and bonds and credit and all those sorts of things. We do all of that in-house. Then the next question is, who do you get to execute that on your behalf? Which is, do you do it in-house or do you outsource? A lot of what we do, we outsource, and we outsource mainly because we don't have the specific expertise sitting here in Sydney and Australia to do some of that. So, for example, we might have a mandate with a manager to look after US bank loans, for example, which is an attractive way of generating investment returns as identified by our portfolio construction team. We would then look to see who is the best in the world for the right price to do that, and we will appoint an external fund manager for that.
Which is a clearly specialist role.
Exactly. Now, you could say, why don't you have an office in New York and London and all? It's just too expensive, and what's our competitive edge? However, there are some areas that we do it in-house. So domestic cash and fixed income, we have an in-house team that looks after approximately $15 billion of our funds under management. We do that because these people are acknowledged experts in their field, and we believe it's much more sensible from a cost-benefit point of view to have that capability sitting inside in T Corp.
And has that sort of increased capability within T Corp increased sort of over? Like, are there records, I guess, showing that over time that sort of reliance on external parties has reduced? Yeah,
it's an important aspect of bringing the 3. Because I said in 2015 there were different areas of government were all doing their own investment management. That was all centralised into T Corp, and there were 2 driving factors behind that. One, you can probably generate better investment returns doing it that way, but you can also drive a lower cost outcome. So we've been very much focused on driving costs down where possible. So 2 ways in doing that: either bringing things in-house, doing more of cash and fixed income. Some of our real assets, we are doing more of those in-house as well. But also moving to things like indexed approach to managing. So rather than paying 0.2% or 20 basis points, you're paying 1 basis point or 2 basis points. So all of that is focused on driving cost out of the system as much as we can do. But we will only do things internally if we believe that there's a competitive edge that we can develop.
Mr. Fang?
Can I just ask, yesterday when we had, I guess, other government entities here giving evidence, they indicated that, in effect, the structure around wages and, you know, the band with which people can be employed under preclude, say, someone with vast experience, I guess, joining sometimes the public service because they can earn more in private work. How does your organisation, I guess, get around that? Is there a wage structure that's different, or is it that these people would be making equivalent or similar money in the public service as they would the private sector?
Yeah, really good question. Getting around it is probably not the word I would use, but how do we get to the point where we can have a number of professionals making these big decisions on either raising debt or investing money, but doing so on the public pay scales? T Corp has an exemption from the Government Sector Employment Act, and that exemption was given to T Corp many years ago on the grounds that there was an awareness that the people that would work at T Corp would come from the private sector. So at T Corp, of our 200 or so people, the vast majority of them have come from two broad areas: banking for our financial markets business and investment management for our investment management business. Myself, I came from the private sector where I'd worked all of my life to start this job 8 years ago. So therefore, what we do is we say to our people, come to government, work for T Corp. There's a profound sense of purpose that you get here. You're not going to get paid as much as you would do in the private sector, but at the same time, we're not going to hold you to the particular pay scales within government, which are it's a very strong pyramid structure. In order to get paid a lot of money by government standards, you have to be managing vast numbers of people. In our organisation, some of my very best people don't manage anybody. They provide profound value to the government, but they don't manage anybody.
It's such a perfect counterexample to what we were hearing yesterday.
Well, I was just going to ask, I mean, and this is, I guess, the obvious question that leads out of that evidence is that given the success in relation to your model, is there perhaps a view that this could be rolled out across a number of other parts of the public service, if not, you know, on a broad scale, at least a limited scale, where there's identified pressures from the public sector, you know, not having enough people, and the private sector having these higher wages, where it could be acknowledged that there needs to be some flexibility in that banding and the scales?
Potentially, but the one thing I would caution is you need very strong governance to do this, because we are extremely aware within T Corp of what we have, which is an exemption from the Government Sector Employment Act. We are extremely careful not to be seen to be not playing by the spirit of that. And so therefore, lots of governance, lots of input from various agencies. I mentioned before we have two Treasury. We have the Secretary of Treasury and one of the Deputy Secretary of Treasury sitting on our board, whose job is to really scrutinise to make sure that we are doing that to the absolute spirit of what the intention was.
So it's not an unreasonable thing to do then. It would just require, I guess, a strengthening of the governance in relation to the setting of and employment of people in with respect to this, I guess, alternate policy as opposed to the government sector wage bands.
I would have thought so. You have to think very deeply about it, because there's unintended consequences of everything that can take place and within.
And is it the case then that because you've only got 200 or so employees within your organisation that it's perhaps a manageable size for an exemption, whereas, you know, somewhere like transport where you've got thousands, it perhaps becomes a much larger, cumbersome issue to manage?
Potentially, and there's the anonymity that goes with that as well. I know everybody at T Corp.
Yep.
So that, and then the Secretary of Treasury and the Treasurer will size me up and say, who are these people, what do they do, are they paid fairly? And so we can provide that level of granularity, if that's the right word, because there's only 200.
Can I ask, just I guess drilling down into that, you mentioned before that the existing public sector pay scale is sort of based around that kind of management function, whereas what we're seeing, where we have quite a big reliance on consultants, is when they're being brought in for this kind of expertise or specialist work. From what you're saying, T Corp obviously has a bunch of experts that have come in that it's able to pay on a competitive scale. So to Mr. Fang's point, is there, in terms of the recommendations we might make coming out of this inquiry, is there a case for looking at particular parts of the government apparatus where we have a reliance on experts sourced externally and changing the pay scale around for that, do you think?
Yes, my instinct, I'm not qualified to talk about the whole of government, but my instinct would be yes. But you need amazing governance around it, because government is so huge. We've got nearly 400,000 employees. You have to be very, very careful about that not leading to a sort of a cost blowout as a result of it. But there's a strong argument, if you want real specialists, don't if you want to pay them well, don't expect them to manage 15 people or 20 people. It's okay to have them managing nobody. Sorry.
Can I ask a related question?
Dr. Kane
Go ahead.
Sorry, Mark. I just want to ask a bit about that governance, because you've mentioned it, I think, in every answer we've given now about this potential alternative structure. And I just wondered if you could outline, you talk about cost blowouts, are there other aspects of governance that either you think work well in your circumstance or that we would need to take into account? I know we're talking hypothetical, but...
What I probably the number one governance thing that I think of is the level of Treasury oversight and awareness of what we do. By having Michael Cootstrotter probably wouldn't like me saying this because he sits on my board and he's a busy guy, but I think having someone very senior from Treasury sitting on your board and having oversight and having that sort of almost director's obligation to make sure that the right thing is done, I think cannot be understated. So that's probably one of the big things that I would speak to. We spend a lot of time within T Corp making sure that these issues that have potential to be what we call social issues, that they can cause great... it can upset people if they know that someone in T Corp is getting paid more than them, and this person doesn't manage anybody, whereas I have to manage 150 people or something. So we do go to great lengths to be sort of keep our stakeholders very aware of what we're doing and why we're doing it. That's sort of where I'm getting to in governance. It's governance, but it's a good bedside manner as well, if I could put it that way.
So it's cultural as well.
Exactly. Yeah.
Just on a related question, so you've got, obviously, in its inception, you're not going to have the internal expertise because this is something where you want market-based expertise with a broad range of investing in all manner of and raising debt on world markets. But now that you've got the expertise inside, do you have a graduate program where you bring people in and mentor them so that you can create that internal throughput?
Yeah, we don't have one ourselves, but we leverage off the Treasury graduate program, and we have found that the Treasury graduates are keen to spend a bit of time cycling through T Corp, and we've been lucky enough that a number of them have actually decided at the end of the program actually to join T Corp. Again, not because of the pay, but because of the interesting work.
But in a sense, that would be a really good way to eventually wean yourself off externals, wouldn't it? Because if they're coming through and getting mentored with the skills that the pre-existing people are there, and they're likely to be quite attracted because of the pay relative to the rest of the public sector is good, then that would be a virtuous, from the perspective of preferring that would be a virtuous cycle over time, wouldn't it?
Yeah, definitely. When we get to the example of consultants, we really as I said at the opening remarks, we're very, very, very careful, almost stingy when it comes to spending money on consultants, because we've got to manage a cost base, and unlike other government agencies where you either spend your cost budget and lose it for next year, for us, we're driving a profit and loss outcome, so we try not to spend any more money than we need to. We absolutely don't want to be repeatedly hiring the same consultant every time, and we'll always be looking to bring that capability in-house as much as we can. On things like the funds management capabilities, that's something that we've studiously done over the last 5 or so years to do more of what we call real assets, which is infrastructure and property management and buying of those assets. We previously had only about 3 or 4 people in that team, very reliant on external entities to provide services for us. We've now built that team to roughly 20 or 25, and our spend on externals has gone down considerably as a result. So, and we're bringing people at all different levels, and the best culture is the sort of the homegrown one, so we don't want to always be bringing people in at the very high levels. If you can bring them from lower down and promote them, that's very much our model.
If I could just pick up on that question in a sense, but I imagine for you to be able to make that determination, so for instance in the building acquisition area, you would have to have an investment strategy which said that was warranted. Correct. And it would take a period of time effectively to come to that point in the strategy where you actually did say, okay, this is something we're going to be doing for the next 5 years. Let's have the in-house capability, but you might be exploring with your portfolio over a period of time, let's say 2-3 years, and not sure that that's going to be the asset class you're going to invest in necessarily. And it may be advantageous at that point in time to use consultants.
Yeah, use an external
provider.
That's right.
Say,
yeah, so some are going to be your bricks and mortar part of your investment strategy. You're always going to have equities, you're always going to have bonds, you're always going to have some form of property exposure. But the example I drew before, US bank loans, that's a very attractive opportunity with the retreat of US banks out of capital markets or out of lending because of the constraints put on them by regulators, has created a wonderful opportunity for asset owners such as ourselves to get into that space. That may not be there in 5 or 10 years' time, so we will be more opportunistic in that. But the long-term allocations to those asset classes, I said before, will have us think, let's think of our implementation plan to do that over the next 5 to 10 years and bring more of that in-house if we think we've got that edge to do so.
Fantastic, thank you.
Can we come back to the BlackRock Aladdin example? So where does the expense for that sit? Is it divided between funds or?
It's through the funds. So
right, okay.
So that's the BlackRock Aladdin system. This is quite frankly, this amazing system that Larry Fink and his team have designed at BlackRock, and they now license that to asset owners around the world, including ourselves, and it's been an enormously beneficial help to us to understand the risks at every level in our portfolio and then reporting it all up centrally. It's a great tool. The expense of that is a direct expense of the funds themselves. And so you will see those expenses come through the individual fund accounts. And then
okay.
Sorry.
So were there any contractors brought into T Corp that were then paid for by those funds? Do you have contractors who are sort of not T Corp employees sitting within T Corp?
Potentially, but they'd be a very small number of people. It'd be, a few. So
Yeah,
I do remember at the time when we were doing the implementation plan, and in fact, it'd be nice to have had my CFO next to me, but when we did the implementation plan, I think some of those costs of putting it in place was actually borne by T Corp as opposed to the trust. Once the thing's up and running, that's then borne by the trusts.
Yeah,
so,
okay.
But I remembering back to that project, there would have been a very small number of people, certainly less than 5 and possibly less than 3, that were brought in as contractors to assist on that transition.
Did T Corp or anybody in New South Wales Government have the expertise to do that work in relation to BlackRock, Aladdin?
No. There's some quite specialist skill sets there. So BlackRock has got a number of clients all over the world. Future Fund uses them, Australian Super, those sorts of organisations. And so when we were doing it, we said, who's implemented BlackRock Aladdin in another client? And so we found this person who'd done it at firm XYZ or company XYZ, fantastic, we'd love to have you on board because you know BlackRock, you broadly know what we do, let's bring it all together and let's have a seamless implementation, which thankfully in that situation was. I remember we flicked the switch on, I think it was March the 23rd of 2020, which I think the day we went into lockdown, which was the ultimate test of confidence that we're able to turn it on when we were all stuck at home.
You could all use it at home then.
Yeah, exactly.
So you recruited in the skills you needed and then contracted in those that weren't able to be brought in-house. Is
That's right.
Yeah.
So the people we contracted, then we then let them go. Said, thanks, you've done a great job,
Yeah.
off you go.
And so I guess the total spend was, potentially higher than having an internal person working on it, but ultimately, once it was, you didn't have to redeploy that person within the organisation.
That's right. We have a thing called an EPMO, an Enterprise Project Management Office, which is permanently staffed by T Corp people, because there's always projects going on, and we have a finite number of people in that. But when there's a major project like BlackRock Aladdin 5 years ago, or 3 years ago, whatever it was, and this current one we've got at the moment replacing the Treasury Management System, we will bring in some surge capacity, but then we'll let them go. But the core group of portfolio managers, we want to keep them because they could be used for a variety of other projects.
It's interesting, you've got 200 employees thereabouts, but I guess you've got that flexibility because you have that team. Do you have instances where, I guess, there's a contraction and you find you've got excess people? Or has that happened a few times? Like, what's the process then? Is it like a redundancy or optional?
One of the good things about our business model, if that's the right way to put it, is that we have a relatively predictable stream of revenue. It's based upon the size of the liabilities book and the size of the funds under management. A contraction would occur if all of a sudden markets fell 50% or something like that, or the government decided to pay back $75 billion worth of debt, those sorts of things. Possible, but highly unlikely. So in terms of our budgeting cycle, out over 3 years, we can, with a reasonably degree of accuracy, forecast what our revenues are going to be and therefore what our cost base should be to support that.
So somewhat facetiously, but in a genuine way, if you've got a change of government that perhaps has a infrastructure pipeline much smaller than the previous government, you would expect, I guess, be contractions around that.
It'll be a slower rate of growth. So let's say I don't want to prejudge the budget that comes out in about 10 days' time. I haven't seen any of the numbers, but one might think that the level of borrowing that T Corp is required to do will be less than perhaps it was in under the previous government.
Well, it depends on the wages cap, really, but anyway, yes.
Yeah, it's just going to be a slower rate of growth.
Yeah.
So again, it comes back to that predictability that we can forecast our revenues, which allows us to forecast our costs, which means the ability to bring people in, hold on to them, and utilise them effectively.
And the natural attrition which occurs might actually be enough to manage that sort of contraction. Smaller growth.
Yeah, look, we're fortunate in our attrition is very small, but nevertheless, from time to time, you can.
Chair, thanks for highlighting the responsible fiscal management of the government, Wes.
Not how I describe it.
I just want to. So, in terms of the requirements for government agencies and departments to go through T Corp, is that universal? So, if someone's got to raise debt or invest, they go T Corp's the intermediary, the specialist agency that makes the decisions.
That's right.
So, do you have any oversight then on? There should, in theory, then there should be no need for consultancies in those sub-agencies or departments in that area because you guys are doing it all for them, correct?
Yeah, we do a lot of the. So yeah, good question. There's a thing called the Government Sector Finance Act, which basically says you can. Say somewhat facetiously, you can choose anybody you like as long as it's T Corp, which comes back to the cultural issue I was talking before about the bedside manner, because we have that monopoly provision of services and we don't take that lightly, and we want to treat every single client as though they could walk out tomorrow, and we give them good customer service, we hope.
That
but
includes SOX, doesn't it?
Absolutely. So, for example, so we have oversight of Sydney Water, Hunter Water, Essential Energy. A lot of the people that are coming along this afternoon, they're important clients of ours. And then what we offer them is a complete debt management service. So we will do all of that for them, which reduces greatly their requirement to think about using any form of external consultants on the debt management side of their business.
There's no provision, is there, for a minority-owned entity like Ausgrid to use TCorp, is there?
No. We work exclusively for the New South Wales Government family, as we call it, and if you are part-owned by somebody else, you're not part of the family, from our definition.
Yep.
I think my parents said the same thing.
Sorry, go ahead, Dr. Kane.
Mr. Deverell, in those, well, not quite negotiations, but in those interactions with agencies or state-owned corporations, are consultants ever engaged by the agencies or state-owned corporations to engage with you?
I don't know. It's a good question. At my level, I'm dealing more at the Chief Executive and Chief Financial Officer level. I don't know. Yeah, I'm happy to do that. Maybe the Sydney Water or the Hunter Water people could answer the question, but
sure, I'll ask them as well.
I can certainly try and find out.
Thank you.
But maybe the best place to ask is with those organisations.
Thank you.
Can I ask? So it's been a really refreshing session because I think this is our 9th day of hearings, and I think this is the first time we've spoken to a government department that seems to be using consultants where they're actually required. I've got a couple of questions though, just going back into the disclosures for consultants in the last 5 years. There's not a lot of detail on the use of a company called Towers Watson. There was about 2.3 million spent in total across 2 years. Can you tell us what that project was?
Yeah, that's good. That was FY19. I think we did 1.1 million, and FY18 we did $1.2 million for those. So that was a really, really seminal piece of work where in 2015 and 16, basically three agencies came together to do their investment management. So we had 3 different investment teams, 3 different approaches to managing money. Our view was that there was a better way of managing money, what we call the total portfolio approach, which is very much a risk-based approach rather than a return-focused approach. And so we wanted to have someone work with us to transition these 3 different approaches to a single new approach. The people at Willis Towers Watson were acknowledged global experts in that space. In fact, one of their people that worked for us ended up becoming the Chief Investment Officer at the Future Fund following that. So we used them very specifically for that particular project. Once that project was finished, we haven't used Willis Towers Watson since. But we very consciously made that choice because we were dealing with $100 billion worth of funds under management. If we could generate returns, even 0.2% better or 0.5% better, that would be worth it many multiples over.
In 2018, BAE Systems Applied Intelligence did almost $100,000 of work. What was that one for?
BAE Systems has until recently been our provider of services on cyber-related things. And so we do a cyber health check on a regular basis. That's what that's for. So we bring people in to say, these are the latest developments in cyber. What was relevant in cyber 12 months ago is no longer relevant. It's constantly evolving. So could you please give us some advice as to how we can strengthen our approach to cyber security?
Thank you. Ernst & Young did work for you in 2018 and 2019, a total of around 650,000. What was that?
Yeah, so the one in 2018 it's an important part of our remuneration approach. We have a scorecard. We call it the corporate report card, which looks at 5 different measures around client, government, operational, risk and people. Operational, financial and people. The creation of that scorecard, of which management has some self-interest in, It was the board's decision that we should get an independent expert to work with management to come up with that system, because having designed that system, it then has an impact on the way in which they assess my performance, for example. So Ernst & Young have a very good people practice, and they assisted us through that particular process.
Can I,
that was 2018. What
Yep.
was 2019?
And then 2019, we had a very, very significant what we call a culture project. So this is, you may remember at the time, we'd just had the Hayne Royal Commission. So it was all about culture. Our board wanted to make sure that T Corp's culture was not showing any of the signs that were being identified by Commissioner Hayne. And so we asked Ernst & Young to come in, or EY to come in and do a culture audit for us, which they did, which was pleasingly positive, but that was the end of that project.
So then finally, before I go to you, Mr. Fang, in last year we've got another EY for 145,000, which was corporate report card review.
Yep.
So is that going back and looking at the work they did in 18?
Exactly. Yep. So, the board wants to make sure that our corporate report card is keeping in line with contemporary practice. They could go and ask management, but there's a bit of self-interest involved in that. Getting that external perspective is how has the financial services sector evolved over the last number of years.
Okay, so that's 400,000 in total so far for this corporate card review to EY.
Yep.
Is that, just from a layperson's perspective, that seems like a lot of money.
Sure.
Is that money well worth spent? Is that a...
I honestly believe it is. And you heard me saying before, I don't like spending money on consultants because it comes directly off our bottom line. But in something as important as remuneration, getting the optics right for... Getting the reality and the optics right for everybody, and by everybody I mean our stakeholders within government, our people and our board, really important to get that right so that you're in line with contemporary practice.
Okay.
I get your point. If you're going to do it every 3 years, perhaps you could have someone internally who can provide that capability, but you'll always be looking for an external opinion on something like that.
So using a consultant in that case was about getting that market, sort of understanding what the rest of the market was doing in relation to a similar process within their own boards, correct?
Yeah, because with Hayne said you must do the following, and everybody said we'll do the following.
Yeah.
And then we were observing actually a lot of organisations didn't do the following, they did something else.
Yeah.
And so we had to make sure that where we were heading, which was generally in that direction, was then, we sort of trim the sails, so to speak, to make sure that we could go that way, because that's actually where the market was heading from an overall performance assessment point of view.
Thank you for that insight. Could I just ask, in relation to, I guess, the remuneration structure that you have at T Corp, does it then, I guess, feed into these surveys providing the opportunity for a bonus payment? Is there bonus structures within the organisation that you do pay bonuses? Is that perhaps then a way of, providing cover for that bonus payment, as opposed to using another measure which perhaps isn't requiring a consultant to sign off on? Just a baseline percentage increase up or down in relation to what the rest of the market's doing.
Sure.
Do we need a consultant to do that?
When the payment of incentive reward is a really, really, really important thing within the financial services space.
It's
a very, very rare thing. So it's very standard in financial services. It's very rare within government. We are acutely conscious of that. So, for example, for myself, and I've given evidence in front of, I think, budget estimates 18 months ago, where I was asked, what do I get paid? On the record, I get paid just a little bit over $800,000 for my base, and I have access to a 60% incentive reward. Okay, so that's the package which I've been brought into government on. In order to do that properly and faithfully, and one where it's completely above board, you need to have an excellent method for assessing that. Again, asking management to come up with that is fraught with all sorts of conflicts. So that's why you would get a consultant to give the green light to the approach that you're using, but the actual implementation of it is completely owned by the board.
So who sets, I guess, the parameters with which you judge the performance of T Corp versus the rest of the other management funds, I guess, or the market in general? I guess you're gonna choose a level with which you compare yourself to. Right. Who does that? Is it the board? So the board will do that, and it's independent of government, like independent of the minister?
Yeah. Well, no. Well, the minister has the power to provide directions to T Corp. That's written into the legislation.
Yep.
But the board makes that determination. So the board, as I said, has got 7 non-executive directors. It's got 2 representatives from Treasury. The board gets its recommendation from our People and Remuneration Committee. The People and Remuneration Committee has, I think, three directors on it, plus a representative from Treasury. And so we're very, very conscious to make sure that that group is fully across all the criteria. And I've said there are 5 criteria: customer, government, operational, financial and people.
Yep.
There's a series of very objective measures that go into each of those, and that comes out at the end of the year with a board assessed
I was impressed
outcome.
how quickly you listed those off when it was first mentioned. So obviously it's a strong focus. I guess my comparator for the way that you judge the measurement of bonus payments is my comparison with another inquiry that I was chair of in the previous parliament, which was around iCare.
Sure.
And obviously there was a lot of consternation around how that occurred. The methodology that you've adopted, has that been, I guess, provided to the rest of the government through, I guess, the ministers and the board to provide, I guess, a more robust way of determining and measuring that bonus payment structure?
A good question. I don't know is the short answer to that.
Should it be?
I don't know again. I went in my comments before about the key to the sort of things that we're talking about today are very strong governance. I'm a profound believer in the benefit that we get from having extremely senior people on Treasury sitting on our board who have direct line of sight of what we're doing, because we think that the decisions that are being made are really, really important ones, and not to be hidden from anybody. You need to be completely transparent with your board and with the senior Treasury officials. Where it goes from there, I don't know, but that's the way the governance works within T Corp. I think it's a pretty good model. I don't want to hide anything. And as I said, we are trying to balance the competing interests of people that 98% of people, 99% of people have joined T Corp from financial services sector where incentive reward payments are the norm, coming into a government environment where it's absolutely not the norm.
It's just interesting that, I guess, there's criticism if there's employment of consultants to impartially and look at the way that we structure these bonus payments in a entity with which we've acknowledged needs to compete with the private sector. That almost directly correlates with the arguments that were made around the bonus payments in iCare, because obviously we're competing for executives within that insurance space, but there seem to be a lot less governance and thought process in relation to the...
I can't speak for iCare, but one thing I will say again, the consultants are only hired to provide advice. The implementation and the ownership of it is completely owned by the board.
Interesting. Thank you.
Mr. Latham, did you have any questions?
No, I don't think there's much to see here. It's
No. Yeah, I'm just curious.
Unlike other agencies, no news is good news.
Can I ask you one more? There was talk when we had the issue, I can't remember now, a couple of years back, around the investment in Russian equities.
Yes.
And we had, I thought at the time there was talk of doing an ESG review.
Yes.
Was that done, and who did it?
Thank you for the question. Yes, it was done, and it was done very thoroughly. It was done by a woman called Prue Bennett. Prue, I've just forgotten the name of the organisation she works for, but she's an acknowledged expert in the field. That was completed. There were 21 recommendations. We are busily implementing those recommendations, and essentially the report was said, the key to ESG is a sort of a culture of continuous improvement, because ESG is evolving so rapidly. It's a bit like cyber; it's just constantly changing according to a whole range of different factors. And so the key is to have that mindset of continuous improvement. There are a series of recommendations, as I said, we're implementing them. And one of the recommendations that we did implement was around the way in which we, and by we, not just T Corp, but the entire industry, invests in some of those regimes, such as Russia, so that we're not caught in a situation like that ever again.
So the cost of that review, where would that appear? Is that
Treasury. That was Treasury done.
So it was a Treasury.
Which other regimes have you ruled out?
A range. I'm happy to talk about our country governance risk framework in due course. I don't have all the list of names right off the top of my head.
How many countries would be ruled out, like the Russians?
I think there were around about 10 or 15 that were ruled out, I seem to recall. But that's a dynamic approach as well. I mean, governments are doing good things and bad things in equal measures and changing their views on that. So it's a dynamic approach.
Decision as to what's a good country and what's a bad country?
We ultimately do during using the framework that we have.
Right, and the Minister is notified of that?
The Minister is, I'm sort of providing a little bit more evidence today than my current Minister is perhaps on top of, so maybe at this point he's been focused on the budget. I'd love to talk to you some more about this particular project. I was thinking maybe even in budget estimates.
I'm going to
Daniel, I'm sure he wouldn't mind.
I'm going to take you up on that offer, but I'm just curious now that it's been raised. What would occur in circumstances where T Corp identifies a regime or country that is hostile or unfriendly to our interests, but somebody like the Treasurer or the Premier determines that no, in fact, for a wider reason or whatever reason, that they aren't going to share that view? Where does that delineation lie?
Can I take that question on notice?
Yeah, along with Mr. Deverill, can you take on notice the list of companies that are
sure.
totalitarian and wretched?
Yep.
Labor, I can just imagine.
Well, the National Party would be on the list, wouldn't it?
We're on everyone's list. What are you talking about? Like, everyone's our enemy.
I've just asked, because I've got one final question around potential conflicts of interest, so another sort of one that we've been looking at a lot in this inquiry.
She's really got nothing out of you. She's really...
in relation to, I guess, in, the context of using other sort of fund managers or investment managers, is that the sort of the main area where conflicts of interest would sort of come up as a potential issue?
Yeah, I guess it's that is a big area. Whenever we're doing a contractual negotiation with any entity, which could be a fund manager, it could be a provider of services of any other description, we go through extensive conflict of interest declarations.
Do you tender for that work? Does it go out on a public tender, or is it a...
We would... it depends on the nature of it. We're not captured by the New South Wales procurement approach, but for a variety of reasons, but where we, as far as we possibly can, we use the approach used by the New South Wales Government as far as that's concerned. So tendering is a very, very common part of what we do once you're above certain levels.
And in terms of, I guess, the transparency in order to then hold T Corp accountable in terms of, around potential conflicts of interest and things like that, where's the record? Is there a, I guess,
Sure.
What sort of public information is there for us?
We
to
have
look
an
at?
internal declaration around all the conflicts, etc.,
Yeah.
etc. It's held by my Chief Risk Officer.
Sorry, I meant in terms of the appointments of those fund managers.
Yes.
Is there, where does that get reported? So if I wanted to find out, T Corp has entered into a contract and paid this amount here, where would I find that?
I don't know. I'd have to ask my Chief Risk Officer, but my Chief Risk Officer keeps a copy of all of the conflicts across all of the range of entities with which we deal.
Yeah. If you could come back to me just with information on exactly where
Where does it go?
yeah, where
Yeah.
where it's then appears, because maybe that's a gap that, from a transparency perspective, if we
Yeah.
could have it sort of written in annual reports or something, we can say, okay, this amount goes to this fund manager and this amount to this fund manager.
Yeah.
Just from a transparency perspective.
Exactly. I mean, we do loads of declarations, particularly at board level. Everybody knows where everybody else's children are working and all the rest of it because of future or past conflicts. Where that information goes, I don't know, but I'm happy to provide that information to you.
Okay, great. Any other questions?
No, I just want to say thank you, Mr. Deverell. Your evidence has been a very interesting counterpoint to quite a lot of the others that we've heard, so it's been really useful. Thank you.
Thank you.
Great.
Thank you.
Thank you very much. That's been very informative and somewhat heartening to not have as much,
Raising the bloke
shock
that gets
horror.
paid above the, above the
You can have that
Anyway.
and gets paid bonus.
It might sound easy, but government is hard. Let's put it that way.
So to the point, questions were, to the extent questions were taken on notice or there are supplementary questions, there'll be 21 days to respond to those. That does conclude this session. Thank you very much. We'll be taking a lunch break and we'll be back at 1:45.
Thank you.
Thank you.
Thank you.
Cool.
started? Great. Thank you. Welcome back. We are now joined by representatives from Sydney Water. If I could ask you each to please state your name and position title and then swear either an oath or an affirmation.
Okay, my name is Paul Plowman. I'm the General Manager of Asset Lifecycle at Sydney Water Corporation. And I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
My name is Denise Sharanbu. I am the General Manager of Governance and Assurance, and I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth. So help me God.
Thank you very much. And would you like to begin by making a short opening statement?
Yes, please. I'll share the opening statement with my colleague. Sydney Water appreciates the opportunity to participate and contribute to this inquiry. We'd like to take this opportunity to provide the committee with an overview of our operations and our approach to engaging consultants. Sydney Water is responsible for more than just providing people of Sydney with their water. Our operations extend to the management, operation and maintaining of wastewater, recycled water, desalinated water and some stormwater around the city. We have a very competent and capable workforce that completes this work daily. Using the New South Wales Procurement Board Directions definition of consultant, we engage consultants for a variety of reasons, including to support our organisational capabilities when they provide international and cross-sector insight and knowledge, third-party independent assurance, oversight and experience, specialist commercial and financial advice, and advisory services in areas such as economics and regulation. This is to ensure we can continue to carry out the vital work we conduct for the betterment of our customers, which is everything that we do. Sydney Water also uses professional service contractors to supplement our capable workforce to deliver our significant infrastructure, asset maintenance and renewals program. A pipeline that we forecast over the next decade to be in the order of $34 billion. I'll now hand over to Denisha.
Thank you, Paul. Sydney Water discloses its spending on consultants in accordance with our enabling legislation, the Sydney Water Act. This Act requires that we disclose in our annual report each consulting engagement costing more than $50,000, along with the project name, the cost, and the name of the consultants used. The Act also requires that we disclose in the annual report the total number of consulting engagements that cost less than $50,000, with the total value of the actual consulting costs. In the 21-22 financial year, Sydney Water's total expenditure on consultants, as published in our annual report, was about $2.1 million. This figure represents less than 1% of our total operational expenditure. Our consultant spend has been consistently at this level for many years. Where Sydney Water does use consultants, we ensure that they are selected from a competitive tender process based on scope and deliverability. When the work is being undertaken, we keep consultants accountable for the work that they're completing and also ensure that deliverables are met according to our expectations. Follow-up sessions are held with consultants to understand progress made and to resolve any issues or delays in the work. Sydney Water is not looking to increase its reliance on consultants. Sydney Water will continue to use consultants only where specialist experience is required and outside perspective is valuable. This helps ensure that we will always remain focused on our customers, allowing them to receive the best possible value for money services from Sydney Water. Thank you again for providing Sydney Water with the opportunity to appear before this committee. We look forward to taking your questions.
Thank you, and thanks for coming along to answer those questions. Can we just start with understanding a bit more about the numbers of employees you have versus consultants or contractors?
So in 2023, we have approximately 3,200.5 full-time equivalent Sydney Water employees. Mm-hmm. We don't specifically measure the numbers of professional service contractors or consultants because they're temporary in nature.
You must have a record, though.
We certainly have a record of the amount we spend, but not the numbers of people because they fluctuate.
You must have a record, though, of how many people are, have passes or are, allowed onto the premises to do work. That must be something that you could...
That is true, but it wouldn't necessarily be an accurate number that we could give. But what I can do is take something on notice and give you some approximate numbers.
Do have a dollar figure, can you give us the dollar figure and then an idea of what that would be in equivalent, full-time equivalent terms?
Yes, so if we can clarify, if we're talking about consultants, then we can give you a figure for consultants
and
then a separate figure for contractors.
That'd be great.
In terms of spend.
Yes.
So I'm happy to talk to the figure for consultant spend.
Yeah.
So as I mentioned, for FY 21-22, the consultant spend was $2.1 million.
So we have that.
Yes.
Yeah.
And for
Mr. Buttigieg doesn't seem to have it.
Well, no, he's not asking for consultants, asking for contractors.
Yep, so I can answer that.
Okay.
So last financial year, our total expenditure at Sydney Water was $2.65 billion.
2.65
billion. That's our total expenditure as a business.
Yep.
Not on consultants.
No.
No.
Absolutely clear.
I'm not specifying for you. I'm more for Mr. Buttigieg.
Order.
So of that expenditure, 100.99 million was spent on professional services spending. So it's just under 4% of
100.99.
Yep.
So 100 million on...
101 million.
Yeah.
So, okay, so of that 101 million spent on contractors, so that's actually on professional services contractors?
That's right. That's people doing engineering activities, planning, mostly technical.
Well, it could be capital works too, couldn't it?
Yeah, it is. That's all
Maintenance,
included.
Everything.
It's all included.
Yep.
Yep.
So what would be your average FTE wage? What, call it 100, 90 maybe?
Depends how good the union is. They didn't seem that
yeah,
impressive.
about that, 180 to 200.
Okay.
So that equates to about 4% of our expenditure every year.
Yeah, I'm not really interested in the percentages as a whole. We're looking at what the number of contractors are.
Well, I think
so. If you worked back from the numbers and made some very broad assumptions, which we need to understand that they are broad assumptions, our expenditure on employee costs, so that's the costs of the 3,200 staff that we have at the moment, was in the order of 560 million.
Mm-hmm.
And so if we spend about 101 million on consultants, it's about 1/6 of the workforce.
Okay, so about 1/6. That's incredibly helpful. Thank you.
Of course, I need to make sure that the committee knows that is very back of the... That is me doing calculations right now.
Obviously. If you could come back to us, though, with some further figures, it strikes me as unusual that you're not aware of sort of how many people are on Sydney Water premises who aren't employees.
Yeah, I'm personally not aware. I'm sure we are aware.
But if you just divide 100 million by 100,000 on a wage on an FTE, that's like 1,000 jobs, isn't it?
Well, what's 1/6 of 3,200?
No. My methodology was to divide the amount you spend, and obviously, includes all contractors. But let's just say hypothetically, you wanted to insource everything. That would buy you 1,000 jobs, wouldn't it? At 100,000 each.
No, it wouldn't, because
on cost?
as I said before.
So what's the FTE with on cost? You're saying 150, 200?
Let me just do some
of course.
calculations.
Yep.
I know you're going somewhere.
I'm
It's
impressed.
just
No, I was
It's
going to
about
say
500.
Yeah, about 500 a year. Yeah. Okay. Thanks.
But that moves up and down, right?
Of course.
Yep.
Yep.
And that's essentially one of the reasons why we have a percentage of our workforce being professional service contractors, so we can move and flex with the workload.
You might be able to elaborate on something that I asked the witnesses earlier. In terms of historical sort of timeline, because roughly 3,000 at the moment, direct. Do you have any historical numbers on that direct employment level going back 10, 15, 20?
I don't have 10, 15, but I did bring with me the last 5 years.
Yeah.
So in 2019, we had 2,417 direct employees, and we're now at 3,200. So I've, over the last 5 years.
You've ticked up over 5, but we don't have the 10 and the 15.
No, I don't have the 10,
okay.
but that's sort of been the trend recently.
Mr. Plowman, can I come back to, are you honestly telling me that you don't know how many contractors Sydney Water has? Is that the evidence here today?
No, I said that I would take it on notice to give you the exact number.
When I first asked you, you were at pains to point out to me that it was very difficult for Sydney Water to know because there were contractors, they weren't employees.
Sorry, I should correct the record. What I'm saying is I don't personally know, and I haven't got a briefing here that tells me the answer, and what I will do is provide that information on notice.
Has Sydney Water not sent people who would be able to answer our questions here today?
Point of order, Chair.
Yeah, I'm happy to hear the point of order.
I think that that question makes a implication against the witnesses that...
No, it's a very simple...
no, I appreciate that. I just think the procedural fairness, like the Chair should probably, restrain themselves from asking questions in a manner with which a witness might take offence.
I'm
just trying to provide some helpful...
Thank you, Mr. Fang. This would strike me as quite basic information to be briefed with prior to an inquiry that's looking into contractors, consultants, and especially given the evidence that was before us from the ASU today. Is your evidence today that you do not have a briefing, you have no information on how many contractors Sydney Water has?
I can't give you an exact number today, but what I will do is undertake to take it on notice and provide you with that exact number.
Could you
Mr.
give
Plowman,
me...
you can't give us an exact number. Can you give us any number?
Well, I would imagine that based on my conversation before, there's in the order of about 500.
Could you tell us
against 3,200?
How many contractors were working at Sydney Water during the 22 financial year?
No, I cannot.
If you look at the annual report, on page 65, we have the number of recordable injuries for millions of hours worked by different types of employees within Sydney Water.
Yep.
These are figures based on, so someone in the organisation must know how many contractors there were and how many hours they worked, and it's then calculating the number of injuries. So clearly this is something that Sydney Water has a record of in order to then prepare this in their annual report. Again, are you saying that you have not brought with you any information in relation to the numbers of hours worked by contractors in the 22 financial year?
That's an important point that you make there that I need to make sure that's clarified. So when I was talking about full-time equivalents and the numbers of staff we have, I was talking about the professional services contractors. The numbers that you've just quoted in terms of TRIFA rates and LTI rates, every contractor that we have in the organisation, from construction contractors to maintenance providers, and that is all of the hours, which are all obviously booked, and there's a statutory process where contractors tell you and declare all of those hours and all of those injuries. So that is the calculation that's been put in the annual report.
But that's what I was asking you, was how many of those contractors that we're recording the hours for in the annual report does Sydney Water have?
We would have to, well, they wouldn't be Sydney Water contractors per se in terms of the definition that you gave before around having a Sydney Water pass.
Is Sydney Water paying for them?
Yes, under a a construction contract.
Yeah, so they're
Yeah.
contractors.
So we
who are
would be able
working
to
within
provide-
Sydney Water.
Construction workers that are working for
I
a
don't
contractor.
mind what their particular job is. What I'm asking is how many contractors does Sydney Water have working for it, or working with it, or working on contract with it,
I
or
would
however
have
you want to
take on
describe it?
notice, and I would have to say that would fluctuate significantly at any given point in time, depending on what we've got in construction. So,
Okay.
if I was to provide that number, how would the committee like to see it? How many we had during a year at a point in time?
Sure, I'm happy for there to be a, even just the records from 2022 that clearly were available in order to do the analysis for the annual report.
More stuff than the current government.
Chair,
Yeah.
could I ask for some supplementary information? Could we maybe, it might make it easier if you could provide us, say over the course, we've been talking over the last 3 years, you could provide us with each of the projects, a list of all of the projects for which you have engaged outside contractors, and it might then be easier to be able to ascertain how many people
Yep.
were employed on
Yeah,
those.
sure.
So I'd like a list of what they are, who undertook them, and how many people were engaged.
Yep. I think you might be able to find most of that in the statement of corporate intent. But we'll
Are you familiar
Sorry, what
with...
would
oh,
we find
sorry,
in the
Chair.
statement of corporate intent?
all of the projects that we have.
But not the numbers of contractors.
And it would be not just the projects, but those companies engaged to
Yep.
undertake them would be there?
Yep.
Fabulous. If you could provide them, that'll be an easy one for you then.
Yep.
So, coming back to this table then that I'm looking at, because there were some statements made by representatives from the ASU earlier around the safety risks of having, such a large contractor force. We look here at this figure and it shows consistently that the rates of injuries for contractors is significantly above that for employees. Does Sydney Water see that as an ongoing problem?
The numbers are relatively good in terms of benchmark performance, but that still means that people are getting injured every single day. Oh, not every single day, obviously, because the numbers are not even
but
close
more
to that.
so if you're a contractor than if you're an employee.
That's right, and that trend is normal. And
when you
but
say
it doesn't
normal,
mean
what
to
do you
say-
mean?
You would normally expect, because our external workforce or our contractors are doing a majority of the more dangerous construction and maintenance activities that we do as a business. It doesn't mean to say that safety isn't the number one priority, whether you work for Sydney Water or you're a contractor for Sydney Water. We work constantly with our contractors to make sure that we're implementing best practice, and our reporting is very diligent in that respect. And we have a whole bunch of our own resources, Sydney Water resources, making sure that we're doing our first, second and line assurance of our contractors around their safety performance.
You've referred there to the term external workforce. Had I used that term to begin with when I asked you what the numbers or even approximate numbers of Sydney Water's external workforce is, would you be able to answer that more readily?
Not given the terms of the reference of the committee. I didn't come prepared with those exact numbers, but I will.
Were you aware that, the terms of reference very clearly are relating to the use of consultants and firms, contractors, whatever. A main part of this inquiry has been looking into the definitions used around what is and is not a consultant. There has been some media just in the last couple of days in relation to the use of contractors, consultants, however you want to call it, by government.
Yep.
Is your evidence today that you didn't come with this information because you didn't think it would be relevant?
I was looking at the discussions that had happened over the last few days in the committee, and I prepared for questions around professional services contractors, but the workforce for our construction and physical maintenance activity, which is workforces that we do not directly manage or directly engage. We have a construction contract, and they manage their workforce as they see fit to build what we have contracted them to do. So those numbers I don't know.
I understand the
Yep.
difference now,
Yep.
but in terms of the professional services consultants,
Yes,
you were
I-
prepared for that.
Yes.
How many do you have?
As I said, they fluctuate, and I've calculated there approximately 500.
You must have an idea, though, an average idea of how many professional services consultants or contractors you
I
have.
did approximately 500 based on the calculations I made here.
But you've just made those
That's right.
in
And-
real
and
time
I-
in front of us. Did you not know before?
quite impressive, I thought.
How
I must
many?
say,
But
Ms.
I
Anbu
will-
seems to
I've-
be...
I think I've put on the record that I'll provide you with the information. So
But you said you'd come today prepared to answer questions about professional services contractors, and yet you can't tell us how many professional services contractors you have.
I'll just take a point of order. And
I'll hear the point of order.
Noting that I was somewhat chastised previously for badgering the witness, I might just indicate that the witness has indicated that he will take the question on notice, and it might be helpful that we continue.
Thank you, Mr. Fang. Did any other members of the committee think I was badgering the witness? I certainly was not intending to. No.
If I could just suggest,
Please.
Madam Chair, that potentially Ms. Anbu might have some information
Thank
as well.
you.
I don't know. If
That would be great.
I don't have any additional information to add. I'd like to support my colleague in the calculation of that number based on the information that we have around professional service contractor spend. So we did come prepared with that information,
in
not
terms
on
of
the
the dollar
numbers,
figures? Yep. Okay.
not in terms of the numbers of professional service contractors, but we did come armed with the information on the amount of spend.
Thank you.
Thank you, Mr. Bauman and Ms. Anbu. I've got a question that relates quite specifically to a consultant engagement in 21-22, and it's to the 256,000 to Bowery Consulting, and the contract description is option analysis for various projects.
Yep.
Could you give a bit more information about what that is and what it might be referring to? It's quite an opaque description.
So Barry Consultant is a consultant that we use to do detailed cost estimating for capital projects, and that engagement was numerous numbers of projects that we had independent cost reviews done for, and we used that independent review to undertake options assessment of which might be the best solution to solve the problem.
Okay. Is it possible to get a bit more detail on notice of that? As I said, I'd just like to understand a bit more what
Yeah,
that
sure.
covered.
Fine.
Of the consultants that are listed, and the chair alluded to a discussion we've been having in an ongoing way in this committee about the conflation of various definitions. With the consultants, let's again take the last 3 years. Have there been consultants that have done work, engaged as consultants, who have then gone on to do work in the professional services or in any other area of contracting for Sydney Water?
Not that I'm aware of.
Not that you're aware of, so that's, you would need to check.
I don't believe that's the case.
Okay.
Yeah.
Could I ask maybe
Could you
that
give
you-
an example of what you might just talk
for
me
example,
through what you
we've seen it before where, let's take PwC as a well-known example, is contracted to do some consulting work, but then also do some project delivery work.
might- Yep.
Are there any examples that you can think of?
No, I can't think of any examples that I can think of. I would probably I would take the opportunity to explain how I would be comfortable in making that assertion, because we have fairly clear processes by which we engage consultants, and I think here is a good example. Your biggest area where you may have people moving into some of those things is in possibly your professional service contractors, as opposed to consultants that you get in, like Bowery, for example. They trade on their independence, right? So they're unlikely to move into a contracting gig, I suppose, later on. But most of our professional services contractors are under an agreement with us that wouldn't allow them to go and move and do one of those jobs. So, for example, we have a planning partnership, which is the agreement that we have with a engineering services firm, and when they do planning work for us, the output of that planning work goes through a whole bunch of rigorous internal selection processes and all of the stuff. But if we decide to invest in something and go forward with a project that came out of the planning process, that would go either two vehicles, through our major projects vehicle or through our regional delivery consortia. And our PSCs that we use for our planning work are not part of the consortia that deliver the work.
Okay.
How long have sewers had a relationship with Sydney Water? Do you know?
A very, very long time. Before me coming to Sydney Water 10 years ago.
Yeah, and the current MD was the previous CEO of Suez, correct?
Yes, up until 2015.
Yep. So he's come on board in 2015 to Sydney Water, has he?
Incorrect. He has come. He joined Sydney Water in 2019 as our managing director after tenure at SA Water.
SA Water.
Yes.
Okay. Are they privatised now?
No.
Okay. Can I ask you, are you familiar with the Treasury accounting standards, the New South Wales Treasury codes for consultants, contractors, temporary employees, capital program delivery? It's a whole range of codes. Is Sydney Water aware of those codes?
Sydney Water would be aware of those codes. I'm not personally aware of those codes. It's outside my area of expertise.
Do you know if you use those codes when you're reporting back to Treasury?
Is there a
Sorry,
suggestion
which
there,
code can you... So maybe I wouldn't know the codes. Can you explain what those codes are? And
Sure.
Then I can tell you.
there's a requirement for state government agencies and state-owned corporations to prepare financial statements in line with AASB, which is the Australian Accounting Standards Boards, and Treasury actually specify a whole list of quite specific codes. AE is the common nomenclature. AE 208020001, for example, is consultants' expenses. AE 208040001 is contractor expenses. Then there's a whole list that goes through. So I just want to know if Sydney Water is complying with that specification from Treasury. So when it goes back to Treasury, Treasury's got a like-for-like snapshot of what's going on in the contractor consultant space.
Yes, but I'm not the CFO, so I didn't do the attestation of it. But yes, we would, as a general comment, comply with everything that the Treasury would ask us to do.
Well, that being the case, then that information should be ready available for the committee because they'll all be broken down into codes. So could you provide that for us on notice?
Yes.
Thanks.
Mr. Plowman, I might just pick up on that question about Suez as well. So the ASU, of course, came in earlier and made some statements in terms of Suez and the Managing Director's former relationship with Suez, which, as you outlined, dates back 8 years. Has there been any uptick in terms of work since the Managing Director's come to Sydney Water to Suez over the time of his appointment from 2019 till now?
I don't believe so.
Can you provide any information on notice in terms of the work of Suez potentially over the last 10 years?
We can provide all of that information.
Thank you.
Can I ask, can I just ask, there's a couple of, just looking back, I've got the last 4 years from your annual reports in relation to the use of consultants, so the consultant engagement bit, and I'll direct this question to you, Ms. Anbu. We have, of the 4 years that I have in front of me, two of them appear to include discrepancies. So I'll just take you to the first one. So in 2021, we have in the usual note on consultants. So in this case, it's note 21 on, where are we? It says financial statements, page 62, or annual report, page 185. It says that the total amount paid or payable to consultants engaged by the corporation during the reporting period was 1.3 million. But then when we look at the amount that you've got in the actual consultant engagements table, we have an amount that adds up to, by my calculations, about 1.6 million. We have a similar thing in 19 and 20, financial year 20, where the figure is off by about 1.4 million between those two recordings. Are you able to explain why that is?
So I have in front of me for FY 21-22 table 21.
So I'm looking at 20 and 21. Sorry, so 21 financial year. So go back.
Yep. And so that would be table 23 of the annual report.
Yep.
And as I articulated earlier in my opening, we outline each of the engagements that are over $50,000.
Yep.
And that is listed in the table. And
Yep.
then according to our reporting obligations, we total the number of consultants that are less than $50,000
Yep.
and provide that total cost, which is listed there at about $356,000. And
Yep.
so the total of those two is 1.6 million.
That's right.
roughly.
And then if you go to note 21 on those accounts, it says 1.3 million. So it's like a $300,000 difference between those two figures.
Okay. I don't have an explanation for that.
It's
for you
also
today.
table
I'm-
16,
I'm happy
So-
to take it on notice.
So similarly, if you look at 19 and 20, sorry, financial year 2020, we have a total figure of about, so disclosed consultant engagements of about 1.3 million. And then in note 20, it says it should be 2.7 million. So again, if you could come back to us on why there's a 1.4 million discrepancy. Sorry, over to you, Ms.
Sorry, and I
Kane.
just wanted to add to that, it seemed that 2016, 2017, the same kind of thing.
Right, okay, so
just-
financial 17 as
yeah,
well.
yeah.
Just if there's another piece missing out of that that's normally disclosed somewhere else, or if you could clarify that for us,
Sure.
that would be very useful.
Thank you. Thank you, Chair. You've already undertaken to provide for us a list which you say is already available, but you've kindly said you'll provide us a list of projects for the past 3 years undertaken at Sydney Water. I wondered if I could ask you also to check with regards to either the consultants spend, the professional service contracts, or those other projects. And we've already started questioning about the Suez connection. Could you check if Mr. Giroux has any current or previous relationships with any of those providers? And let us know on notice, please.
Yep.
Thank you.
Can I?
No, you go ahead.
Are you okay?
Yep.
Yep.
Okay.
Thanks, Chair. Can I ask you? This was socialised a little bit in evidence this morning. In terms of the ability for internal workforce to put forward a competing bid for work, whether it be capital or maintenance, can you just walk us through that process and how it works? Because the evidence this morning was that whilst there is information provided, the infrastructure, so to speak, the intellectual infrastructure, if you like, to be able to make those to allow those internal employees to put together a decent, is quite sort of scant. Therefore, they feel they're at a disadvantage to be able to put in a competing bid. Can you talk us through, firstly, how thorough that process is and how often it happens, and commentary around that evidence?
I wonder if you can help me understand what a competing bid might look like, so I can answer
So-
that a bit better.
Traditionally, what would happen in these organisations, and I know because I have personal experience having been through it at Ausgrid, is that you set up this tension with the internal workforce by contracting work out, and to be quite frank, it upsets the internal employees for obvious reasons because they see their work going out the door, and in this case, allegedly to higher paid contractors. But leaving that aside, what you would normally do is give, sometimes via the industrial instrument, sometimes voluntarily, you would give the employees internally the opportunity to go, well, we think we can do that. But in order for them to do that, they're not accountants, they're not project managers, they need the wherewithal to be able. They need the wherewithal to be able to put it together. So they need the information pertaining to the project, but they also need people to help them put together an alternative proposal. Has that happened to your knowledge in Sydney Water?
So hopefully I'll answer this question if I give you a bit of context and history about what's happened in the last 5 to 10 years. So some 10 to 12 years ago, a similar process went with our mechanical and electrical maintenance activities, which were outsourced to contractors to be done before my time. And then more recently, we have actually benchmarked our internal workforce for civil maintenance activities, so people that are out in everyone's street repairing water mains, unplugging blocked sewers and things like that. And we obviously retained that workforce because it was competitive. So all of the principles that we always go by is, how do we actually deliver our services for as much value for money for our customers as it can be, and that's the frame of reference that we assess those opportunities.
Yeah, I was more, so that's in a generalised sense that presumably that's a desktop analysis of, well, we think our people can do it, so let's just keep it in. But what about where there's a proposal to contract out work? Are the internal employees given the opportunity to go, well, we think we can do it for as cheaply or as effectively or better quality or whatever it is? Is there any rigour around that, a process, a template approach to doing that, or is it just desktop analysis from management? Yep, no, that's going out.
Well, it is desktop analysis.
Right.
And we understand the input costs and all of those things to come to that conclusion.
But do you think that having employees working internally who in some cases live and breathe this stuff over a period of 40 years, and from a morale, cultural point of view, might be good to ask them if they think they can do the work and give them the opportunity to prove why they can do it as effectively and cheaply?
Well, effectively that has happened in the civil workforce.
Oh, so there is a formal process for it?
Well, it's not a formal process, but we're engaging with employees all the time, and we understand their capabilities, their the productivity that we get, and we work with them every day to have that conversation.
So do they get input into that desktop review then?
No.
Okay. Which I think is where we're...
So there is no... Okay.
Yep.
Chair, may I just pick up on Dr Kane's question, which we will take on notice, about links of our MD to consultants listed in the annual report. I feel it would be remiss if I didn't let the committee know how robust our conflict of interest and ethical decision-making guidelines are at Sydney Water. Would it be worthwhile outlining what our processes are?
Perhaps you could
Chair?
put them on notice.
Sure.
I suspect they're similar to a lot of the other guidelines, unless you've got some instances of those guidelines being enforced or monitored in any way, with any sort of real life examples of the action taken in relation to potential
We'll
conflicts of
include it in the
interest.
material to respond
Thank
to
you.
the
Thank
question
you.
on notice.
Go ahead.
I just want to ask about sort of your threshold or assessment for how you determine, which projects across any of the categories that we've been talking about, consultants, professional service or contractors. What are your thresholds? What's your process for determining that you engage external services? Well, let's start with that.
So I think the first thing is we don't seek to contract or use consultants for things that are absolutely fundamental and core to us providing services to customers. So there are critical roles around the business, both from a technical and maintaining what we would call an intelligent client, and certain governance roles, or certain roles that just shouldn't be, they're Sydney Water decision roles. They just, from a governance perspective, they need to maintain Sydney Water per se as a first consideration. The second consideration is how specialised the skills are, and whether we would need to have that resource full time. So lots of different specialist skills that if we had a person that had those skills, we wouldn't be using them all the time. So therefore, it's more efficient to get a contractor to do that work.
Can I just stop you for a supplementary question just on that, with two examples. In the use of consultants in 21-22, there are several,
Consultants or contractors?
Consultants in this case, that are about support for business case or developing business cases.
That's right. Yep.
That would seem like something that is a fairly standard business requirement.
Yeah.
And then if we're talking about, across any, again, and let's go to professional services, for example, I think you said there were 500 odd people, we were doing our rough estimates, across those. It seems to me that that's a lot of specialised people. What kind of overall analysis has Sydney Water done to look at gaps in skills and capabilities, and is there a sort of a live plan for not having to fill those gaps?
Yeah, so in my opening statement I mentioned a forecast of $34 billion of investment over the next 10 years, so that does open up the opportunity to think about the capabilities and type of workforce we will need to manage a volume of investment like that. So we are undertaking a strategic workforce plan at the moment, which would go through some of the criteria that I've just talked about. The example you gave about business case is an interesting one. At the moment, we have about somewhere between 1,500 and 2,000 projects. All of them have a business case. So you're correct to say that is part of our core capabilities, to be able to make an investment case and decide how we're going to deliver something. It's 100% correct. Where it gets interesting and where we have engaged specific expertise is to help us with economic assessment, and also going through the requirements that government has for very, very large investments that we've got. And that comes into the category of, would we need someone, because we don't do those business cases all the time, we need to leverage the specialist expertise of some of the consultants that have been mentioned there.
It's just that we
wouldn't do that type of business case all the time.
Yeah, it's just that you seem to already have included that differentiation in. So there are some who are associated with economic advice, economic modelling, scenario modelling, and those that are business case support or development. So you seem to already have differentiated those, but still have some left over, which just seem to be business case. Is that just that they've been mislabelled?
So there are some people that are doing economic analysis, which is quite technical, and there's other people that we've used to help us write the business case.
Could I ask then that for those two that I could see for the last year on business case development, 9 Squared and Sense Strategy, that we might get the project scope for them as well as the Bowery on notice? Thank you.
Can I, would you have a list of capital projects and maintenance projects since Mr. Chareau's been at the helm?
The relevance?
2019, I think it was, you said, came on board.
Sure.
So
Is there a broader question that I can help you answer with that?
Well, no, simply the list of capital works projects commenced since 2019.
I'm struggling to understand how that fits into the terms of reference.
Is there a point of order?
Point of order?
I'll hear the point of order.
Oh, thank you, Chair. I'm struggling to understand how that fits into the terms of reference.
We're
Well-
wanting to know what the projects are. We're talking about the crossover between, sorry, to the point of order, Wes.
Yes.
We're wanting to get a sense of the overall allocation of projects across these three areas, because in our experience so far, and it hasn't been proven otherwise today, there is some conflation of those different categories, and we have already asked for a list of projects for the last 3 years, so I suspect that there
It
is
does
a
appear, sorry, on the point of order, I will rule, it does appear relevant to the list of consultant engagements we have in front of us. So on that basis, I'll rule it in order.
Well, just the only point I would make is that in putting the question, Mr. Buttigieg may well have actually been better off or better served by indicating a date range as opposed to projects under
Well,
a
2019 is a date, Einstein.
Yeah, he did. All right.
Oh,
Order.
Thank you for acknowledging my
Mr.
superior
Primrose.
intellect. But
Please ask your question,
I
Mr.
think
Primrose.
suggest that it's probably
my
not
question
appropriate.
is simply this. I've been quietly sitting here listening to all the information you've provided, and I note that there are a number of things you've taken on notice. I was wondering if you'd just be able to also on notice give us a list of the senior executive and the various positions they have within Sydney Water, in case the committee may decide, for example, that it wishes to call back people. I mean, we need to identify who will actually be able to answer some of the and provide some of the information that you haven't been able to do. Now, I know you've taken things on notice, but it makes it very difficult for us to engage in any sort of, cross-examination in relation to gaining the information that we're seeking that's pertinent to this inquiry,
Well,
if
Chair,
you're unable to deliver it.
I'm
So
gonna take a
my
point-
simple request is if you could please on notice just provide us with that list of senior people within the organisation, so if we choose to continue this, we might be able to call those people back.
Well, Chair, I'll take a point of order on that question as
Here's
well.
a point of order.
Thank you. In relation to that, that list, I guess, the minute that it's produced is automatically dated in relation to the relevancy of those positions. I think that...
Thank you. In relation, just in the interest
I
of time.
haven't finished my point of order, that is that at the time with which we then decide we may or may not wish to recall witnesses, that is when we should be seeking to identify
If you could let me now rule on the point of order, I'm sure that the witnesses are capable of returning the position names rather than the names of the people in those positions in order to address that concern. If we could, just in the time we have left available, which isn't very much, and understand if you need to take this on notice, I noticed that there's a lot of consultant spend on Aboriginal cultural heritage and heritage assessments.
Yep.
And I also understand that the organisations listed as having performed those services are not necessarily, or don't appear to be, First Nations led or, sort of staffed with First Nations identifying people. Are you able to tell us on what basis those consultants are selected for that type of work?
Yeah, we have a panel of consultants that would undertake the field work, but of course they would follow the legislation that we've got.
And how was the panel selected?
Competitive tender process.
And as part of that, was there consideration given as to whether or not these people had First Nations expertise?
Yes.
But you still managed to hire people that don't have any First Nations experience?
I'm not sure that's the case, is it?
I'm talking about companies that are not Aboriginal-led or owned, where work is being undertaken in relation to Aboriginal cultural heritage by people who don't have Aboriginal heritage. Is it a criteria to get onto that panel that you have that sort of experience?
I'd have to take that specific question on notice, having a look at whatever the selection criteria at that time was, because I wasn't part of that process.
Thank you. That would be very useful.
Yeah.
Thank you. Unfortunately, that is all we have time for. Thank you very much for attending and answering our questions. Any questions on notice and supplementary questions, you'll have 21 days to respond, and the Committee Secretariat will be in touch. But thank you very much for your time.
Thank you.
Thank you.
Thank you.
And then to be back through. Fully set it up.
Feel better too.
Okay. I now welcome our next witnesses from Hunter Water. If I could ask you each to please state your name and position title and then swear either an oath or an affirmation.
Good afternoon. I'm Darren Cleary. I'm the Managing Director at Hunter Water. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
And thank you. I'm Jennifer Hayes. I'm the Executive of Finance and Business Performance, which is also the CFO of the corporation. And I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you. And would you like to commence by making a short opening statement?
Yes, thank you, Chair. Good afternoon, and thank you to the committee for requesting Hunter Water participate in this hearing. Briefly and by way of background, Hunter Water is a 130-year-old entity. We have expanded considerably since 1892, enabling the growth of our region to more than 620,000 people through the provision of high-quality water, wastewater and some stormwater services. Hunter Water was corporatised in the early 1990s as New South Wales' first state-owned corporation. We're governed in accordance with the Hunter Water Act 1991 and the State-Owned Corporations Act. Hunter Water state ownership was recently enshrined, as you'd be well aware, in the New South Wales Constitution via the first bill of this term of Parliament. Under the State-Owned Corporations Act, Hunter Water is required to operate as a successful business that operates at least efficiently as any comparable business and maximises the net worth of the state's assets. We have an independent board of directors which sets our strategy, ensures we meet our regulatory commitments and oversees our governance, including via our Audit Risk Committee. We are audited annually by the Auditor General. As a commercial entity, we pay tax, dividends and commercial financing fee to New South Wales Government. We are self-funded, with our customers funding our activities through their water bills. As a monopoly service provider, we are regulated principally by the Independent Pricing and Regulatory Tribunal, IPART. IPART recommends our operating licence to the New South Wales Government, undertakes an annual audit of our performance against that licence, and determines our prices in 4 to 5 yearly blocks known as a price path. We are currently preparing for our next price path, which will commence from the 1st of July 2025. This preparation involves significant customer and community engagement and planning works to ensure our services deliver on the expectations of our customers. As our pricing regulator, one of IPART's core functions is to ensure that our business operates prudently and efficiently. IPART undertakes an expenditure review of Hunter Water during each regulatory period to ensure that Hunter Water's customers pay no more than the efficient cost of the services they receive. During our current regulatory period, IPART has applied a 0.8% efficiency requirement on our business, which we support. This compounds to a saving of $7.5 million for Hunter Water customers. I understand from earlier hearings that there has been some commentary regarding state-owned corporations seeking exemptions from some reporting requirements. I wish to assure the committee that Hunter Water has not sought such an exemption and publishes consultancy expenditure as part of our annual report, tabled in Parliament and available on our website. For consistency in reporting, we apply the definition of consultant as outlined by the New South Wales Procurement Board. Hunter Water is a complex business that requires the specialist advice of consultants to inform key decisions and support operations. Recently, this has included consultants required to support our 15-yearly major safety review at Chichester Dam, assistance in improving cybersecurity of our business, and improving our customer experience outcomes. Across each consultancy, Hunter Water acts as an informed client, utilising our internal expertise to ensure engagements deliver value for our organisation and for our customers. This is reinforced by our procurement policies and practices. Our consultant expenditure has remained stable since 2012-13 financial year, averaging $3.95 million per annum, equating to approximately 1.3% of operating expenditure over that period. We welcome any questions you may have.
Thank you very much. And can I start by thanking you on for two different reasons. One is having the Managing Director and the CFO attend. I'm sure you'll be able to answer our questions, so thank you for taking the time out at that senior level. And secondly, to thank you for taking, for not having sought those exemptions and for providing annual reports that do have a level of detail around your use of consultants already. One issue, though, I'd like to bring up with you is under the tables, at least for the last 3 years, under consultancies, under the heading consultant, when we get to then project level, on at least one occasion in every year, you've written various consultancy services, which is not particularly useful. We already know that they're consultants sitting under a consultancy's table. For example, GHD was the largest consultancy spend in 2020 at 1.6 million, and it just says various consultancy services. What can you tell me about that?
Certainly, can take on notice to provide a more detailed breakdown. The reason that it is aggregated is, and it goes to this issue which was raised in the previous questioning, and I'm not trying to be difficult, but the definition between professional service and consulting. So GHT is a major service provider for Hunter Water, providing services across a range of activities, including professional services, things that we would identify as professional services, for example, design services, through to advisory services such as our dam safety work and providing expert advice on dam safety risk assessments. So the aggregation is because it's across a range of services, and in some cases it could be one engagement that covers both consulting services and professional services. I don't have the specifics, so I'll take on notice and we can provide a more detailed breakdown.
That would be very useful. And just if you could explain to us then, would that be under one contract that you have with GHD?
No, it's unlikely to be under one contract with GHD.
Okay.
We'd have a number of different engagements with GHD.
Okay, so you've aggregated them all together rather than having them split out.
That's right.
Okay. Are you able to tell us how many professional services contractors you have working at Hunter Water?
So in terms of the number of people, the answer is no. I don't have that information readily available. And the reason being is, frankly, we don't track it. Now, to the earlier questionings, obviously we track who comes into our building. But if we're talking about a professional service contract, many of the people, for example, working on a design for us, they don't come to our building. And it goes up and down, fluctuates. So I'm not trying to be difficult, but in terms of the actual number of people on any one time that are working for us, it's not a number that we actually do specifically track. So what we could do is get the total expenditure, and of course we can come up with an estimate based upon an averaging of a salary, so we can provide that information. But we don't track the numbers of people for that reason.
So, and that's very interesting, so that's useful, because I think we're talking at cross purposes then. What we're interested in here is the numbers of people who are basically sitting within Hunter Water next to employees who would otherwise look and smell like employees. I don't know what employees smell like, who would otherwise appear to be an employee, but actually because, of the specialty that they're providing or some other reason, they're technically on a contract.
That's fine. So what I can do, and we will have to come back with some specifics. So we do have a number of arrangements where we do have those sorts of arrangements in place. So, for example, in our capital delivery part of the business, we have an engagement with WSP. So they supplement our capital delivery team. So project managers, inspectors, some technical advice. We have an internal team that manages our the capital delivery works, and WSP supplement that workforce, and they sit alongside our people. So I apologise, I didn't bring the numbers. We have Veolia operate and maintain our wastewater and water treatment facilities. So they have a substantial workforce, and they provide that core function to us. They have for the last 9 years, and we're about to go to market to renew that contract. Again, I apologise, I don't have the specific numbers.
That's okay.
But we absolutely have those arrangements in place.
Yeah, and I think then we understand the problem I was having with the last witness, because it would seem relatively clear that, for example, if you're hiring PAWC to do something and they all sit somewhere else at PAWC doing their work, I don't expect you to know how many of them are doing the work that you've asked for and that they're contracted to do for you. But if you've got people sitting within Hunter Water who are providing services alongside employees, I would expect you to know how many there were. Not off the top of your head, appreciate that. But yes, if you could come back to us with that would be very useful.
Will do, yes.
Just picking up, so that example you gave, Veolia, 9 years, managing the wastewater treatment. Why is it that you outsource something like that? What's the benefits for Hunter Water in doing so and not doing that in-house? Do you not have the capabilities? What's the rationale?
At the time that decision was made, we had a... sorry, I will start it again. At the rationale at the time, and of course these are all about a point in time and where the business is at. At that point in time, we had the operations of our treatment facilities were run by a subsidiary business of Hunter Water Corp, which we've since sold, and we were maintaining those assets. And it was clear that we needed to increase the overall capability of the business, so we weren't providing the level of service that was required. We had some compliance issues, and we had some safety issues, and we were spreading our workforce very thin across our maintenance workforce across both areas of maintaining our network assets and our treatment assets. And we did a strategic review around how do we best deliver that service efficiently. And at that point in time, the decision was made that certainly the capability we had was very strong in the network part of our business. We were doing that very efficiently. In the treatment part of the business, our internal workforce wasn't performing particularly efficiently, and there was certainly external expertise operating across the country and internationally that we thought could bring that expertise to bear and provide value to our customers, and we think the outcome of that contract demonstrates that that's the case. So we did get significant cost savings from that contract, operational cost savings, and the performance, the safety performance importantly, and the compliance performance of those facilities has improved over the source of that contract. So that's a point in time. So it's not a philosophical perspective, it's really an assessment of where is the workforce at, what's the service we have to deliver for our customers, and how do we best meet that service.
So it's a fairly pragmatic decision in that regard. You've seen that that's had benefits, but you haven't taken a path where you've sought to now insource that or thought about what's the trajectory to come back to operating that sort of operation of your business yourselves.
No, we haven't sought to insource that arrangement. As I said, we are in the process of going through a market process to re-engage that contract. And again, we see that the expertise and the potential value that can be added, particularly in the era of big data. These assets are our most expensive assets to operate. They're also where we spend the majority of our capital expenditure. So getting that view in to our organisation to help us make better decisions we see as a potential benefit, and to continue that very high level of performance. Us insourcing that arrangement, we'd miss out on that, or it'd be harder to engage that potential in a truly incentivised way of sharing the benefit, and it would create a significant challenge for the business to do that as efficiently as those businesses that have those systems developed over decades.
Thank you.
Can I ask, you mentioned before WSP, I think it was?
That's correct, yes.
Providing some of those services where people are actually sitting within Hunter Water. How are they differentiated from employees, if they are at all? Like from, in terms of, if I was an employee of Hunter Water, would I know that who else within the organisation was a direct employee and who was a contractor?
So obviously, from an employment perspective, there's a very clear differentiation.
Yes.
But in terms of within the office, there is no deliberately. We are not trying to differentiate people. We're trying to form one team. Does everybody know? Of course they do. They know all of the employees know who's employed by them, and but deliberately, culturally, we're trying to build them as part of the team delivering the capital works expenditure.
How long is the average kind of contractor there for? Like someone from WSP, how long would they be within Hunter Water?
They tend to, we do have some people that have been there for the duration of the contract, but it does tend to be that part of the workforce does tend to have a higher turnover. That's part of the advantage of the arrangement and the relationship.
Yeah. So what's that sort of length of the contract? What was that then?
So it was an 8-year contract,
Right, okay.
and we've just extended.
The second term of that contract.
So, okay. So if I'm from WSP or wherever, and I'm sitting within Hunter Water for 8 years, and there's no real differentiation between me and an employee of Hunter Water, then presumably I'm getting the information that everyone else is getting, and there's nothing in place to stop somebody contracted from another entity to use that, sort of take that information back and then use it to get further work from Hunter Water, for instance?
So there is. So under the terms of the contract, WSP can only provide those project management services. So we've made it contractually bound that they can't then go and compete, so for example, for design services or work either for us directly or for one of our contractors. So that's part of the terms of the contract. We're very clearly that would present a conflict of interest.
Yeah.
And so the terms of the contract prohibit that work from
Okay,
occurring.
but when it came to the renewal, you had a bunch of people who were already there and had the experience of 8 years or whatever working within Hunter Water. Did that then make it pretty hard to get somebody else to fill that role? Do you think it was?
So in terms of we've extended the
Okay.
contract. So in terms of going back out to the market,
Yeah.
And whether we will get a competitive offer, that I'm confident that we will, and we haven't made a decision. Sorry, I should go back a step. We haven't made the strategic decision yet about how we continue to procure those services. Indeed, whether we in-house. The reason that we outsourced that function in the first place was about managing peaks and troughs in capability. So Capital Works is, and particularly at the scale of organisation we are, we can have large projects come in and have a big impact on our workforce, and then once they're complete, we have a trough. So we're using WSP to help manage that peak and trough in workload. So we haven't made a decision yet about the future, how we provide that capability in the organisation, whether we renew that, whether we recontract that service, or whether we seek to do it back in-house. That's a decision yet to be made.
Are those people? Are you saying that? So some of them have been there 8 years, but
most haven't. So we have turnover in that workforce, and we
Yeah.
have people that come just for one project. We have people that leave. As I said, they're being used to help manage the peaks
sometimes
in
there's more
workloads.
of them.
Are they with labour hire companies?
No, they're not with labour hire companies.
Haven't got any labour hire?
No, they're not labour hire. And the advantage of that arrangement in trying to manage those peaks and troughs is that they do have somebody that is employing them that deploys them on other work. And we also get the benefit of that.
They're from a consulting firm.
A consulting firm or a contracting firm. So WSP provides that service to multiple clients.
So can I just to clarify a bit further. It's just the concept of peak and trough. That seems like quite a long wave, an 8 year. So are you saying that that's not the case, that actually within that there's peaks and, because didn't you say the contract was for 8 years?
Oh, it is. So they're helping to manage peaks and troughs, but but absolutely we have people that are in the organisation all of the time. With any, obviously with any professional service organisation, the ability to go and call on people when you need them depends upon how committed they are to your organisation. And if we are not giving them, if they're not working for us at all, they have no knowledge of us or our systems or how we work or even certainty of getting work, and then we say to them, in 3 months' time, we've got a big tender going out, we need a project manager, particularly in the current market, the likelihood of getting somebody is very small. So the way that we've structured the arrangement is by saying we'll have a baseload of work that you help us to deliver. You'll be embedded in our team. We are managing it. We are the decision makers. They work for our managers, but they supplement our team. And then when we need specialist advice or we have a peak in workload that we need to fulfil, they're much more capable of providing.
What workload is what? Infrastructure failure? You can't predict when pipes bust, can you?
You can't predict when pipes bust, but it's also the time of getting things to market. When contractors building work, so jobs run late, for example, wet weather. We've had a lot of wet weather. We've had a lot of delays in construction contracts.
I'm struggling with this concept. So you've got peaks and troughs. I understand that, but you've got a workforce, and you've got these people on the drip just in case there's a peak in demand for work, but they're there for 8 years. You're either going to bring them on to answer a peak or not. You can't have your cake and eat it too, can you? You can't have them on the books.
What I'm saying is that the workload is variable. It goes up and down. And we get multiple benefits. The workload so over an 8 year period, our workload absolutely goes up and down. As you can see.
But when it goes down, that means you've got people on the books doing nothing.
No, when it goes down, we say to WSP, these people, so this project's going to finish in 3 months' time, or 6 months' time, we'd have it, and so we won't need this person anymore. So WSP, so the advantage of the arrangement is those WSP does the planning and they go, well, we can use this person somewhere else in their organisation, working in mining or the other sectors that they service. They're not simply working for Hunter Water. So frankly, from our perspective, we see it as actually a very efficient way of providing that resource and doing it in a way that is actually quite respectful of the people who are working for us, because if you do it via labour hire, for example...
So in other words, what's the acronym again?
WSP. Company.
They just vary their charging to you based on how many employees you need, yeah?
The total fee depends upon... That's right.
Yeah.
The rates are agreed as part of the contract, but that's correct.
Isn't there another way to address a peak that... I mean, I don't know what the relative rates are and the on-costs and everything, but... often organisations like yours will use overtime to address that with internal labour?
And we do use some overtime, but that's not sustainable. When you've got a large peak in workload, you have well-being issues. People can't consistently work long rates of overtime.
Well, but you'd have, being a SOC, you'd have fatigue management policies in place, wouldn't you?
It's not just about fatigue management. Indeed you do. So look, I mean, my view is very strongly overtime is not a sufficient tool, and this is a clear strategic decision we have made, and again I stand by it. It is an effective way of delivering the Capital Works program, and happy to demonstrate, provide the information to show this arrangement is delivering value for money. It provides a number of benefits. It's about managing peaks and troughs. It also provides our project managers with exposure to project management practices across a range of sectors in a quite an effective way. So you're working with project managers who've come and worked off mining or worked in electricity, and so you've got that cross-fertilisation. It also allows us to, at times, access expertise from some of the other sectors that consulting service has that isn't as easy to access. So we see a number of benefits to it, and we think it's a key part of us being an informed client. Having these integrated teams, I think, is a very effective way of making sure that we're providing good professional development for our people and being an informed client by getting that cross.
If you did everything with permanent full-time staff, what would it add to your cost structure? Estimate.
An extra $11 million a year.
11 million, and that's passed on to
customers. Yes. That's exactly right. So, and as I said, I think it's got professional development opportunities.
Flexibility saves money.
Correct. And it does so in a way...
It's important for, this cost of living issue as well.
Indeed. And it does so in a way that is respectful of the people who are working for us, because they have somewhere to go back to.
Yeah. Can I just clarify? On evidence this morning, we heard that some of the contractors at Sydney Water are actually getting paid a lot more than the internals. Is that similar for Hunter Water?
Look, there would be
how do these companies, if they're paying contractors more than internals and they're charging you, how do they make a profit unless it's more? I don't understand the. The hourly rate obviously would be higher because they've got to recover their costs and make a profit. And some of these contractors, yes, would be getting paid more than our people, but they're under different employment arrangements and they're working for a different business. So some of them are. I'd like to see the spreadsheet, but anyway.
Of course, and of course, the advantage of the WSP arrangement is that, like I said, if we don't need the workers, if something happens, they go back to WSP. So
can I just clarify though? Yeah. So we have a variable number of employees under this contract. I understand that, but over the length of the contract, what's the minimum number of WSP contractors who have sat within Hunter Water that whole time?
I'd have to come back to the exact number who've been there the whole time. I'd have to take that.
But it's not zero.
No, it's not zero. Absolutely.
No. So there is a number of them that have been there the entire time. So some of them are peak and trough, but then they're, I understand that's for the excess, but there is still a minimum number who have been sitting there the entire time.
Well, there's a minimum number of roles. In some of those cases, we've had turnover in those roles, as we do have turnover in our own business. But in terms of the number of roles that have been there for the entire time of the contract, I'd have to take that on notice, but we can provide that information.
Thank you.
Madam Chair, if I can add, importantly, I think this is about infrastructure. This is about building infrastructure. So we use WSP to help us deliver infrastructure. So at times we have new plants that we're building, at times we are doing plant upgrades, and at times we don't. So they have also had turnover within their business, and they will upscale and downscale within their own organisation to meet the needs of our contractor and infrastructure delivery.
I guess the concern here is that we're not using contractors where we could otherwise be using employees, and I absolutely understand what you're saying about sometimes there's a peak and you need to get more people on, But to the extent that under this contract we have people who are, similar to what we heard yesterday, working for, year after year within an organisation where otherwise perhaps that could be an employee, that's something that we're very interested in. So if you could maybe just come back on notice.
We will.
Yeah, I understand. We can provide that information on WSP.
So at a bottom line level, if you're confident that if you were to try and conduct the same exercise on overtime rates with internal staff within the fatigue management, it just wouldn't be sustainable.
No, that's correct.
Based on a financial analysis.
Also
Based
on
upon a
wellbeing.
wellbeing analysis.
No, I said within the fatigue management policy, because you have fatigue management for a reason, right? Presumably, if you have parameters around, I don't know, what is it, Sydney Water, 56 hours a week? That's there for a reason. You don't exceed 56 hours, you're okay. I mean, how many hours do you work a week, Mr. Cleary?
How many hours do I work a week? So,
Are you responsive to the fatigue management policy?
Well,
As management? No, you wouldn't be, would you?
yeah.
well, we are from the perspective. I mean, technically, the key thing about fatigue management, yes, we are to an extent, but obviously the hazard that in terms of the fatigue management policy, we don't operate heavy machinery or get in hazardous situations. So
But you drive a car home. Can I ask
no,
you?
exactly. So to that point, we are from that perspective. To your point, that's where we are. Absolutely.
Can I ask you about this? I'm not sure if you heard my question about the Treasury Standard Accounting Codes, and I think in your opening statement you indicated that you comply with all of those. Is that how you report back to?
I'll pass over to Jennifer.
Yes, we do. So I am absolutely familiar with the financial reporting codes.
You're doing better than Sydney Water.
TPG 2303 in terms of the definitions around consultants and contractors and employees. So our accounts, are prepared in accordance with those. As part of my CFO attestation, I attest to that and the controls around that. And our accounts are audited. So
if we were to ask you for a breakdown based on codes, you'd be able to give that to us on notice?
There are a lot of codes,
Yeah.
but in terms of that reporting code specifically around consultants and contractors, yes.
Okay.
TPG
thanks.
2303.
Can I just ask you out of interest, you mentioned in the opening statement, so what are you paying back to government now? You're paying presumably a dividend and then tax equivalents?
And a government guarantee fee, correct.
And
a government guarantee fee. So that is
Equivalent interest on our debt. So
okay.
to be commercially competitive, so we borrow through T Corp, so New South Wales Treasury Corporation, and we pay like an equivalence of what a commercial entity would pay in a government guarantee fee, which for us is about $20-ish million per year.
so that's the principles of competitive neutrality.
Yes. So 20 million on interest to T Corp. What about tax equivalents?
Yeah, so it's about 16 to 17 million per year.
And dividends?
Last year was $27 million.
Okay, thanks. That's very helpful. Thanks.
Can I ask, just back on WSP quickly, does WSP give advice to any of your, contracting partners, anyone that you contract with?
So, as I stated previously, under our contractual agreement with WSP, they are not to provide advice to any of the parties that work for us with respect to Hunter Water projects. So they are not to provide any of that information that they gain and then work on or provide any of that information to contractors or work for those contractors on Hunter Water projects.
Okay, and that's just a blanket. They're not allowed to do that. Okay.
So just to clarify, they may work for those contractors on other clients' work, but not on Hunter Water projects.
Okay. Is it, I guess it's still possible that they could, not that they would, but they could. I'm just thinking about the PwC example. If when we're looking at, potential misuse of information and the way it can then be used by contractors or consultants to get more work or to, sort of impress their own clients, is there a potential for information to be taken from Hunter Water and used by WSP for the benefit of clients that, although that client's gone somewhere else for the particular tender to work for Hunter Water, is still a client of WSP?
I would say that we certainly have obviously no evidence of that, and I would say the likelihood of that would be very remote because we are still managing those bids coming back in. The information is very specific to Hunter Water and our designs and our jobs. And if there was a, it would be hard to contemplate how they would be providing that without it then becoming noticeable through the tender assessment and the review process that we have with those clients. So it would be corruption on a fairly grand scale.
If there was, under that contract, if Hunter Water was to let WSP go and get somebody else into that role, would that contract continue to apply? Would there be anything stopping them using the information they'd gained at Hunter Water after the contract had ended?
So the obligations. So there's the obligations for the time, for the information that they gained while they were working with us, which would continue to apply, post that.
I understand
that
they've got
engagement.
general confidentiality obligations, etc. But in
there's
terms of the
there's a legal
contractual-
obligation that goes post that, and obviously it's project specific and related. So with time, that risk diminishes as the projects are completed. But there is still a legal obligation for them to keep that information, as you said, confidential.
Under the contract?
Under the contract, yeah.
Okay. Thank you.
That was going to be my question, what's the implementation mechanism? So it's a contractual, it's not a policy. It is a policy, but it's expressed through your contract.
It's a contractual obligation, yeah.
Okay. Is there any further questions? No? It's the post-lunchtime slump, I think, over here. Thank you very
yourself,
much.
Chair.
Oh, I will. Thank you very much for your attendance.
$11 million.
In relation to questions
A lot of money.
taken on notice and supplementary questions, you'll have 21 days to respond. But that does conclude this
Cost of living
part of
crisis.
our hearing. We will take a short
pay more for your
afternoon
water.
tea break and we'll be back at 3:30.
Thank you.
Thank you very much. Thank you, Rebecca. That was very good.
Here they are.
Yeah. I know.
Great, welcome back. I will now welcome our next panel of witnesses, our final for the day. If I could ask each of you to please state your name, position, title, and then either swear the oath or the affirmation, noting that Mr. Smith, you don't need to because you've already previously been sworn in for this inquiry. Thank you.
Okay. James Hay, Chief Executive of the Energy Corporation of New South Wales. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you.
Andrew Lewis. I'm Acting Deputy Secretary of the Office of Energy and Climate Change in New South Wales Treasury. I solemnly, sincerely and truly declare and affirm that the evidence about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. And would you like to begin by making a short opening statement?
Yeah, I do have one, if that's all
Please,
right,
go
Chair.
ahead.
Thank you for the opportunity to appear before this committee today. Despite being legislated for in 1987, Energy Co, or Energy Corporation New South Wales, is actually a new and different entity within the New South Wales Government and national electricity market structures. It operates within a complex regulatory and funding arrangements. This context is important for this inquiry, so with your forbearance, I'll just give you a little bit of background on that.
Please.
Energy Co is legally a statutory authority. It was created under the Energy and Utilities Administration Act 1987. It was set up, broadly speaking, to investigate, plan, coordinate and promote energy infrastructure development in New South Wales and advise the government of the day on those. One of its particular factors is it has the power to acquire land. Energy Co lay dormant until the Electricity Infrastructure Investment Act 2020. Had one property in Lightning Ridge for no apparent reason. It was re-established to support implementation and delivery of the New South Wales Electricity Infrastructure Roadmap under the Electricity Infrastructure Investment Act 2020. Under that Act, the primary role for Energy Co is as infrastructure planner for the 5 renewable energy zones and currently 2 priority transmission projects. Those are the Waratah Super Battery and the Hunter Transmission Project. Under Section 63 of the Electricity Infrastructure Investment Act, the infrastructure planner is responsible for investigating, planning and coordinating investment in generation, storage and network infrastructure in each renewable energy zone. It's also responsible for designing, implementing and operating network access schemes. These are the rules by which generators can connect to the new networks, and community engagement and benefit programs. Energy Co, along with other roadmap entities, is tasked with delivering the objectives under the Electricity Infrastructure Investment Act, particularly the 12 gigawatts of renewable energy by 2030 and the 2 gigawatts of long duration storage by the same date. But the overall objectives are for a clean, reliable and affordable electricity in New South Wales, as well as ensuring social and economic benefits to the host communities. As infrastructure planner, those 3 core functions. We plan, procure the delivery, funding and operation of the major network infrastructure projects. We design, manage network access schemes for generators to access that network so they can get connected fast and stay connected, which has been a major issue in the national electricity market. We coordinate local community and employment engagement and benefit programs to support joined-up delivery of this major infrastructure and the delivery of benefits for those communities. Our projects are funded by the New South Wales electricity consumers under a closely regulated set of processes, overseen by 3 independent regulators and the Australian Energy Market Operator. Our funding reflects this and is not the same as other New South Wales infrastructure delivery entities. The direct development and construction costs of Energy Co's current program of Deliver Now network projects is estimated in our network infrastructure strategy, which we published in May, at just under $9 billion. That's the direct building costs and the cost of getting to the point of building. This excludes finance, generator connection assets, system strength costs, that's a part of the network that keeps the quality of the network running, and it's presented in that way so it's comparable to the numbers that are used in the national electricity market. Those latter costs would typically, the extra cost on top would add another 70 to 100% of the costs, because those are the cost of connecting the generators and the cost of providing quality in the electricity system. In addition to that, we have the $900 million Waratah Super Battery project. That's on time and on cost and due to be completed next year. Since our re-establishment, we've grown from 0 employees, and technically EnergyCo is not allowed to employ anyone, so we all are employed by our host department, currently the Treasury, and it has grown to a current staff comprising 195 people, 74 employees, 23 contingent labour team members and 98 contractors. To support our growth and move to a mature business model, we will continue to procure more employees, and we will use judiciously consulting firms, specialist skills and other professional services as required to support this $9 billion program. New South Wales has not seen investment in substantial new grid for 40 years. And at that stage it owned and controlled the fuel and set prices. Since 2020, the full scope of work has become clearer in the context of new industry ownership and regulatory structures, and more importantly, current community expectations. EnergyCo published its first assessment of the costs and timelines to deliver the key network projects in May 2023 in our network infrastructure strategy. Prior to then, the market relied on figures supplied primarily from Transgrid and incorporated in AEMO's integrated system plan. Our network infrastructure strategy dovetails with 2 other statutory documents, the Statement of Objectives from the Consumer Trustee about how the targets in the Act will be met, and AEMO's integrated system plan. Why engage consultants? As we set up these projects, many of them have 6 to 8 year delivery timeframes. To start, the first phase of a project is the development phase. That's typically a 2.5 year phase. It's about getting started, it's about understanding what goes, it's about aligning a whole lot of different resources in the community and having a very wide number of diverse conversations. The delivery phase of major infrastructure projects commences once you've got to the final investment decision and you've got the contract in place and you're managing the contractor through to completion of delivery. Typically you have one group of people who are very skilled at the development phase and another group you phase in over time, and they tend to be your longer term employees over time to do that delivery over that longer term part of the contract. So we're in that phase of just about to transition in some of our projects. Waratah Super Battery is the exception, that's already in delivery, but the other projects are moving through the development phase. Central West Orana is at that point of getting very close to transitioning, and so we have a plan over time to have a long kind of baton change between the initial people we've employed to get the project up and running, to do the development phase, and those who will be accountable for the actual delivery. Our organisation is designed around 4 key functions. Planning and engagement, which is the community engagement and obviously planning processes. Technical, this is the hardcore electrical engineering. Regulatory, these are the very bespoke processes that we have to go through with our 3 independent regulators. And projects, the projects themselves. The core intellectual property we develop is in those first 3 areas, and that's the intellectual property that transcends all the projects. So we tend to have employees in that area and embed them in the projects. As we get settled, as we move into a more mature state, we will populate in greater level right throughout the projects, and so you'll hear that theme from us. Consultants, as you've heard from many people, are there to address specific needs, and in our case, that getting into business and then moving into a stable state. So we've been running for 2.5 years. So, and many of our projects are slightly shorter than that. Key areas where we use consultants: network infrastructure, technical design, procurement and financing, network access scheme design. That's some technical work which we look at from overseas and all sorts of other jurisdictions. Detailed project management and implementation, transaction management and market engagement, and initially and sometimes specifically for particular issues, organisational design, accounting and performance. So sometimes we need external reliance, and figures like an audit needs to be external. We leverage the technical specialist industry insights, international sector practices, and remembering many of these projects have not been done for 40 years. So, and the technology that we're now building them with, the generation technology, has changed dramatically. We look to retain knowledge and build it across through those core design of our organisation with those core functions. I'll just quickly finish the last things. It's important to understand the regulatory structures that we work under. We expect 100% of the direct costs of our projects to be recovered from electricity consumers over time. So in order for that to happen, we have three main processes we go through. The first is we have to go to the consumer trustee, who was set up under the Electricity Infrastructure Investment Act, who's responsible for reviewing what we recommend is the right network to build, with Parliament having set that there shall be 5 renewable energy zones, and the initial size is indicated in the Act. So we come up with options to deliver that. The consumer trustee looks at that from a consumer's point of view and says, is that the right recommendation? And what's the maximum cost consumers can pay for that? After that, we then go to the Australian Energy Regulator to review the actual costs we're proposing to spend on that asset. They have to be less than the amount set by the consumer trustee. So all our costs are subject to that independent regulation. Finally, IPART reviews all the activities that we do under the Infrastructure Investment Act. So we have those 3 independent regulators. And in that process, we also working consistently with Transgrid as the jurisdictional planner and AEMO as the National Electricity Market Operator. So it's really important just to break that down. Just one final point. So for our overheads, clearly some overheads are attributable to those direct costs, so we also attribute those to the projects and seek to recover those over time. And there are some costs, such as my appearance here today, and costs that are just part of being part of government, so they are funded by the taxpayer. They account to about 20% of our costs.
Thank you. Thank you, Mr. Hayden. That was very useful information. There's a lot to get into. I just want to ask you about one contract, and then I will pass to Mr. Latham, who was seeking the call. I just want to ask, and I think this is probably a question for you, Mr. Smith, in relation to the report, the Marsden-Jacob report, in relation to the New South Wales electricity supply and reliability checkup. The e-tender record shows this being published on the 16th of August. It says that it was a limited tender. Can you tell us who else was considered in terms of, who else tendered for this?
It's probably a question for Mr. Lewis, I believe.
Sure.
So there were 3 pre-qualified firms that were approached: Boston Consulting Group, Ernst & Young, Port Jackson Partners, and Marsden-Jacob Associates.
And when we've got, so it says here that 50% of the weighting was on the, of the evaluation criteria was on non-price factors. What was it that pushed Marsden-Jacob sort of over the line?
The primary factor that led to Marsden-Jacob Associates being selected was the price criteria. They were significantly lower than the other 2 quotes that were received from the other 2 firms. More generally, those 3 firms were approached because of their extensive knowledge and experience of the energy market, the electricity market, and the electricity market in New South Wales.
So this is $217,800 for 1 month of work. So it's contract duration, so 5th of June this was entered into to the 5th of August, 2 months of work, my apologies. Is it, when we look at the price, it says here, summary of the criteria against which the various tenders were assessed, and look at the e-tender record, it says that price was only 50% of that. So my question is really what the non-price considerations were that accounted for 50% of the decision to use Marsden-Jacob.
The non-price considerations were primarily knowledge and ability in relation to the electricity markets.
And did you, were you aware that Cameron O'Reilly would be the person writing the report? Was that part of the tender?
that he was the lead partner within, sorry, not partner, associate within Marsden Jacob Associates who responded to the request.
Okay, so when we're talking about knowledge and experience, was there consideration given to the sort of, I guess, the general approach or ideological settings of this particular individual?
Ideological settings?
No.
Okay. Who was the decision made by ultimately as to who to go for?
Ultimately, the decision was made by the Secretary of Treasury under advice, and I was the primary provider of that advice.
Okay. Mr. Hay, did Mr. O'Reilly talk to you about the report at all?
We had one session with them and then one follow-up session, very short, relatively short sessions.
Was any draft report provided to you for your consideration? No. And the session that you did have, how long did that go for? What was that?
I would have to check, but I'm thinking about an hour.
Okay, an hour.
I think there might have been one follow-up session, very relatively short.
What sort of questions were you asked? Were you actually asked questions, or was it a sort of overall discussion?
I think there was a bit of presentation of what we did, not dissimilar to what I've probably just ran through with you. I don't recall a specific line of questioning, but I can go back and...
Were your views sought in relation to the matters that the report finally gave recommendations on?
I saw the final report.
During your discussion with Mr. O'Reilly, were you asked your views on any of the issues that have ended up forming recommendations in this report?
With Mr. O'Reilly, no.
Okay, thank you. I'll go to Mr.
Yeah, thanks, Chair. And to Mr. Lewis, wasn't Cameron O'Reilly in the department working on the electricity roadmap in the first place, which is a pretty important skill set and experience, isn't it?
Yes, that is correct. He was employed in the New South Wales Government in the then Department of Planning, Industry and Environment, I believe from 2018 to 2021, and one of his responsibilities as the Principal Energy Advisor in the department was some of the initial stages of development of the electricity roadmap.
Yeah, so he had that specialised knowledge and experience plus the lowest price, so who else could you pick? That's obviously the decision that was made. Just coming to that electricity roadmap, if I could ask Mr. Hay, how many consultants were used in its development, and how do you now explain from Minister Sharp, the O'Reilly report, other commentary, the failure to deliver on the early promise, particularly the way in which these renewable energy zones are hopelessly over time and over budget?
So, just to be clear, Mr. Latham, you're asking how many consultants were used in the
development of the electricity roadmap. They set up the framework that you now operate, including Energy Co.
So, as you may recall, at that stage I was the Deputy Secretary, so
you were.
I would answer in that capacity, not as the Energy Co Chief Executive. And I'd have to take that on notice. In terms
And
of
was one of the consultants Danny Price?
Not to my recollection, but I would have to check.
And did Danny Price forecast that the roadmap would bring forward the closure of coal-fired power stations, which is now the Eraring problem that we've got?
So there was some work done by Frontier Economics, of which
Yes.
Danny Price is a member.
Yes.
I'd have to look at that.
You take that on notice?
Yes.
Thank you. And if we can just go to Minister Sharp's comments publicly, and obviously what's in the O'Reilly report about the slow development of the renewable energy zones. You mentioned earlier on that Energy Co started with no staff. It somehow was to be responsible for a $9 billion construction program where Minister Sharp's saying the easements aren't sorted, the housing supply for the workers, there are labour supply shortages, skill shortages, public opposition to transmission corridors, the gas peaking at Kurri Kurri and Tallawarra are over time. There's no pumped hydro investment, just some studies out there, and of course the Snowy 2.0 debacle. Looking back, wasn't it just true that projects of this dimension, which is to effectively rebuild the entire electricity grid and rewire the state, it was going to take 20 or 30 years to do it properly rather than 10?
There's projects do take a long time, Mr. Latham, you're right, and we have acted as early as possible to address those issues. So there is a 20-year plan under the Electricity Infrastructure Investment Act to deliver the energy transition, so that is accordance with the timeline that you've indicated. There are some urgent actions, some of which came after the policy was intervened, including the announced intention to retire Eraring early. That was well after the Act was passed.
But it was forecast by consultants.
That was not anticipated in the same
others.
way, and certainly not at that level, no.
And it seems that in terms of the decision to negotiate or engage with Origin about extending the life of Eraring, the main issue is firming capacity, isn't it? That it's a question of how do you back up the intermittent renewables. And on the firming capacity side, the gas peaking plants are over time and there's no pumped hydro investment. So what are you relying on? Some batteries?
So in relation to that's about the engagement that's been referred to with Origin out of the O'Reilly report. I'll pass that to Mr. Lewis because he's now leading that.
Sorry, Mr. Latham, could
the
you
firming
please repeat
capacity
the
is
first
the main
point?
problem, isn't it? There's enough investment in the pipeline for actual renewables, wind and solar farms, but when the sun's not shining, the wind's not blowing, what keeps the lights on? Isn't that the fundamental problem that we've got?
That's one of the issues that we are looking at and working through with the Australian Energy Market Operator AEMO's recent electricity statement of opportunities. AEMO has indicated that if all the projects that are currently known and in progress are completed on time and at their capacity, AEMO is not forecasting any reliability or security risk for New South Wales. However, there is the risk element of if they're not on time or at capacity. And that is what we are looking at as part of the engagement that will occur with Origin Energy. We will be looking at what are the true level of risks, what is the likelihood that some of those projects may not proceed according to the time frame that they've currently been taken into account by AEMO, and looking at that level of risk and determining to what extent Eraring may or may not need to be kept in the market.
Right. What are the consultants saying about the likelihood of pumped hydro in New South Wales?
Sorry, which consultants?
Well, any of the consultants or expertise you're using, contractors, anyone, about the likelihood of pumped hydro, because the O'Reilly report has submitted that there's feasibility studies and inquiries being made, but actually no investment in new pumped hydro, and we know that original consultant report said that they were relying on Snowy 2.0 to be finished in 2025, which of course is now a pipe dream. So what are the consultants saying about the likelihood of pumped hydro being developed as firming capacity?
So pumped hydro is still identified as a feasible firming technology in New South Wales. There is not only the Snowy Hydro 2.0 project, there are a number of other projects that we're aware of. Mr Hay, maybe
which ones have been approved for development?
The pumped hydro program sits partly with you at the moment.
So I might add to that, we have run a program for feasibility studies for pumped hydro. There were 6 projects in that who were successful bidders for that funding. One has chosen to discontinue, although it is seeking to extend its grant, so they may still wish to continue. The other projects are still continuing with their feasibility studies. So to our knowledge, they still think those projects are viable. They are pushing.
Well, are the feasibility studies finished, or they're continuing?
No,
well, how do you know they're viable if the study's not finished?
The feasibility studies are on track. They're meeting their milestones. They have not finished the studies.
Right. So after 2.5 years, though, you haven't got anything.
The grants program to issue the grants takes time, Mr. Latham, as you know, and we have to follow process. So I will come back to you with the dates on which the grants are issued. But I just don't have that on. I might be able to get that whilst we're in the meeting.
Thank you.
Could I ask, just coming back, Mr. Lewis, in relation to this contract and the way in which it was, the tender was run, you said before the other 2 firms were Boston and EY Port Jackson, is that right, that were invited?
Yes.
Those 2 firms, neither of them are part of the standard commercial framework. So you would expect them to come in as a more expensive tender than for Marsden Jacob. Isn't that correct?
They are not. They have not agreed to the standard government terms and conditions and fees. However, under the procurement framework, they are allowed to be approached or invited to tender, and there are separate approval processes if they are considered to be an effective or a suitable consultant to be used.
Sure, but Marsden Jacob is part of the SCF.
Yes.
And we know from our inquiry so far that the companies, the firms that are part of the SCF will put in, cheaper tenders by, matter of course. Did you deliberately select 3 companies or 3 firms, knowing that 2 of them were going to come in with a more expensive tender?
No.
Was it the decision, or was there any instruction to you, or did you, off your own bat, decide to prefer Marsden Jacob as the firm for this work before the tenders came in?
No.
Given that Mr. O'Reilly is on record as being very much in favour of privatisation of the national energy market, he wrote an entire opinion piece in the Mandarin arguing for market privatisation in 2015. He did his master's in privatisation of the energy market. Given the change in government, do you think that that was the appropriate choice for writing a report of this kind?
So Marsden Jacob Associates was approached as one of the 3 companies that we approached because of their significant experience and expertise in relation to energy market issues. It was not known that Mr. O'Reilly would be the Marsden Jacob and Associates associate that would be leading the response to the tender.
I thought in your evidence just before you said that one of the reasons that they were selected was because Mr. O'Reilly was...
No, my evidence was that Marsden Jacobs was approached because of the firm's experience, of which Mr. O'Reilly is one of a number of associates that have experience in the energy and electricity markets.
So the tender that Marsden Jacob then gave to the department or put in didn't say who was going to be working on the project?
It did. The tender came back with Mr. O'Reilly as the lead, who wrote the response on behalf of the firm.
Yeah. So if you were to and presumably it said that he would be the one who was going to be working on the report if you were to hire.
So there were three identified associates of Marsden Jacobs: Mr. O'Reilly, Ms. Veronica Neves, and Mr. Rod Carr.
Yeah, and was Mr. O'Reilly identified as being the lead partner or the lead associate on that? Right.
He was.
Okay. So you were faced with a tender, with a bid that came in that was obviously going to be lower than the others, and that had Mr. O'Reilly in the driving seat. So my question again is, was it thought appropriate in these circumstances where we have a change of government, where this particular government has been talking for some time about the regrets that it has over privatisation and has sort of rallied or railed against the privatisation of our energy assets in the past? Why was it thought appropriate to appoint a firm to write this report led by someone who is on record as being so fervently in favour of a privatised energy market?
I would answer that by saying privatisation was not part of the terms of reference for the engagement and is not a relevant factor for consideration.
You don't think that it influences at all the recommendations in this report?
Mr. O'Reilly has extensive experience in the energy sector in a number of different roles, including working for the New South Wales Government and having been one of the officials who set in place the roadmap process. So he and the firm that he currently works for were deemed to be suitable from an experience and a knowledge perspective, and that was one of the main factors in approaching and seeking their quote in response to this piece of work that we were asked to do.
Which then makes sense that this report really does continue the ideology of the previous government, doesn't it?
I can't comment on your opinion.
And the government before that had a premier and a treasurer who pursued electricity privatisation to their political cost. So it's not unusual inside the Labor Party to have those advocates.
Mr. Hay.
Can I just ask one question following up on that?
Sorry.
Was the Treasurer or the Minister for Energy consulted on the appointment of Mr. O'Reilly before that was confirmed?
They were
Or O'Connor Marsden, I should say.
They were advised in being kept up to date, but they did not have a decision-making role.
Did they express a preference at any point?
No, not that I can recall.
Can I ask you, Mr. Hay, I asked you before about what your level of involvement in this report was. On page 18 of the report, it says that this report was based on existing information, resources, and known developments and structures, including targeted interviews with New South Wales government agencies. Do you believe that Energy Co had a targeted interview with Marsden Jacob?
We certainly provided a lot of information, as it says, it relied on existing information. And we provided very specific comments to Mr. O'Reilly about what was needed moving forward. So that was the targeting that we chose and we expected from that report.
Have you got any objection to his chief recommendation about engaging with Origin to keep Eraring open, in that your first renewable energy zone, Arana, won't be starting up until 2027? What is the alternative to keeping Eraring going to keep the lights on in New South Wales?
Nuclear.
So as the Energy Co Chief Executive, that's not part of, and as in my engagement, if it's out of the question, that was not one of the questions that I was in.
No, but I'm asking you now, in light of the O'Reilly report, what's the alternative to keeping Eraring open while we all sort of pedal?
Those are questions for government policy, not for me, Mr.
Well, there
Latham.
must be questions for you. You run the Energy Co, which is supposed to keep the lights on in New South Wales. You can't duck the question. What's the alternative to keeping Eraring open?
Mr.
You've got
Latham,
no pumped hydro. You haven't started Arana until 2027, 2 years after the slated closure for Eraring. The gas peaking plants are over time. Snowy 2.0 won't be happening anytime soon, maybe 2030. What's the alternative here?
Mr. Latham, the Energy Co is responsible for delivering the renewable energy zones and the priority transmission projects.
You don't take any responsibility for keeping the lights on. That's reassuring.
We
You
are
paid a lot
a
of money
key
to do that,
participant in helping keep the lights on, but that isn't
Helping.
our project. Our role is to be very focused on delivering the projects that contribute to that outcome.
Okay, well, you haven't been able to identify an alternative to Eraring continuing. There is none, is there? Well, it's trying to turn the Queen Mary around on a 5-cent piece. You just can't do it.
My job is to deliver the renewable energy projects and priority transmission
When does
projects.
the first of those start up?
Sorry?
When does the first of those renewable energy zones start up? When will it actually be operational?
27, 28.
27, 28. Okay, thank you.
When will they be connected to the grid?
So, Mr. Latham, as Mr. Hay mentioned before, under the roadmap, the target is 12 gigawatts of new renewable capacity and 2 gigawatts of firming. There is already, I think we're already a third of the way towards that 12 gigawatt target. Since the roadmap was implemented, there has been, I think, over 4,000 megawatts of new renewable generation that has been built in New South Wales. Also, the process that is being undertaken in terms of the firming tenders, the first round of those has been completed. A second, I believe, is currently underway, and that is bringing forward projects as well too. So to answer part of your question,
Which projects are being brought forward?
I can't recall off the top of my head, but it is publicly available and listed from AEMO services. So there are a range of new generation projects and new storage and firming projects that are being built as part of the replacement for the existing coal fleet in New South Wales.
Okay, can you take on notice those that are being built and give us their projected completion dates?
Yes.
Thank you.
In relation to those renewable energy zones, when will they be connected to the grid? I guess not only the grid, but be able to supply metropolitan areas?
So Central West Arana's the first of the renewable energy zones. It will be connected to the grid in 27, 28. We are working, as our role under Section 63 of the Act is to coordinate, as I mentioned before, the investment in not just the network, but the generation that comes on stream with that. So we are working closely with the generators who are developing projects in that area. They then have to go through a separate process to be awarded access, and if they need them, long-term energy service agreements from the consumer trustee. The whole objective is to bring them on at the same time, so that we get the original policy objective, and it goes to your point, Mr. Latham, about bringing these projects in time, is about the practical coordination of generation, transmission, storage and firming.
Sure.
So is it EnergyCo's role to plan the construction of the transmission aspects of the renewable energy zones to the main metropolitan area grids, or is it effectively just the construction body? Who?
What if you see in our network infrastructure strategy, what
Yes.
you'll see is that the first stage of Central West Orana is timed and sized to use existing capacity in the existing network so that it can get to the load centres.
I'm not really interested, and you might sort of guess where I'm going with a lot of this. Is and look, to save time, I'll come straight out. There's obviously two ways that we can look at these proposals. You can have overhead and underground. Now, we've just had an inquiry that's been, looking at those issues and aspects. In relation to consultants that are engaged to look at these works, where does EnergyCo sit in relation to looking at the transmission projects, looking at the different roles with which you can transmit power, either overhead or underground, and how much investment has gone into looking at both of those solutions?
Of the comparing underground to overground?
Yes.
So we do, that is part of our core role, and we've looked at those in some detail to see underground. Undergrounding is very difficult of large-scale, high-voltage transmission.
Mm-hmm.
The cables, the diameter of the cables, roughly 30 centimetres for underground because they have to be protected and armoured.
Yep.
The cable for overhead, much, much smaller.
Yep.
That then means that whenever you come to a dip in the terrain, you have to build a bridge because the cable can't follow the terrain.
Right.
Moreover, the cables need to be roughly 2 metres deep and 2 metres apart from each other.
Yep.
And they carry less transmission. Their carrying capacity of transmission, even though they're much bigger, they conduct less electricity.
Are you talking AC or DC now?
This will be AC at this stage. So
Okay.
DC.
Was it five times more expensive?
It would be at least that.
So
At least
what
that.
if-
And your policy is 100% cost recovery from consumers. So this policy is an increase in electricity prices.
As is the national electricity market.
Except,
all,
what if
all
That's
transmission projects that are shared network are recovered from electricity
Recovered from
consumers.
consumers. So you want to put them underground, people have got to
You
pay
put
for
them
it.
underground, you have
People who are
Except-
300 kilometres from the transmission corridor. Everyone's got to pay.
you
Can I ask, sorry, since we're talking about questions, not statements,
That was a question. Everyone's got to pay.
well, sounds like more of a statement,
right,
but
order.
anyway, I digress. In relation
How are you going to get out
to
of this?
AC,
I'm very interested
Transmission.
in this. I still don't know what it has to do with our terms of reference.
well, I'm just wondering
But just-
I'm just wondering, given that we're talking about consultants, have we actually engaged?
I've just been through the same inquiry as you with. So, I mean, I'm
Well, you should be really interested, Mr.
I'm
Primrose.
fascinated.
Good.
But
Well,
I
we've
don't know
got
what
the
it's to do with our
experts here.
terms of
We're two
reference.
birds with one stone.
I'll leave that to the chair to decide.
I've been waiting for a point of order to be taken.
No, I won't
but-
take a point of
No,
order.
no. He's as interested as I am.
I'm interested.
He's
I
interested.
just don't know what it's to do with the terms of reference.
All right.
Obviously, that we're talking about AC undergrounding. What about DC undergrounding, which has been obviously shown to be more efficient, more easier to install, perhaps more cost effective than AC undergrounding, and effective, I guess, for long distances, which is what we'd be talking about between the renewable energy zones and the metropolitan grids.
Yeah. So
Have we spent
I've
any
had
money
quite
at all looking at
significant
that?
experience in my career coming from New Zealand and dealing with HVDC, because there is an HVDC line that runs from the centre of the South Island to Wellington.
Yep.
Including going under the water.
Yep.
HVDC is particularly characterised by the fact you can't connect into it. It's a point-to-point connection. So
Correct.
for a renewable energy zone, it is not the appropriate technology because
Yep.
the renewable energy zone is there to connect generators. We will have multiple points of connection. So it's not an option for that. It may well be for very long connections.
Yep.
If you were to develop major solar inland. But again, the point is undergrounding creates serious issues because finding the fault is very, very difficult.
Well, that's, I guess,
Chair,
we
point
heard
of
evidence
order.
was outside
Oh, thank
of that.
you. I'll hear the
However,
point of order.
Point of order, Chair, my colleague might not be, might want to continue with this, but I really think we should return to the terms of reference, given that
Well,
we have limited time, and I suspect that there are other members who have questions to ask which do actually
Well, I was
relate
leading-
to the terms.
Thank you.
I was leading to that, and I've got one more question if that's okay.
I will allow you to ask one more question, then I will go to other members. If there's more time at the end, you can ask these less relevant
I
questions.
very much appreciate
Go ahead.
that, Chair. Thank you. In relation then to HVDC underground, have we done the work? Have we got consultants perhaps who are able to price that work in? Because I know communities don't particularly want these overhead lines to become pseudo-reses and being able to tap in along the way with further renewable energy projects. I think a point-to-point connection with DC is actually a much more equitable solution given that it's going from res to zone. Have we not got consultants that can perhaps provide an answer on this?
One of the
Tangentially within the terms of reference, I would say.
Appreciate that, Wes.
I tried.
As the committee will appreciate, there are consultants who provide answer to any question you ask.
Oh, I know. They might even provide the answer you
Nice.
want. But I guess in relation to this, are we doing the work, to support a model the community wants as opposed to the overheads, which might benefit metropolitan
We've done
areas
a
but
lot of
aren't
work on
benefiting
the
those in the rural
feasibility
regional
of
areas?
options. Particularly, I re-emphasise the initial stages of the renewable energy zones are utilising the existing transmission network.
Mm-hmm. Happy for
To
that.
the extent that we are supplementing that with the Hunter Transmission Project, it goes through terrain that would make undergrounding unfeasible. As I said to you, these cables do not bend, they do not follow the terrain.
The AC ones do, but the
Okay.
DC ones are much smaller.
Order.
DC
I will
would be very
now.
difficult.
I will now allow Mr. Farlow to ask some questions.
Okay.
Thank you very much. Mr. Lewis, I might just return to the engagement of Marsden Jacobs, and I apologise for saying Connor Marsden previously. I say another firm I'd had, I think, local government engagement with and was in my mind. In terms of, you outlined with Marsden Jacobs that it was, of course, Mr. O'Reilly who was put up as the lead associate on that engagement. You referenced, and one of the things we've heard throughout this inquiry has been the relationship when it comes to consulting of people who've worked within government and then taken that experience outside of government and been able to secure work from government in that environment. And of course, Mr. O'Reilly worked with the government from, I believe, 2018 to 2020. When it came to the Boston Consulting bid and the EY Port Jackson Partners bid, did they have people who were put forward as the team who had relevant government experience and had worked inside New South Wales government as well?
Yes.
Yes, they did? Okay. Thank you very much.
Chair,
Go ahead.
thank you. Just trying to get a handle on this, the remit, I suppose. You're a coordinating agency and established to carry out the planning and coordination of the renewable energy zones. And there's consultancy presumably on how to tender for the generation and where it'll go and all that sort of thing. Is that the expertise that we're getting in?
So we have the role of coordinating the investment in renewable energy zones and the priority projects. We also take those projects, the network part of those projects, to market. So we do a lot of work to get the concept designs of the network solutions. We have to recommend that concept design to the consumer trustee for approval. And that's when they set the maximum sum. So we have to do a lot of technical work. So we do require very specialist technical advisory services to help with those designs, as would anyone else doing it, Transgrid or anyone else, AEMO. So we do that work. That's a large portion of our work. We also do a lot of work on the environment. We are the planning authority, so we're seeking the planning permissions for these projects. So that means we run the EIS processes. So we have all the scientific advisors and the environmental advisors to work on that, the biodiversity offset advisors. So there's another big tranche of consultancy in that space.
So what are we talking about here in terms of the source energy? Is it solar charging up batteries largely? Is it wind charging up batteries?
In Central West Orana, we would say that the majority will be wind.
Yep.
But there's increasing, what we're seeing now is an increasing amount of projects wanting to do batteries on site as well, but also batteries have this ability to be put wherever they're needed. A lot of the projects are looking at what we call battery electric storage systems, so they are looking at combining that with, this is part of the firming that Mr. Latham was referring to, so we see that they can make better use of the network connection that they've got and the quality of the network they're connected to. So we're seeing that incentive to optimise that and deliver that firming faster and through market processes.
And what did we say the spend was on consultants to advise on this? So how many employees are we talking about directly government employed, by the way, in Energy Co?
So I'll just make sure I get the numbers.
195, was it?
We've got a 195. It's made up of employees,
Contingent.
contingent labour, and contractors, not consultants.
Yep.
So I think the number, just referring to my notes, if you don't mind.
We had 98 contractors and 20-something contingent.
74 employees, was it? I think.
Yeah.
That's as at today, if you like.
Just strikes me that there would be a lot of resident expertise in some of these utilities, essential energy, for example. I mean, Transgrid's been sold off now, but you've got a lot of engineering capacity there. Was there any opportunities explored in that cross-fertilisation from those pre-existing engineering
Transgrid wears a number of hats in this capacity.
Yeah,
so
I appreciate.
It's the jurisdictional planner.
Yep.
And we're the infrastructure planner, and AEMO is the national planner. So we work very, very close. We have days when we have planning conversations with those parties, and some of our costs incur reimbursing Transgrid particularly for some of those costs. So then Transgrid also is an asset owner, and it wants to bid to build these projects, whether it does contestably or they're awarded directly to it. So we have to separate those conversations.
Yes. So on that point, who will actually, in terms of asset ownership, so the transmission lines, which, as we've heard, are likely to be overhead, that they will be owned by who at the end of the day once the connectivity happens?
Each project we look at one of our recommendations to the consumer trustee is who would be the right network operator for that particular investment. So we recommend two things. What's the right project to meet the target? In the case of Central West Orana, the capacity expressed in the Act in New England. So what's the right project to do that, and how would you phase it over time? And the second one is who's the right person to build, own, operate and finance that? Because we don't build, own, operate or finance anything.
No. So Transgrid might put in a bid for the transmission lines, which means they'd own the asset and charge for the...
Yes.
Yeah, the
and
wheel.
so their costs will be recovered.
Or it could be someone else.
Yeah.
Yeah.
It could be
and what about the generation assets?
The generation assets are pursued by generation developers. They are private parties. Some of them are the parties the Origins and the AGLs, but there are other developers as well who are Tilt and other parties. There's a raft of them. In Central West Orana, there are 12 candidate foundation generators that we call them. So they cover the broad spectrum of investors and developers.
Okay.
Can I ask you, just looking at the 22 financial year accounts as they appear within the Treasury accounts, it's showing Energy Co as having around, I think, about a $408,000 consultancy expenditure. Does that sound right to you?
These are the ones that were for the financial year ended 30 June 2022. We were part of the Treasury for a period from April through to June.
Right. Are you able to tell us what those figures will look like approximately for unaudited for 2023?
Yeah, very much unaudited at the moment. 2023, the figures you were asking are for contractors and consultants, is it?
If you could, separately, if you could let us know consultants and then contractors And also contingent labour would be useful.
So projected total expenditure on consultants for 2022-23, and I'll give a breakdown between what's going to be capitalised into the projects and what is
Thank you.
OPEX as well, is 46,517,000. That's for consultants. For contractors will be 27,872,000. And these are very unaudited numbers at this point.
Understood.
Contingent workers, 4,159,000. So we separate out, for the reasons we've been talking about, fees and amounts we pay to market bodies, because we're required under the Act to consult with them, so we don't include in that those numbers.
Okay. In terms of what gets capitalised, what's the...
So, and now as with all accounting questions, there's first layer and the second layer. So the direct costs of those that we've incurred are in the same order. So consultants, 43,965,000. Contractors, 16,011,000. Contingent workers, 964,000.
Okay, so that's the amounts that represent sort of your operating functional costs.
No, those are
versus-
were the capital.
Oh, they're the capitalised
those
amounts.
Are the capex numbers. So, of our OPEX numbers, I can give you those as well.
Thank you. Yep.
Consultants, 2,552,000. Contractors, 11,861,000. Contingent workers, 3,194,000. Of those numbers, we would expect, even though they're categorised as OPEX, some of those costs, a good proportion, maybe more than 50%, are also attributable, because they're overhead attributable to the direct capital costs. So they will be, they are legitimately part of the project cost.
So that, sort of under the operating expenditure, the 3 million on contingent workers, can you give us a flavour of what kind of contingent workers they would be?
Of the operating cost?
Yeah.
So these are people we have needed to bring in at short notice whilst we look at longer term recruitments typically. Or they might be very highly specialist people who are working for us as part of our team for a period of time. To give you an example, a regulatory specialist, whilst we're doing an application, what we call an authorisation application to the consumer trustee, we might want someone who's worked at the AEMC and worked in one of the big law firms who's just done this day in, day out to really get to this is incredibly detailed work, and you need people who know how it's worked in the national electricity market to know how it should work under the regulatory environment that we're working in. So that's the kind of person we might use. Equally, there might be some very specialist planning resources to help with preparation of any EIS, that help manage the external advisors, the scientists who are doing the environmental surveys. So in order to meet the spring survey timeline, we might just need to get someone on very, very quickly, over time. And depending on the nature of where we're working on this environmental survey, you'll want someone who, you're so much further ahead if you've got someone who's actually done the surveys in that area before and knows what flora and fauna you're dealing with. So that's where sometimes you just need that specialist and you need to see what you can get.
What's the difference then between a contingent worker and a contractor? Like I would have expected environmental surveyors.
So contractors
and stuff
are also brought in from professional services to help with some of those skills.
Yeah.
So a lot of it depends on which organisation they're coming from or how they can go. So where we bring contractors in to be part of our teams, we run procurement processes in accordance with the work my colleague Mr. Smith helps us with. Contingent labour has its own processes. I could talk to you about that, but many people have. So we look to see who's available and what's the right way to get them on.
So what's your workforce look like then in terms of direct employees assigned to Energy Co versus contractors and
I gave you those
contingent
breakdowns
workers?
before, so 74 employees.
Sorry, say that again.
74.
Yes. employees.
Yes.
And
23 contingent labour.
Yeah.
The balance is 98 contractors.
98 contractors.
The contractor number will change day to day because we're bringing people in, we're moving them on. What I really emphasise again is the phasing of projects. So we, especially through the development phase, you do lots of specific work on stuff that you won't come back to in the project. So you want people in for that phase to be the expert. There's a lot of handovers, and what we are doing now is looking to the procurement phase. So the delivery of Central West Orana is scheduled to start from June next year, once we get through financial close, finalise all those regulatory processes I was talking to you about, and at that stage and well before then we'll be starting ramping up the delivery people who will be there for the duration of the delivery through to 27, 28, and in fact the defects liability thereafter.
What happens when all the reses are complete and we've got Nirvana and everything's connected? What happens to EnergyCo then?
We have a number of things. So the access rights that we administer run for 35 years or 33 years from project completion. So we're the administrator of the access rights. So at one level that's about a registry of who holds them and where they go, and that as part of the administrator of the access scheme, one of our jobs is to continually evaluate the performance of the network. So can we let more people connect? The basic premise of an access right is a promise to the generators that within the renewable energy zone we won't connect more generators beyond a certain level, because what happens in the national electricity market is new generators can come and connect and write off the value of the existing. Depending electrically, they can sort of get into a place that affects the generators who are already on the grid. So the access right is a way of helping generators be confident over the life of their investment that they will be able to export the energy that their generators are producing. So that's a 35-year scheme. The access and the generators pay an access fee over that period, and includes contributions to community and employment benefits. So we administer those grant schemes as well, which we're looking at. So there's quite a bit there, Mr. Buttigieg, but
your contractor spend will wind down as these projects come to fruition, obviously, and
yes,
then, you just have a permanent residual date.
That's right.
Yeah.
That's right. And so we're working designing some of those community. One of the ideas of the community benefit scheme and the employment benefits is to deliver those benefits at the time the projects are happening, not 10 years down the track, and to work very closely with the communities and First Nations communities, and to really sort of look at what's actually needed. All the projects will give out high-vis jackets and sponsor new barbecues and do all that sort of stuff that projects do, but this is much more about maintaining and enhancing services in the area, looking at what the communities actually want to achieve long term out of the benefits of these projects.
Can I ask, do you use any external parties to run community consultation?
We do, and so we have many types of community consultation. Some of our community consultation is quite specialist on environmental issues, some of it's quite specialist on land issues. So we do bring parties in, and we also want to, and increasingly looking to recruit locally, but often that means we need to employ through contractors as opposed to employees, at least initially, to get up. And we have a surge with community engagement, and when we launch a project, there's a surge. We are employing as employees, liaison officers for First Nations. We are employing regional representatives as employees, so who are based in the communities, and our local presence, you'll see that grow quite substantially. But sometimes just to get in there, and we advertised for some of these roles immediately pre-COVID. One of the features of EnergyCo is we were at our very early stages, we were absolutely gazumped by COVID, and our community engagement really was affected by that clearly. We advertised and we didn't get much response to the job, so now we're going back with the deeper relationships we've built with the communities to really drive those in and diversify them, and have our presence in a long-term sustainable employment way, particularly around these community benefits which are there for the life of the projects.
Mr. Feng?
Oh, I just wanted to ask briefly, no chance that you'll be getting some consultants in to do some work on nuclear, any chance?
No, nuclear projects aren't.
Wales, you voted to keep the ban.
Did I? No, well, I think I spoke pretty passionately about removing the ban.
Order. Can
Anyway,
we let the
just
witness
a
answer
suggestion, just a
the
question. Just a question.
Was it a performative question, or do you want to answer?
Oh, well, no, I like, given all the problems we've got around transmission and renewable energy zones and the like, shouldn't we just put like small modular reactors everywhere where the...
I'll let my colleague jump in a moment, but
I'm sure he's dying to.
No proven small modular nuclear technology anywhere in the world, and if it was to come, it would be for the next generation.
Oh, well, I think there was...
order.
Okay, sorry.
The only thing I would add is that you would still need to build the transmission to connect up from the locations to the load centres.
Oh, not really. I mean, depending where you put them, and you can have them closer to the metropolitan centres, and then
Are there any other questions?
That's not a community engagement I'd like to lead.
Can I just ask,
I'll have one in my backyard.
if you could indulge me a little bit, Chair, it's a bit off, terms of reference.
Well, what stopped us today?
Like, in terms of one of the things that's always sort of been proffered to me by engineering people who are in this game is the issue of how to operate under a fault condition with batteries and wind and solar. Has that technical issue been overcome? In other words, when you get a fault on the cable, it's hard to generate the necessary impedance to trip like you would on a traditional sort of AC coal. So is that still an issue?
At a very specific level on the impedance and those things, I'd have to get you a more technical answer. But at a more general level, we're working very closely with Transgrid and AEMO around what we call system strength, which I referred to earlier, and how a lot of what we've had to do too in designing the renewable energy zone has been about how we meet those reliability standards. So the resilience, the number of circuits, the way we've put them, and how that's where you're right, it's a very big issue, and that's where a lot of our focus has been.
And are the AER ultimately telling you how much you can spend on these networks, or...?
The AER's role under the roadmap is, yes, to approve the actual proposed expenditure. So with Central West Orana...
You did say this, yeah.
With Central West Orana, we've run a contestable process. We've had 3 bidders sort of shortlisted. They've put their bids. We've gone down to... We're now first ranked. AER has sat in on all of those evaluation sessions and all of those meetings. So when we go to them, they will know the costs that we've delivered are market-sourced costs.
Thanks.
Unfortunately, that's all we have time for. Thank you very much for your attendance and answering our questions. To the extent there are questions taken on notice or there are supplementary questions, there'll be 21 days to respond, and the Committee Secretariat will be in touch. But that does bring us to the end of today's hearing. It has been a fascinating day of peaks and troughs, shall we say, ups and downs. Yes. But that does conclude us for today.
Thank you very much. Thank you all.
Thank you.
Thank you. Thanks.
That was great.